officer, sir. Court officer, sir. Court officer. ಇಲ್ಲ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಇದೇ ಮಾಡಲಿಲ್ಲ ಮ್ಯೂಟ್ ಓಪನ್ ಮಾಡಲಿ ಆಗಲೇ ಓಪನ್ ಮಾಡಿದ್ರೆ ಏನಾಯ್ತು ಗೊತ್ತಾಗಲಿಲ್ಲ.
Number 14. Quota number 14. Adjudication were adjourned. Tomorrow,
madam. Please hand over all quota number 14 matter. Tomorrow, I think the entire board is full up to 27th.
Yes, it could be taken up on 27th.
My lords, on Tuesday, my lords, quota number 14.
Hand over all the memos of quota number 14. Let the court officer give dates.
27th.
Sir, Tuesday.
27th.
Court, you please wait. All quota 14 matters memos, you please hand over.
Quota 14, one submission. In this matter, my lord, relaxing video conferencing guidelines, and we moved memos several times, my lord. The issue being that before the trial court, the matter is last chance on the 28th. The guidelines are not relaxed by then, we will not be able to read our evidence, my lord. The matter will be closed, the evidence stage will be closed, and we will for arguments.
Where is the person residing?
Dubai. So travel ban has been imposed upon him, and he can appear through VC. But
when is the case listed before the trial court? 28th, 27th, madam.
I have also annexed the e-court's order.
27th.
One matter was dismissed for non-prosecution. Recall of petition. Date was given last time, 21. Matter did not come up.
Check more days. Any other total 14 matters?
number 14.
My lordship, the respondent police are trying to arrest the petitioner here.
Total 14 matters. Yes. Hand over the
So it may be taken
hand
up
over the
today in
memo.
It may be taken up today in the afternoon, my lord.
No.
The urgency is much. There is much urgency in this since the petitioners are bedridden, my lord.
Yeah. What is challenged?
The FR 482. So criminal petition. So an alleged FIR has been filed against this petitioners, my lord.
Alleged FIR andre?
So it has been filed under 406 and 420 and read with 34 of IPC.
When was the FIR registered?
It was registered on 3rd of October 2025. And
3rd October
the
25,
respondent
you
police
say
are-
it's urgency. Let it come. Yes.
Charge finally by 12th May.
Huh?
12th May. Finally, the charge finally at 12th May. For that.
One date kodi.
Lordship, 27th.
Total 14 ah?
14.
Kodi.
Lordship.
You please hand over all memos.
Case of acid attack. Case of acid attack.
Acid attack anta nodi madam. 20. Acid attack ad yado nodi togoli. 27th or 28th kodi.
My Lordship, one submission, my Lordship.
Which court? When was that phrased? Last month. So it will come on 28th or 29th. So already you give it, Mr. 28th or 29th it will
Lordship,
come.
one submission, my Lordship.
See the board, I believe the court has listed 300 matters every day on 20 up to 27th. Please be human to the judge also. Be considerate to the judge also, mister. 300 cases he has listed. And how many more cases do you want a judge to deal with? Be considerate. Please hand over the memos. The court officer will decide. Huh? In bail, 482. You not sought for bail. Then let it come. 482 bail entertain madadilla. It is the most.
My Lordship.
Most. Mr. Grounds of arrest, the Supreme Court has clarified in what cases grounds of arrest has to be issued. All right, you hand over the memo, it will come.
One submission, my Lordship.
Total number 14.
Under section
Today-
85 BNS, your Lordship. Under section 85 of BNS.
14 matter, total 14.
House. Total.
Yeah, Kodi memo kodappa.
ನಾಳೆ ಇದೆ ಸರ್. ಏನಕ್ಕೆ
ಆಯ್ತು 27th ವರೆಗೂ ಹೌಸ್ ಫುಲ್.
ಉಲ್ಲಾಸ್ ಮೇಲೆ FIR ಆಗಿದೆ.
ಹಾ?
ಉಲ್ಲಾಸ್ ಮೇಲೆ FIR ಆಗಿದೆ.
ಯಾರ ಮೇಲೆ?
85 of BNS ಸ್ವಾಮಿ ಡೌರಿ ಹರಾಸ್ಮೆಂಟ್.
arrangement case in-laws ಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ಏನು
Quotal number 14, my lord. It is today, it is listed after lapse of 7 months, my lord. First time it is coming before your lord. Lordship kindly have it on tomorrow at least.
No.
7 months ಆಗಿದೆ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು. With great difficulty.
ಇದೆಲ್ಲ 25th ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ನೋಡಿ.
All the today's matters, my lord.
All the today's.
All today's matter is ordered to be listed on 25th.
Lords kindly, Lord.
Yes, please.
Quotal number 14 matter. My lord, the dispute, my lord, between husband and wife settled. Payment is also made. Mediation, my lord, both the parties have signed. Even then, my lord, in a pending matter, they obtained, my lord, the NBW, and with the police help, my lord, they assaulted me. My lord, all my belongings, my lord, including, my lord, the mobile phones were taken out.
Settle ಆಗಿದೆಯಾ? I told, settle told.
Please, there are two matters.
Yes, 230 told, yes. Adjournments.
List number 1, adjournments, page number 6, serial number 26, page number 7, serial number 27 to 33, page number 8, serial number 34 to 41, page number 9, serial number 42 to 46, page number 10, serial number 47 to 49, page number 11, serial number 50, page number 12, serial
My
number
lord, serial
51 to
50, serial 50, my lord. Serial 50, I am for the appellant. I seek accommodation, my lord.
Learned counsel for the appellant seeks time list on list after
After the
summer
case, my
vacation.
lord, after the case edit.
page number 12, serial number 51 to 54, page number 13, serial number 54.
Yes.
List
Correct.
number 1 for order, serial number 1, Srinivas V.
Srinivas
This matter,
Respondent.
reporting settlement. ಏನಾಯ್ತು? ಆಗಿಲ್ವಾ?
Yes.
Please use the mic, Srinivas.
My lord, he says that she is not in station, my lord.
My lord, Monday will keep 40% on Monday.
ನಾವು ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, ಅವ್ರ ಮನೇಲಿ ಏನೋ ಸಾವಾಗಿದೆ ಅಂತೆ.
My lord, I am traveling out of the country, my lord.
ಯಾವತ್ತು?
Today night, my lord. Today night I have a flight
Then after vacation.
after vacation. Much
List after vacation.
obliged. Serial number
Learned
2,
counsel for the petitioner seeks time list after vacation.
serial number 2, HV Devaraju.
That I appear for the appellant. In terms of the entry model, the depositing the amount.
ಶ್ರೀನಿವಾಸ್ ಇವತ್ತು ಹೊರಟಿದ್ರಿ, ನಾಳೆ ಕೋರ್ಟಲ್ಲಿ ಕಾಣಿಸ್ಕೋಬೇಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, ತಾವು ಕೇಳಿದ್ರೆ ಫ್ಲೈಟ್ ಟಿಕೆಟ್ ತಂದಿದ್ದೀನಿ.
ಅಲ್ಲ ಹೇಳಿದ್ದು ಇವತ್ತು ಹೊರಟಿದಿರಿ, ನಾಳೆ ಕಾಣಿಸ್ಕೋಬೇಡಿ ಕೋರ್ಟಲ್ಲಿ ಅಂತ.
ಇಲ್ಲ, ಆತರ ಸುಳ್ಳು ಹೇಳೋ, ಕೋರ್ಟ್ಗೆ ಸುಳ್ಳು ಹೇಳೋ ಅಂತ ವ್ಯಕ್ತಿ ನಾನು.
ಎಸ್, ನೆಕ್ಸ್ಟ್.
ನಿಜ ಹೇಳ್ತೀರ.
That in terms of the entry model, depositing the amount, that there is a delay. And I have also filed application for extension that has not been put up, that.
What extension?
That in terms of the entry model depositing the amount for the extension of time, the before filing application, the 15th I have filed a memo with the demand draft.
No, you are supposed to deposit some 50%.
Yes, that I have.
ಮಾಡಿದಿರಾ?
Late in the delay in depositing.
ಬರ್ಕೊಳ್ಳಿ, ಎಲ್ಲಿದೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದೀನಿ, DD number ಇದೆ.
Where is the application?
The application has not put up. Application filed on 21/4.
ಬರ್ಕೊಳ್ಳಿ, ತರಿಸ್ಕೊಳ್ರಿ ಅಪ್ಲಿಕೇಶನ್. IA 1 of
2026.
26 is filed by the appellant for extending the time for depositing 50% of the decretal amount as ordered by this court, order dated 9/12/2024. It is stated by the learned counsel for the appellant that 50% of the amount as per the order dated 9/12/2024 was deposited on
15/4/2026.
15/4/2026 after 2 years.
That
2 years.
After 2 years.
1.5 years. That some that in a.
ಅದಕ್ಕೆ ಎಷ್ಟು ದಂಡ ಎಷ್ಟು ಹೇಳಿ? For that, how much will be the cost? Deposited on
15/4/2026.
15/4/2026. Full stop. Though this court had passed an interim order on 9/12/2024 staying the operation and execution of the impugned judgment and decree subject to the appellant depositing 50% of the decretal amount within 6 weeks. However, even after 1.5 years, the appellant has deposited the amount and has filed an application seeking enlargement of time to deposit. this conduct of the appellant is unbecoming and therefore warrants deterrence. Consequently, IA so-and-so is allowed subject to payment of cost of rupees.
Any reasonable?
No, nothing comes free, sir. ನೀವು ಒಂದು ದಿನ ಟೈಮ್ ಬಿಲ್ ಕಟ್ತಿದ್ರೆ ನೀವು ಟ್ಯಾಕ್ಸ್ ಹಾಕ್ತಿರಲ್ಲ, ಪೆನಾಲ್ಟಿ ಹಾಕ್ತಿರಲ್ಲ. ಒಂದಿನ ಬಿಲ್ ಕಟ್ಟದೇ ಇದ್ರೆ you will impose interest. So better pay. Cost of rupees 25,000 payable.
That's reasonable.
No. Payable to the respondents. This shall be deposited within 2 weeks from today, failing which the appellant shall pay further cost of rupees 10,000 for every month's delay in depositing rupees 25,000. Yes.
That 4 weeks deposit.
No, 4 weeks ಏನಕ್ರಿ?
That
No. Yes, next 2 weeks.
Number 3, Raghunath MD.
Raghunath MD.
My lord, as far as R2 is concerned, he has also challenged the judgment. He has filed RFA 2008/24.
Barkul. Yar advocate here.
Mr. N. Dinakaran.
Mr. N. Dinakaran is directed to accept notice for respondent number 2. Office is directed to list RFA number so and so along with. Yes.
No, interim order.
Interim order granted earlier is extended till the next date of hearing. Mr. R.B. Sadashivappa.
Number 4, R.B. Sadashivappa.
Respondent.
Non-payment of DCF on the value of rupees 1 lakh in view of section 24B. DCF ಅಂತೇನೋ ಇದೆಯಲ್ಲ ಸರ್?
Last time ನಾವು ಹೇಳಿದೆ DCF ಬರೋಲ್ಲ because whatever we have paid in the trial court, we have paid it here.
What is the suit for?
Suit for declaration and for injunction.
Suit for declaration.
Between husband and wife problem. And husband executes a gift deed in favor of his own sister, second defendant.
What is the value mentioned before the trial court?
Value as such, my lord, is not. My lord finds it on page 26, my lord.
26.
1 lakh, my lord. The suit is not dismissed on merits, my lord, but on a preliminary issue.
Preliminary issue.
That is what my lord wanted a decision on the point. I take my lord's attention to the judgment of the Supreme Court.
No, that is right, but valuation is 1 lakh, is it, before the trial court?
1 lakh.
Barcode.
My lord,
The appeal is valued at a sum of rupees 1 lakh under section 49
yes,
of the Karnataka Court Fees and Suits Valuation Act. Hence, the valuation of the appeal is accepted. Office objection in this regard is overruled. ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ court fees? You not paid any court fee at all.
no, 150.
ಅಲ್ಲ 1 lakh ಗೆ ಎಷ್ಟಾಗುತ್ತೆ?
150 rupees ಕಟ್ಟಿದೀವಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಅಷ್ಟೇ ಕಟ್ಟಿದೀವಿ, ಇಲ್ಲೂ ಅಷ್ಟೇ.
ಅಲ್ಲ 1 lakh ಕೋರ್ಟ್ ಫೀಸ್ ಎಷ್ಟಾಗುತ್ತೆ? 15,375 ರೂಪಾಯಿ ಆಯ್ತು.
ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾವು 50 ಕಟ್ಟಿದ್ದೇವೆ.
ಎಷ್ಟು?
55 rupees 50. And here they, since they asked for more, we paid 150 in excess.
ಅಲ್ಲ ಬಟ್ ಇದಕ್ಕೆ 1 lakh ಗೆ ಎಷ್ಟಾಗುತ್ತೆ ಕೋರ್ಟ್ ಫೀ? You sought for declaration injunction or what? Declaration possession. What is sought for?
We have sought a declaration that the gift deed executed by the husband in favor of his sister.
So 50%, 50,000 ಗೆ ಎಷ್ಟಾಗುತ್ತೆ?
Is null and void ಅಂತ ಕೇಳಿದ್ದಾರೆ.
ಆಯ್ತು 50,000 ಗೆ ಎಷ್ಟಾಗುತ್ತೆ? Null and void ಅಂತ. 50,000 ಗೆ ಎಷ್ಟಾಗುತ್ತೆ?
50,000.
Even if you say 1 lakh, 50% is 50,000. 50,000 ಗೆ ಎಷ್ಟಾಗುತ್ತೆ?
ಅಷ್ಟೇ 400.
Your lordship, what has happened, your lordship? They have challenged the very gift deed.
ಇದೊಂದಲ್ಲಿದೆ.
They are not parties to it. They are not parties to the gift deed.
Yes.
So, not binding upon them ಅಂತ ಕೇಳ್ತಾರೇನೋ? What have you sought for?
The
Null and void.
And such being the case, as according to the market value of the property.
Right, you raise the defense before the trial court. Come on, merits.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, your lordship may kindly appreciate the previous occasion this honorable court has hearing the matter
with respect to the preliminary issue is concerned.
ಆಯ್ತು, preliminary issue ಮೇಲೆ ಹೆಂಗ್ dispose ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Lordship, section 41 H and J of the specific relief act is very clear.
ಏನಂತ?
When the efficacious remedy is available.
What efficacious remedy?
Lordship, in this case, the present appellant has filed the suit before the court below for declaration and injunction. Now, what is the relief sought for is, the appellant has only stated in the plaint that she has contributed some amount for construction of the house. It is not that she is having any share in the very property. When such being the case, the trial court has rightly framed the preliminary issues.
Can there be no dual ownership?
No dual ownership at all.
She says that she has contributed money.
No. She has not contributed the money to purchase the site.
What about building? Building.
Or only the building, only she says, but there is no any evidence at all also.
Sir, evidence ಮಾಡೇ ಇಲ್ವಲ್ರಿ? Evidence at all ಅಂದ್ರೆ preliminary issue ಮೇಲೆ dispose ಮಾಡಿದ್ದಾರೆ. Evidence ಇಲ್ವಂತ.
ಅಲ್ಲ, why the preliminary issues should not be considered ಅನ್ನೋದಕ್ಕೆ.
Please read the order.
The order is very clear. Your Lordship may kindly appreciate.
41H ಅಲ್ಲಿ ಹೆಂಗ್ ಬಾರ್ ಆಗುತ್ತೆ ಹೇಳಿ? Please point out under section 41H how the suit is barred.
Your Lordship, the order is very clear. Whether the suit in the present form is maintainable in view of the bar contemplated under 41J of the specific act and 41H of the specific relief act.
Yes.
Your Lordship may kindly appreciate with respect to the ownership of the property involved, the ownership of the house involved, the plaintiff before the court below admitted that the ownership is of the respondent.
Please tell me 41H ಹೆಂಗ್ apply ಆಗುತ್ತೆ?
Like efficacious remedy is elsewhere available.
Elsewhere and where? Elsewhere and where?
Andre, your Lordship may kindly appreciate our contention before the court below is, except giving some money to put up the house, there is no any contribution made.
Prakash, yes. 41H, for example, I'll give you an example. ಇಲ್ಲ, ಇದು KIT ದಲ್ಲಿ ಇದು ಅಂತದ್ದು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್, you cannot challenge in the civil court.
How?
Because there's an efficacious remedy before the high court or before whatever other, or assistant commissioner order before the deputy commissioner. So therefore the suit is not maintainable. I can understand. Here she challenges a gift deed executed by her husband in favor of his sister to deprive her claim. Where is the efficacious remedy? Yellow bakuru.
She can
Ultimately she may lose the suit. That's a different thing. She may lose the suit.
Yes, your Lordship. But she can file a suit only with respect to the money contributed by her to put up the structure.
That's the
not very challenging the very gift deed of
41H ಹೆಂಗ್ apply ಆಗುತ್ತೆ? How is 41H applicable? Suppose she has filed the suit for some reliefs, court can say you're only entitled to refund.
Ashte. It is
But
also
for
been
that the suit has to proceed. The suit has to proceed.
Not with the relief of declaration.
Sir, your suit dismiss agide.
How?
Ultimately, if the suit proceeds and if the court comes to the conclusion that she is not entitled to the relief that is sought for, but she is entitled to something else, court can mold the relief and direct refund of the money that she has paid.
Rather wasting the time in such a way of declaration, the court has.
Make an offer. According to you, how much she has contributed, you make an offer if she is willing.
In fact, your Lordship, not even a single pie has been.
So therefore, somebody has to investigate. Somebody has to try that.
What has happened, your Lordship? The marriage in between the respondents are strained. Only for that effect to.
First of all, this could not have been treated as a preliminary issue.
Preliminary issue
can be treated only when it goes to the root of the matter.
With respect to the framing of preliminary issues, I have a citation, your Lordship, of the Honorable Supreme Court, where Done.
Hmm.
When the contention and
Yes.
the issue is not touching with
What is the
respect.
issue in this?
Idralli, Your Lordship, they have attained the sannyasatva.
Hmm.
And since they have attained the sannyasatva, the concept of declaration and selling away the property, it can be considered as a preliminary issue anta ide. The same analogy is applicable
Oh,
to
no.
this case also, because she has sought for declaration.
ಇದರಲ್ಲಿ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಲ್ಲಿ ಕೊಡಿ.
ಅದಲ್ಲ ಕರ್ನಾಟಕದ ಫುಲ್ ಬೆಂಚ್ ತಗೊಳ್ಳಿ.
Supreme Court.
Full bench judgment.
On the point.
ಎರಡು ಸೇರಿ.
Some ದೇಸಾಯಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಯಾವುದು? Some ದೇಸಾಯಿ.
ಕೊಡಿ ಸರ್. ಅದನ್ನೇ ದೇಸಾಯಿ ಜಡ್ಜ್ಮೆಂಟ್.
ಇಲ್ಲಿದೆ ರೀ ಅದು. ಅದು ಇದೆ ಹಾಗೆ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಎರಡು
ಬರ್ಕೊಳ್ಳಿ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ is later.
The plaintiff in OS number, plaintiffs in OS number 4589 of 2017 on the file of so-and-so have filed this appeal challenging an order dated 19/10/2024 passed by the so-and-so, by which the suit was dismissed on a preliminary issue. Next para. The suit in OS number 4589 of 2017 was filed for a declaration that a deed of gift dated 19/7/2013 executed by the defendant number 1 in favor of the defendant number 2 is null and void, and to restrain the defendant number 1 from alienating or creating any right or any encumbrance in respect of the suit property until the marriage of the plaintiffs 2 and 3. Full stop. Briefly stated, the averments made in the plaint are that the plaintiff number 1 is the wife of the defendant number 1 and plaintiffs 2 and 3 are their children. Full stop. Defendant number 2 is the sister of the defendant number 1. Full stop. It is stated that the defendant number 1 owned the suit property and he had constructed a house in the year 2012 for which the plaintiff number 1 had also contributed. Full stop. However, the defendant number 1 abandoned the matrimonial home on 1/10/2015 and thereafter, to avoid the claim of the plaintiffs, executed a gift deed in respect of the suit property in favor of the defendant number 2 on 19/7/2013. The plaintiffs claim that they are residing in the suit property and the gift deed is designed to ensure that the plaintiffs are evicted from the suit property. So therefore, the plaintiffs sought for.
We are residing in one of the flats, not
residing in one of these flats constructed in the suit property. Therefore, the plaintiff sought for a declaration that the gift deed is null and void and for consequential injunction to restrain the defendant number 1 from causing any encumbrance until the marriage of the plaintiffs 2 and 3. Full stop. The defendants entered appearance and filed a written statement denying the contention of the plaintiffs that plaintiff number 1 had contributed to construct a building over the suit property. They also claimed that the defendant number 1, being the lawful owner of the suit property, had validly executed a gift deed bequeathing the suit property in favor of the defendant number 2, and therefore the suit of the plaintiffs is not maintainable, as they did not have any proprietary interest in the suit property. Full stop. Based on these contentions, the trial court framed issues. Full stop. The trial court, in terms of an order dated 19/6/2024, framed 2 additional issues which are treated, which are as follows. And copy mode. And the said issues were treated as preliminary issues. Full stop. The trial court, after considering the contentions urged on these 2 preliminary issues, held that a civil suit can be filed in respect of a property only if the plaintiffs have personal interest in the matter. And
With respect to the recovery.
if the apprehension of the plaintiffs was that the defendants are trying to dispossess the plaintiffs from the suit property, they ought to have filed for perpetual injunction to restrain the defendants from dispossessing from the suit shell property. Consequently, it held that the suit filed is not maintainable in view of section 41H and 41J of the Specific Relief Act, and answered both the preliminary issues in favor of the defendants, and consequently dismissed the suit as not maintainable. Being agreed with the said judgment and being agreed with the said order passed by the trial court, the plaintiffs are before this court. Next part. The learned counsel for the plaintiffs submitted that the trial court committed an error in framing two issues on the basis of section 41H and 41J of the Specific Relief Act 1963. He contends that at any rate, these two issues could not have been treated as preliminary issue, as they had a bearing on the other issues framed by the court. Full stop. He contends that a preliminary issue can be framed only when the issues goes to the root of the matter, such as jurisdiction of the court to try the suit, or any other lawful defenses such as res judicata, etc. In this regard, he relied upon the judgment of a full bench of this court in AR 2019 Karnataka 47, and contended where the full bench of this court held double inverted comma where the question of court fee is linked with jurisdiction, a defendant has a right to raise objection, and the court should decide it as a preliminary issue. But in those cases where the suit is filed in court of unlimited jurisdiction, the valuation disclosed by the plaintiff for payment of amount of court fee on relief claimed in plaint or memorandum of appeal should be taken as correct. This does not preclude the court, even in suits filed in courts of unlimited jurisdiction, from examining if the valuation on averments in the plaint is arbitrary. Full stop. He also referred to the judgment of the apex court in Satyanath and another versus Sarojamani, where
There are 7 and 18.
the Honorable Apex Court, after considering the provisions under Order 14,
Rule 2, madam. Paragraph 7.
held as follows.
Page 4, para 7.
Para 20 I'll copy out. Para 20. He therefore contends that the reasoning of the trial court that the plaintiffs were bound to sue for perpetual injunction, and therefore the bar under section 41H of the Specific Relief Act 1963 was applicable, he is misplaced. Likewise, he contends that the trial court assumed that the plaintiffs did not have any personal interest in the property, while the plaintiff number 1 had specifically mentioned that she had contributed for construction of the building over the suit shell property. Full stop. He therefore contends that the trial court committed an error in answering preliminary issues against the plaintiffs and in favor of the defendants. Per contra, the learned counsel for the defendant number 1 and 2, defendant number 1 and 2 submitted that there is no embargo in law against considering issues framed as preliminary issues and determining the suit on such preliminary issues. He contends that the plaintiffs do not dispute the fact that the suit property is owned by was owned by the defendant number 1, and that the plaintiffs did not have any right, title, or interest in the suit property. He contends that the only claim of the plaintiff number 1 was that she had contributed some money towards constructing a building over the suit property. If that be so, he contends, that the plaintiff suit must have been one for recovery of money rather than challenging the gift deed executed in favor of the defendant number 2. Full stop. He therefore contends that the plaintiffs ought to have sought for correct reliefs rather than seeking for a declaration that the gift deed dated so-and-so is null and void. Besides this, he contends that the plaintiffs categorically admit they did not have any personal interest in the suit property, and hence the trial court was right in exercising jurisdiction to set at naught a mischievous suit filed by the plaintiffs. In support of this contention, he relied upon the judgment of the apex court in AR 2021 SC 2710, Cost State Law Comedy. Full stop. Anything else? Consider the submissions of the learned counsel for the plaintiffs and the learned counsel for the defendants. Next panel. The apex court, while considering the contours of CON TOURS of Order 14, Rule 2 of CPC, held that it is only those suits that fall within the ambit of Order 14, Rule 2 A and B that a preliminary issue could be framed and the suit could be disposed of. However, in respect of those suits which fall beyond or outside the scope of 14 Rule 2 A and B, the courts cannot frame a preliminary issue and decide the suit. Full stop. In the case on hand, the plaintiffs claimed that the suit property belonged to the defendant number 1 and that an apartment complex was constructed thereon, and in one of the apartments, the plaintiffs were residing. Full stop. Plaintiff number 1 claimed that she had also contributed some money for constructing the apartment. Full stop. Apartment, and therefore the defendant number 1 could not have executed a gift deed bequeathing not only the suit property but also the apartment constructed thereon. Full stop. In India, the concept of dual ownership is recognized, and while the plaintiff number 1 could be a part owner of the building constructed, the defendant number 1 could be the owner of the property. Therefore, this question had to be determined by the trial court after a full-fledged trial. It could not have considered the suit of the plaintiff by applying Section 41H and 41J of the Specific Relief Act 1963, and it could not have dismissed the suit by applying Section 41H and 41J of the Act 1963. Full stop. The discretion to grant reliefs by the trial court is guided by Section 41H and 41J of the Act 1963, and that in itself cannot become a ground for rejection of the plaint on a preliminary ground. In that view of the matter, the impugned order passed by the trial court is erroneous and calls for interference. Consequently, this appeal is allowed. The impugned order passed by the trial court is set aside. The trial court is directed to take up the suit on merits for trial on merits, and thereafter decide all issues including the preliminary issues framed by it in accordance with law.
Please, please.
I'm only for D2 in this case.
D2 ga
Only.
T1.
defendants, but you have filed a common statement or what?
No, different statements.
Defendant number 2 ಅಂತ ಹೇಳ್ಬಿಡಮ್ಮ. Yes.
Serial number 5, Madhu SB.
Madhu SP.
2 weeks time will be granted for the complaints of the office of.
Non-compliance of office objections. ಏನಿದೆ proper DCF to be made, good markings in the
Court fees on.
annexure, detailed memo for valuation to be stated, type
All other-
copy of OS valuation slip to
All other objection is complied, my lord. Only in respect of court payment.
Court fee?
Yes, my lord.
ಎಷ್ಟಿದೆ?
2 weeks. 45,375 it is.
1 week time is granted.
2 weeks
7th
time.
time ಕೊಟ್ಟಿದೆ. This is
Like
the 7th time it's been
Appellant
listed.
accident ಆಗಿದೆ sir.
Huh?
Appellant accident ಆಗಿದೆ. Bed
ಆಯ್ತು
ridden.
7 ಸತಿ ಟೈಮ್
weeks.
ಕೊಟ್ಟಿದ್ದೀನಿ. As the last chance, 2 weeks time is granted to comply the office objections, failing which, the appeal shall stand dismissed without reference to bench. Chaitanya SG.
Serial number 6.
Appearance of appellant in this case, my lord.
List after service of notice to response 1 to 3.
Great,
Entry
sir.
ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
Next, Raghuram Pillai.
Number 7, Raghuram Pillai.
2 weeks time is granted to do the needful, failing which the appeal shall stand dismissed without reference to bench.
Serial number 8, Syed Khalil Pasha.
2 weeks ಬೇಡ, 5 weeks ಅಂತ ಮಾಡಿ, ಹೆಂಗೋ ವೆಕೇಶನ್ ಬರುತ್ತೆ. 5 weeks.
Serial number 8, Syed Khalil Pasha.
Syed Khalil Pasha.
Service of notice, my lord, is pending.
Awaiting.
List after service of notice to respondents 3 and 4.
This month, last week, my lord.
Huh?
This month, last week, my lord, I'll take chance, my lord, because the execution petition is
This
filed.
month, last week, stay ilva.
Taylor.
There is another appeal pending which is filed earlier. ಅದನ್ನ ಸಪ್ರೆಸ್ ಮಾಡಿ ಇದು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ ಫೈನಲ್ ಡಿಗ್ರಿ.
This is against the final decree.
This appeal is against the final decree. The preliminary degree is also challenged. ಅದನ್ನ ಪರ್ಸ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ. ಇಲ್ಲಿ ಇದು
ಆಯ್ತು, preliminary decree ಹೇಳಿ ಯಾವ್ದು, ಅದೇನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಬರುತ್ತಾ ಅದು?
ಇಲ್ಲ
Single bench.
ಇಲ್ಲ ಸಿಂಗಲ್ ಬೆಂಚ್.
Please give the number. List along with RFI number.
8.1 ಅಂತ ಲಿಸ್ಟ್ ಆಗಿದೆ.
This point is very limited, my lord, with regard to the rent collected by me from the defendant number 2. That is the issues raised by the FDP filed by the appellant. Therefore, my lord, this honorable court.
Preliminary decree ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ.
ಈ ಮಂತ್ ಇದು ಇನ್ನು ಇಬ್ಬರಿಗೆ ಸರ್ವಿಸ್ ಮಾಡಬೇಕು.
ಇಲ್ಲ ಇಬ್ರು ಇದ್ದಾರೆ.
Non amendment of cost title in respect of deceased R6.
We have complied all this.
Yeah, Dattatreya Joshiyar.
Another advocate is appearing in that case.
Let him at least do this amendment.
ಅಲ್ಲ ಮಾಡಲಿ, I have no objection.
Pass over, let him come. Let him come and amend the cost title. Pass over.
Serial number.
Mohan Chandra.
Serial number 9, Mohan Chandra P.
Does not exceed 10 lakhs.
Valuation slip ಅಲ್ಲಿ ಏನ total 3 items of property. My page, your lordship, kindly see the page number 27 and 28. Total 8 ಎಕರೆ 66 ಸೆನ್ಸ್ ಲ್ಯಾಂಡ್ ಉಂಟು. ಟೋಟಲ್ ಮತ್ತೆ ಇಲ್ಲಿ ನೆಕ್ಸ್ಟ್ 28 ಪೇಜ್ ಅಲ್ಲಿ 3 ರೆಸಿಡೆನ್ಷಿಯಲ್ ಹೌಸ್ ಮತ್ತೆ 1 ಡ್ರೈಯಿಂಗ್ ಯಾರ್ಡ್ ಮತ್ತೆ ಬೇರೆ ಪಂಪ್ ಅದು ಇದು ಅಂತ ಉಂಟು. ಮೋರ್ ದನ್ 50 lakhs ವ್ಯಾಲ್ಯೂ. ಅದಕ್ಕೆ ಪ್ರೆಸ್ ವ್ಯಾಲ್ಯೂಷನ್ ಸ್ಲಿಪ್ ಆಗ್ತೇನೆ.
I do not know what was the value before the
ವ್ಯಾಲ್ಯೂ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಮೋರ್ ದನ್ 50 lakh.
Where is the valuation?
ಅಲ್ಲ, ನಾನು ಪ್ರೆಸ್ ವ್ಯಾಲ್ಯೂಷನ್ ಸ್ಲಿಪ್ ಹಾಕ್ತೇನೆ. ವ್ಯಾಲ್ಯೂಷನ್ ಸ್ಲಿಪ್ ಕೆಳಗಿನ ಕೋಟಲ್ಲಿ ಹಾಕಿ ಕರೆಕ್ಟ್ ಇಲ್ಲ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 31. ನಾಟ್ ಇನ್ ಅಕಾರ್ಡಿಂಗ್ ಕರ್ನಾಟಕ ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಪ್ರಕಾರನೇ ಇಲ್ಲ ವ್ಯಾಲ್ಯೂಷನ್ ಸ್ಲಿಪ್.
Page number
31. ಟೋಟಲ್ 20 lakh ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅಷ್ಟೇ, ಬೇರೆ ಏನ್ ಬರ್ದಿಲ್ಲ.
If it is 50 lakhs, then it has to go before the division bench.
ಅದಕ್ಕೆ ನಾನು ಪ್ರೆಸ್ ವ್ಯಾಲ್ಯೂ SR ವ್ಯಾಲ್ಯೂ ಅಂತ ತಕೊಂಡು ಎಷ್ಟು ವ್ಯಾಲ್ಯೂ ಅಂತ ನಾನು ಇದು ಮಾಡ್ತೇನೆ. ಅದಕ್ಕೆ ಕೈಂಡ್ಲಿ ಗ್ರಾಂಟ್ 1 week time, I will file a press valuation slip.
What is your share?
Half, ಅರ್ಧ.
ಅವ್ರು 20 ಲಕ್ಷ ಅಂತ ನೀವು 50 ಲಕ್ಷ.
ಅಲ್ಲ, ನಾನು SR ವ್ಯಾಲ್ಯೂ ಪ್ರಕಾರ ಇದಕ್ಕೆ 20ಕ್ಕಿಂತ ಜಾಸ್ತಿ ಉಂಟಲ್ಲಿ. ನಾನು SR ವ್ಯಾಲ್ಯೂ ಎಷ್ಟನ್ನು ನೋಡಿ.
Correct. Did you raise an objection regarding valuation before the trial court? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಾಡಿದಿರಾ?
ಯಾಕೆ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜಿಗೆ ಮೋರ್ ದೆನ್ 5 lakh above, ಅದಕ್ಕೆ ಜೂಡಿ ಅದರ ಬಗ್ಗೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ನಾವು
Did you question the valuation before the trial court?
ಅದು ನೋಡಿಲ್ಲ ಅದರ ಬಗ್ಗೆ.
ಮತ್ತೆ ನೋಡಿಲ್ದಿದ್ರೆ
ಅಲ್ಲ ಅದಕ್ಕೆ
now
ಯಾಕಂದ್ರೆ
you cannot say it was 50 lakh.
ಜೂನಿಯರ್ ಡಿವಿಷನ್ 5 lakh ಬಿಲೋ ಅಂತದ್ದು ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಬಹುದು. 5 lakh ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜಿ ಮೋರ್ ದೆನ್ 5 lakhs.
My dear friend,
Yes.
did you question the valuation of the suit at rupees 20 lakhs? Was any issue framed?
ಇಶ್ಯೂಸ್ ಅದರ ಬಗ್ಗೆ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ.
You are not raised, how can you ಬರ್ಕೊಳ್ಳಿ?
ಅಲ್ಲ ನಾನು
File an appeal before the district court.
ಅಲ್ಲಲ್ಲ ಯಾಕಂದ್ರೆ ನಾನು ಎಸ್ಆರ್ ವ್ಯಾಲ್ಯೂ ಅಲಾಂಗ್ ವಿತ್ ಪ್ರೆಸ್ ವ್ಯಾಲ್ಯೂ
ಅದನ್ನೇ ಹೇಳ್ಬೇಡಿ ಮೋಹನ್.
ಅಲ್ಲ
You are not questioned the valuation before the trial court. Please understand.
ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಕರ್ನಾಟಕ ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಪ್ರಕಾರ ವ್ಯಾಲ್ಯೂಷನ್ ಇಲ್ಲ.
This is an appeal filed by the plaintiff, by the defendant number 1, challenging the judgment and decree dated 25/9/2025 passed by so and so in OS number 47 of 2022. Full stop. Office has raised an objection that the suit was valued by the plaintiff at a sum of rupees 20 lakhs and the value of the share of the plaintiff in the suit property was rupees 10 lakhs. Full stop. And therefore, this appeal, therefore, the first appeal before this court is not maintainable in view of section 19(1) of the Karnataka Civil Courts Act. Full stop. The learned counsel for the appellant submits that the value of the suit properties is more than rupees 50 lakhs, and therefore an appeal before this court is maintainable. However, a perusal of the judgment and decree passed by the trial court would show that the defendant did not contest the valuation of the suit as valued by the plaintiff. Full stop. Therefore, the defendant cannot now contend that the value of the suit properties was more than rupees 20 lakhs. If that be so, this appeal also has to be valued at a sum of rupees 10 lakhs, which is the value of the share of the defendant in the suit properties. Consequently, in view of section 19(1) of the Karnataka Civil Courts Act, the appeal before this court is not maintainable. Consequently, this office objection regarding maintainability of the appeal is upheld. The appeal is dismissed as not maintainable. However, liberty is reserved to the appellant to file an appeal before the appropriate appellate court. Office is directed to return the certified copy of the impugned judgment and decree after retaining a photocopy. The time consumed in pursuing this appeal shall be deducted while calculating limitation applicable to an appeal before the district court. Court fees ಏನು ಕಟ್ಟಿದಿರಾ?
ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟೇನಿ
ಎಷ್ಟು?
200.
Since the appellant has paid court fee before this court, he is exempted from paying court fee before the district court. Yes.
One more submission. ಈಗ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನು ಬರ್ದಿದೆ ಅಂತ ನಾನು ನೋಡಿಲ್ಲ ಪ್ಲೇಂಟ್ ಕಾಪಿ. ಒಂದು ಅದರಲ್ಲಿ ವ್ಯಾಲ್ಯೂಷನ್ ಬೈ ಮಿಸ್ಟೇಕ್ ಅಲ್ಲಿ ಇದ್ರೆ ನಾನು ಪ್ಲೇಂಟ್ ಕಾಪಿ
you should challenge it. You should challenge it.
ಯಾವುದು?
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕೋ ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಾಗ್ತದೆ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ 15 lakh ಹಾಕಿದ್ರೆ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜಿ ಅನ್ಲಿಮಿಟೆಡ್ ಜುಡಿಕ್ಷನ್.
Correct, Mr. You should challenge it. Now you cannot come before this court and say it is 50 lakhs. That you cannot say.
ಅಲ್ಲಿ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ 50 lakh ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ರೆ ಇದೇ ಕೋರ್ಟ್ ಜುಡಿಕ್ಷನ್ ಬರ್ತದೆ ಅಂತ ನಾನು ಹೇಳ್ತಿದ್ದೇನೆ. ಅದಕ್ಕೆ ಪ್ಲೇಂಟ್ ಕಾಪಿ ನಾನು
next
ಅಲ್ಲ ಈ ಒಂದು ನನ್ನ ರೆಸ್ಪೆಕ್ಟ್
ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿಲ್ವಂತೆ.
ಯಾರು ಹೇಳಿದ್ದು ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದೇನೆ?
ಕಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಕಟ್ಟಿದ್ದೇನೆ.
ಯಾರು ಹೇಳಿದ್ದು ಅಂದ್ರೆ ಕೋರ್ಟ್ ಫೀ ಟು ಬಿ ಮೇಡ್ ಗುಡ್ ಅಂತಿದೆ.
ಅಲ್ಲ ಕೈಂಡ್ ಪಾಸ್ ಅವರು ನಾನು ಎನ್ಕೊಂಡು ಇಲ್ಲ ಅಂತ ಕಟ್ಟಿಬಿಡ್ತಾರೆ.
ಅದು ಹೊಡೆದಾಕಿ ಲಾಸ್ಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಕರಿ.
Number 10 K Vijay Kumar,
awaiting service of list after service of notice to response 1 and 2.
Execution proceedings immediately after vacation not granted, my lord. That's why immediately after vacation, my lord, I will also
suit is for recovery of possession.
My lord,
suit is for recovery of possession.
Yeah, declaration and possession, objector property is different and decree holder property is different. The finding also, my lord, both the property are different. The court given a finding that you file a separate suit. I cannot file a separate suit.
Have you served the counsel who represented?
Counsel is not in station, my lord. When we decree holder counsel, when we went 21.
You send it. You should have sent it by RPAD.
Yes.
RPAD ಕಳಿಸಬೇಕಾಗಿತ್ತು. Yes, list after service of notice to response 1 and 2.
Number 11 Arun Govindraj,
Arun Govindraj,
Time for kindly take a 25th, my lord.
non-compliance of office objections, fourth time.
I have received a letter from my learned friend today. I will not object to time. May I make my submission only pertaining to the office objection, my lord? My lord, office objection 1 to 7 is in relation to the cause title of this appeal, my lord. It is the same as in the judgment. And on the last day, the senior counsel had submitted that we would be filing a memo seeking dispensation of issuance
Wherever
of notice.
there's duplicity of the same defendant, you can remove it.
It is the same as the judgment in the impugned judgment, my
You
lord.
make a note, the defendant number 263 and 264 are the same.
Please.
Make a note.
I filed an office note. I
Really?
have mentioned an office note. There's a written submission in that regard. And I've also filed a memo seeking dispensation of issuance of notice to all the defendants who were ex parte. My memo was filed on 21st of April, my lord.
Noted. Office objection number 3 is defendant 2474 and 2460 are deleted but made parties in this appeal. Defendant number 1648 and 1649 both are made parties in this. In D1650, clarify details of R364 to be clarified. Made parties twice, clarify and ranking to be rectified. Ranking before transfer response.
With regards to the same, I have sought for dispensation of issuance of
Sir, you
notice.
do whatever you want. You give a memo saying that so and so you can be renumbered as so and so. And you know, Kodi, there's duplicity of the same defendant.
Indeed, I understand, my lord, but the same was because of the impugned judgment, as was recorded. I understand what the court is.
Just because the trial court has not looked into this, the High Court also should not be blind and
I'm not saying
High Court can
any
correct
such
the
thing.
mistake.
Since I was seeking for dispensation of issuance of notice, it may be
ಅಲ್ಲಾಗಿರೋ ಮಿಸ್ಟೇಕ್ ಇಲ್ಲೂ ಮಾಡಿ ಅಂತ ಯಾಕೆ ಹೇಳ್ತಿದ್ದೀರಾ? ಅಲ್ಲಾಗಿರೋ ಮಿಸ್ಟೇಕ್ ಇಲ್ಲೂ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಾ ನೀವು? Correct it.
Please, my lord.
Why shouldn't you
It may be
correct
taken
it?
up on Saturday.
Yes. Yeah. What is the suit for?
Suit was for mandatory injunction, my lord. Filed by
You
the
correct.
respondent
You
number
attend
1.
to the office objections. Barkola list on Saturday if office objections are attended to. Yes.
My lord, kindly direct to serve the copy, my lord, memos. They already filed the memos.
Kodi, Adhyana, whatever that you want to serve, you please do it.
Serial number
A list on Saturday for admission if all office objections are complied or attended to. Yes.
Machkal, Rudraya, please.
We have for respondent number 1.
Document to verify the exact value for the
Valuation slip has been filed.
I appear for
Valuation
respondent
slip
number 1 in
is
this
44.
matter.
The valuation has been shown as rupees 10,000 and above as per section 35(2).
Valuation is shown as?
Above rupees 10,000.
Above.
Please.
Page
44. This property is situated in Bangalore.
What is the suit property? What is the suit reliefs?
Suit is for partition.
Partition.
Please. 1/3 share.
35 feet by 35 feet.
Please.
65 feet by 35 feet.
Huh?
65 feet by 35 feet.
It says east to west 35 feet, north to south 57 feet. Plus
8 feet of marginal land.
35 feet into 8 feet of marginal land.
Marginal land, yes.
So what is the value? 10 lakhs and above?
About 10 lakhs. About 10 lakhs. Yes.
Basongudi.
Yes.
Suit is filed in 22.
22.
Why don't you file a memo valuation, giving the correct valuation, at least the guidance value?
I'll file it.
The learned counsel for the appellant undertakes to file the valuation slip based on the guidance value of the suit property in the year 2022.
Please.
List after the same is done.
Please.
ಏನಿದು order 7 to 11 reject ಆಗಿದೆಯಾ?
Suit for partition.
Decreed.
Suit is decreed.
Defendants.
Defendants, yes.
Serial number 13, VV Ravi Shankar.
Needful done, you submit.
Learned counsel for the appellant submits a process to issue notice to the respondent number 1 is deposited along with other requisites. Office granted to check, verify and proceed.
Interim order be extended.
Interim order granted until the next date. Rakshita.
Serial number 14, Rashita DJ.
Your Lordship, on the last occasion, I directed the commissioner report to be filed.
Respondent. Yes, madam.
ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ. ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ.
ಏನಂತಾಯ್ತು?
As for exhibit P25 to 30 sheds ಇದೆಯಂತೆ. 33.
So let that status quo continue.
Yes. And in fact, my lord, what they say is, this is 38 guntas of land. The total extent, my lord, which we are in possession, my lord, is 7 acres plus this 38 guntas. My lord, entire, this 8 acres, my lord, has been compounded, which the commissioner can say. Entire 8 acres, my lord, has been compounded.
No, I think we will say that let the status quo be maintained as found in the photographs taken by the commissioner.
Yes.
Let one submission, the last occasion, I, sorry to forget.
Got your fees, madam?
Yes, madam.
You got your fees?
Let one memo, my lord, kindly see, the after judgment, my lord, the total extra 21 guntas has been constructed, the sheds are constructed. That lordship, the trial court also held that the sheds are constructed. After the judgment, that in the last month, my lord, I let out, my lord, the remaining portion of that extent of the land out of 38 guntas to some parking of some vehicles. But the rental agreement also I'm producing before lordship.
I think whatever remains will remain.
Please.
So nobody will put up any construction, nobody will demolish anything?
No, please.
No. Barkul. The commissioner appointed by this court with a order dated 17/4/2026 has filed a report. And along with the report, she has furnished photographs of the construction existing in the suit property.
Construction on the
temporary construction existing over the suit property. Full stop. Since the appeal is admitted, both the appellants and the respondents are restrained from putting up any construction other than what is already found in the photographs furnished by the commissioner, putting up any construction over the suit property, and neither the appellant nor the respondent shall demolish the temporary structures found in the photographs furnished by the commissioner until disposal of this appeal.
This memo may be taken on record.
For what?
Not that I have let out remaining portion of the property for parking of the vehicle.
Both the parties shall maintain status quo of the property till the disposal of this appeal.
They shall not obstruct the parking of the vehicle.
Copy no kotila. I do not even know what it is.
Parking
has to be other than nothing.
Entire 8 acres, if I may show my lord, our ಕೇಳ್ಬೋದು entire 8 acres
No, that is not pertains to our property.
And this 38 guntas is also inside that.
No, that property is not pertains to my brother.
Let the commissioner say, my lord, whether it is there.
No, there is no existence actually.
Please wait. The 38 guntas which you saw, was it within this enclosure?
ಹೌದು my lord. ಸುತ್ತಲೂ ಹಾಕಿದ್ದಾರೆ.
ಸುತ್ತಲೂ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವ್ರದ್ದು ಸೇರಿಸಿ.
ಹೌದು ಅದು ಮಿಡ್ಲ್ ಇದೆ ಸರ್.
For me, some other access is there, man. By using that road, my lord, we are accessing the property.
If he is using some other access, let him use
it. The entire has been compounded.
No, we will not obstruct their, we will not use that access, man. We are using some other access to park.
But now what will happen?
I already let out the premises.
I will say that if he is using the suit property for parking vehicles to some other access, he will continue to do so, but he will not affect or disturb the compound or whatever fence that he has put.
Yes.
Can that be done?
Yes,
please. It is made clear that if the respondents have let out,
will give scope for litigation.
Portion,
this will give scope for further litigation.
Have let out the vacant space. Let out the suit property for parking vehicles through a separate entrance. He shall not be disturbed by the appellants from doing so. However, this shall not mean that the appellant can cause any damage to the
appellant or respondent.
To the
the respondent cannot cause any damage to appellants.
However, this shall not mean that the respondent shall cause damage to the fence.
Existing fence like this, my lord.
Existing corrugated sheet fence put up by the appellants around its property.
Yes. Lord, may I make one more request, my lord? My lord, the suit, my lord, the comprehensive suit which is pending should be decided, my lord, without my lord being influenced by.
Again, what is this decree? What is this decree?
The injunction is though, there, my lord, for a declaration has been filed. Therefore, my lord, your lordships have passed a detailed order on the earlier occasion, where, my lord, your lordships had said, my lord, all these matters had to be taken up together.
But why did you allow the suit to be decreed?
My lord,
then?
we had in fact, my lord, filed an application, my lord, for transferring everything together. Therefore, my lord, then your lordships have made an observation, my lord, the court itself should have, my lord, taken up together. Now, my lord, what happens? Now there is an order of injunction. Now, my lord, my lord, they should not take up a contention, my lord, that there is already an injunction, because all those orders, my lord, were ex parte, without even serving us.
But based on the trial, my lord, the suit was decreed, not merely on the basis of, my lord, my submission. On the trial. No, my lord, what was happened?
For injunction.
My lord, what was happened? They filed an application section 24. It was rejected. They never chosen to file an appeal before this honorable court. They simply skip quiet. That is the reason the case was proceeded, my lord, it was decreed.
You sued for injunction act 3. Again, you filed a suit for declaration.
Not by me, my
Now,
lord. They only.
My lord, earlier they have taken, my lord, if your lordship remembers, my lord, if your lordship kindly see the last order, my lord, which your lordships have passed.
Yeah, the difference was also. So.
Para 6, my lord.
Without being influenced by any of this, my lord, let the matter be.
They never proceeded further. They have accepted the, my lord, the order passed by the trial court.
The suit filed by the appellants here in OS number 7515 of 2018.
And miscellaneous, my lord.
And miscellaneous. So and so filed by the appellant shall be taken up without being influenced by the aforesaid order.
Yes.
Yes.
15.
List after service of notice to R2.
Interim order method.
Interim order granted under extent till the next date. Yes, madam.
Your lordship, if your lordships go through the order.
No, but whether R2 is a necessary party.
Yes, my lord. He has received the amount.
Not to your lordship, he became ex parte actually.
No, correct, but
He was ex parte.
he was placed ex parte.
Yes.
Right before the trial court.
Yes, your
ಮತ್ತೆ
lordship.
ಕೇಳಲಿಲ್ಲ
He
ನೀವು
never appeared before the court.
ಅರವಿಂದ್ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ ಅಲ್ಲಿ ಆಫೀಸ್ ಇದ್ದು ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ 27 ಲಕ್ಷ ತಗೊಂಡು. ನಾವು ಮೇಲಾಡ್ದಕ್ಕೆ
ಡಿಫೆಂಡ್ ನಂಬರ್ 2 is placed ex parte ಅಂತ ಹೇಳ್ಬೇಕಲ್ವಾ ಕೋರ್ಟಿಗೆ ನೀವು?
ಅಲ್ಲ ಅವರು ಕೋರ್ಟ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆಗಿದ್ದಾರೆ ಸಭೆ, ಬಟ್ ದುಡ್ಡು ತಗೊಂಡಿರೋದು ಅವರು ಸಭೆ.
ನೀವೇನೋ ನಾನು ಏನೋ ಕೇಳಿದ್ರೆ ನೀವೇನೋ ಹೇಳ್ತೀರಾ. ಅಕ್ಕಿ ಕೊಡ್ರಿ ಅಂದ್ರೆ ಬೇಳೆಗೆ ಚೆನ್ನಾಗಿದೆ ಅಂತೀರಾ ನೀವು. Defendant number 2 is placed ex parte ಅನ್ನೋದು ಕನ್ವೆ ಮಾಡ್ಬೇಕಲ್ವಾ ನೀವು?
Defendant number 3, your lordship.
Sorry, ma'am.
Defendant number 3. Defendant number 1 and 2 are the tenants, and defendant number 3 is the property management company.
It is seen from the judgment and decree of the trial court that the respondent number 2 was placed ex parte before the trial court. Therefore, notice to respondent number 3 is not necessary. Respondent number 2 is not necessary. Yes, what is the case about?
Your lordship, for the past 6 years, without paying any rent, they are staying in the property. The property value is around 3 crore now. It's a 2,000 square feet apartment in Prestige
paying
property.
the rent or not?
My lord, may I submit? The first respondent, my lord, had authorized the second respondent to let out the property on lease and indirect tenants. My lord, the appellant, my lord, has paid a sum of rupees 27 lakhs to the second respondent on no rent, no interest basis. Now, my lord, the first respondent, my lord, being the owner of the property, my lord, files a case against the second respondent for recovery of the arrears of rent which is not paid to the first respondent. My lord, there is no obligation, my lord, for the appellant to pay maintenance charges. Because, my lord, as per the agreement, my lord, which the first respondent has authorized, my lord, the said agreement authorizes the plaintiff to the second respondent to collect the rent, and my lord, he collects the sum of rupees 27 lakhs.
Correct, but was there any authorization given to the respondent number 2 to take lump sum money?
Yes, my lord, agreement is there.
Illide.
I am filing, my lord.
Allide ಅಂದ್ರೆ ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕ್ಲಿಲ್ವಾ?
Your lordship, the
ಹಾಕಿದ್ದಾರೆ
authorization.
ಅವರು ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವರು ನಾನು ಮೆಮೊ ಹಾಕಿ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಇವರು ಬೈ ವರ್ಚ್ಯೂ ಆಫ್ ಅನ್ ಅಗ್ರಿಮೆಂಟ್, ಮೈ ಲಾರ್ಡ್, they authorize the.
Exhibit P10 ಅಲ್ಲಿ ಏನಂತಿದೆ?
Your Lordship, the
Does it-
authorization given, Your Lordship, I can take the copy of this. Basically, the authorization is given for collecting 1,60,000 rupees, Your Lordship, not for 27 lakhs.
Clause number 9 may kindly be seen.
ಇದೇನು clause number 5 ಓದಿ?
Yes.
It is mutually agreed that the second party shall pay a sum of rupees 1,60,001 as security guarantee deposit towards possession of the property. If the property is still vacant, deposit will be paid within 25 days from the date of the agreement. The security deposit shall not carry interest and shall be refunded back to the second party at the time of vacating the scheduled premises or termination of this agreement, whichever later, after deducting any arrears of rent, electricity bills, breakages, repairs, cleaning and painting charges. 50% of the security deposit bracket 1 lakh should be given to the first party when the agreement, and the remaining 50% should be paid within 25 days from the date of the agreement or the tenant occupation, whichever is earlier. My lord, clause number 9 may kindly be seen, my lord. The same agreement. In the clause number 9, my lord, the second party shall be competent to negotiate with the third parties for the purpose of renting out and leasing out the scheduled property, and is also competent to sign any required paper pertaining to lease or rent of the scheduled property, and may issue receipts for having received the advance amount. My lord, by virtue of this power, my lord, he enters into an agreement, my lord, with me. I am along with a memo, my lord, I kindly giving the copy of the agreement, my lord, that he has entered into between me. Kindly take the clause, my lord.
Clause number 10 also, Your Lordship, next
It is
clause.
my appeal. Kindly please wait. I will submit. Bring up our agreement. Yeah. Ink page 14, my lord, of the agreement, my lord, which I now produced along with the memo, my lord.
Yes.
In that clause number 2, the duration of the lease shall be for 2 years from the date of the agreement, which may be renewed for another term after mutual discussion and understanding between the parties. The lease shall commence from 9th of August and deemed to be terminated on 8th of August to 22. After the completion, accordingly, the lessee is put in possession of the scheduled property and thereafter hold the same and enjoy the same for a period of subject to terms and conditions. Next clause, my lord, it is mutually agreed that the lessee shall pay a sum of rupees 27 lakhs, including maintenance, 27 to the lessor towards interest-free security deposit. This amount, my lord, of 27 lakhs is
27 lakhs ಅಂತ ಎಲ್ಲಿದೆ? Clause number?
2, my lord, in page 14 of the agreement between myself, second agreement, my lord, in page 14.
No, that is right, but you have to recover from it from him.
My lord, he has vacated the premises and left the place, my lord.
Yes.
The premises belong to the first respondent. By virtue of the authorization given by the first respondent to the second respondent, my lord, he collects the amount. Now, my lord, its whereabouts are not known, and the suit is also for not for recovery of possession. It is only for arrears of rent, my lord. The suit, my lord, filed by the landlord is not for possession.
Yes.
Kindly see the prior, my lord, in the suit. It is only against the respondent number 2 for arrears of rent,
No, Your Lordship.
maintenance. And my
Prayer is
lord,
absolutely
and my lord,
to vacate,
there is
Your
no
Lordship.
contract between, there is no contract or lease between myself and the first respondent. The lease is between the second respondent and the appellant.
Yes.
The appellant, my lord,
Suit is for vacating the tenancy, Your Lordship.
Is that so?
kindly see I will pass on the plaint, my lord. I'll pass on the
Your
point.
Lordship, basically, there are two different agreements, Your Lordship.
It's a suit for recovery
I
of
have
possession.
submitted, Your Lordship, in that. It is the plain.
Suit is for recovery of possession.
No, not to direct the defendant to vacate defendant number 1 from the suit schedule property and to hand over the possession of the suit schedule property
No,
to
they are
the
plaintiff.
plaintiff. The defendant.
Internal page 8, Madam, is the prayer.
Page number.
Pass a judgment and decree directing the defendant number 3 to vacate defendant number 1 from the suit schedule property. The plaintiffs, my lord, are not asking any direction to vacate the premises. D3 D2 vacate ಮಾಡು ಅಂತ
Number
ಹೇಳ್ತಾರೆ.
1 ಯಾರಲ್ಲಿ?
ಇವರು ನಮ್ ಟೆನೆಂಟ್ ನಮಗ್ ಕೊಟ್ಟಿರೋರು D2 ನಮಗೂ ಆಗ್ಲಿ
Plaint is only for recovery of arrears of rent.
Yes, my lord, kindly see the second prayer. D3 to direct the defendant, D3 is to pay the defaulted rent from the March 23 till the disposal of the suit. To pay the defaulted maintenance
If you
charges.
have vacated, you hand over possession.
My lord?
If you have vacated, you.
I have not
hand over-
vacated, my lord, I am still in possession, my lord. I have this.
If you want to be in possession, pay the rent. We will decide the suit.
Your Lordship, the rent
Pay
is.
the rent.
ಅಲ್ಲ 27 lakhs ಗೆ ಪಾಪ ಪುರೋಹಿತರು ಸ್ವಾಮಿ ಅವರು
That
27
is
lakhs.
question that has to be decided in the suit, in the appeal. If you want to reside in the premises, pay the rent. We will decide the appeal.
This 27 lakhs interest, my lord.
That is your problem, Mr. Barkul.
Your Lordship, the current rent in that property is approximately around 78,000. It's a
ಅಲ್ಲ
2,000 square feet of apartment.
ಅಗ್ರಿಮೆಂಟ್ ಇರೋದೇ
The 2,000 square feet of super built up area with all the facilities and amenities, Your Lordship. It's a
maintenance-
prestige property. Your
The
Lordship, I
maintenance-
haven't received not even a single pie from this tenants actually.
What
From
was the-
2020 onwards.
What was the rent that the
That time, 2020, it was 40,000.
40?
40.
40,000.
40,000.
agreement ಹೆಂಗ
And now, from 2020, they were in possession of the property even
40,000 along with maintenance or without maintenance?
with maintenance. But they haven't paid any maintenance amount. I was the one who has paid.
What is the maintenance now charged?
That time it was 6,000. Currently,
Now.
Your Lordship, quarterly around 22,436
Is the maintenance?
is the
Monthly?
maintenance amount.
Monthly
That
or-
is in 2023, Your Lordship.
Monthly or once in 3 months?
3 months, 3 months.
Once in 3 months. Barkul.
So it's a prime property. I haven't received a single pie of 27 lakhs. Their remedy is against the D3, Your Lordship. It's a property management company.
The operation and execution of the impugned judgment and decree state subject to the appellants paying monthly rent of rupees.
That document 78.
ಅವಾಗ ಎಷ್ಟು 40,000?
ಅವ್ರು 36,000.
ಇದು ಮೇಂಟೆನೆನ್ಸ್ ಎಷ್ಟು?
Maintenance 6,000.
So 34,000 was the rent.
Your Lordship,
34.
once
Please wait.
that
madam.
time, Your
Please
Lordship.
wait.
Clause number 2 of the lease deed.
ಎಷ್ಟನೇ ಇಸ್ವಿ ಅದು? ಎಷ್ಟನೇ ಇಸ್ವಿ ಅಗ್ರಿಮೆಂಟ್ ಅದು?
2020, it was
20
40.
agreement.
And now,
2020 agreement.
2020. So even if you say 20% escalation for 3 years, 20% escalation for 3 years ಹಾಕಿದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? 34,000
20%
into 0.20, 6,800.
My lord, Lordship has to take into consideration, my lord. that
ಬಂದೆ
is-
ಬಂದೆ ತಾಳಿ plus 34,000 into 0.20. What is the date of the agreement? 2020.
2020. And it was expired in 2022. And now it is a tenancy at sufferance, Your Lordship. Their possession was legal, now it is illegal. And they were staying there for the past 6
Some more
years
rupees
without.
50,000 per month, apart from the monthly maintenance. Full stop.
And the
This-
ideas of rent also, Your Lordship.
This shall be paid by the appellants every month to the respondent number 1. And it shall be the duty of the respondent number 1 to ensure that the monthly maintenance is paid to the apartment owners association. This shall not be construed as if this court has treated the rent at a sum of rupees 50,000, and the same shall be subject to final adjudication.
My lord, my amount of rupees 27 lakhs, my lord, which is lying with second respondent authorized by the first respondent, my lord, that remains interest free, my lord.
Yes, yes.
And
You pay that will see whether he is liable, somebody else is liable. We'll consider.
my lord, by virtue of the authorization given by first respondent, my lord, the second
If you
respondent.
want to be in the premises, you pay the rent. If you want to be in the premises, you have to pay the rent.
No, the contract for payment of rent is between the first respondent and the second respondent, my lord. As far as I am concerned, there
Yes,
is
if
no
you are
agreement, my
entitled
lord.
If you are entitled to, then we'll direct the recovery of this money from this person, or by proceeding against the property also. But so long as you are residing in the premises, now there is a decree for eviction, you are bound to pay the rent.
My submission is, my
Your
lord, that the
Lordship, the
suit
current rent is
that,
around 78,000. I can submit the
but the
document
suit,
connected with that.
since there is no
We are
contract.
not finally deciding, madam. It is tentative. This is all
For
tentative.
the past 6
contract,
years,
there is no contract or there is no lease deed between the first respondent and the appellant, my lord.
Yes.
It is
Your
only
Lordship-
between the second respondent and the appellant.
Yes.
Your
There
Lordship,
is no,
Sir, he is only authorized agent to let out the premises on her behalf or his behalf or whatever. So
But,
therefore, even if you say there is no contract, there is an implied contract between the plaintiff and the defendant number 1.
that stand, my lord, when once to question of repayment of the amount, they say I am not responsible. When
yes.
once to
We'll
question
consider
of rent, my lord, they
Lordship,
cannot.
they will continue because
Leela P.
50,000 is
Serial
very
number
less in that
16,
property.
Leela P.
My authorization is only to collect 1,60,000 and they collected 27
Madam,
lakhs.
we are not deciding the appeal.
But
which
they
is-
will continue because 50,000 is very less for a prestige
Don't
property
worry,
of
madam.
this
If you
house.
don't want that, we will
Your
remove that
Lordship,
also.
I am just informing because for the
We'll
past
remove
6
that also
years,
if you do not.
for the past 6 years, I haven't received anything in
Yes,
my
yes,
hand.
yes, next.
Serial number
I
16.
said this is only tentative.
Yes, Your Lordship.
Lord, this
I-
is the racket, my lord, going on in Bangalore, my lord, where they appoint the service agent, they receive the money and abscond, my lord.
Yes, you should be cautious, mister.
No, this, by virtue of this agreement, my
No, you
lord, they have
should be
paid them.
cautious. You should be cautious. Yes, Leela P.
Serial number 16, Leela P.
Your Lordship, this is supposed to be a second appeal. Due to some oversight in the front page, it's mentioned as a first appeal.
Barkoli, the appellant has challenged the judgment and decree passed in RA, passed by so and so in RA number 5039 of 2017. The office has raised an objection regarding maintainability of a first appeal, as the appellant was bound to file a second appeal.
File the memo
In that
for
view of the
withdrawal.
matter, this appeal is dismissed as withdrawn.
Liberty.
Full stop. ಅದಕ್ಕೆ ಮುಂಚೆ, the appellant has also filed a memo to withdraw the appeal. In view of the above, the appeal is dismissed as withdrawn. Liberty is reserved to the appellant. You want this to be converted or what?
I will file it again as a second appeal.
Liberty is reserved to the appellant to file a second appeal. Office is directed to return the certified copy of the impugned judgment and decrees. The time consumed in pursuing this appeal shall be directed while calculating the limitation applicable to a second appeal. Any court fees to be paid?
Court fees is, there is some objection.
Not paid any court fee. Yes, next.
Wait.
For statistical purposes, this appeal is treated as closed.
Serial number 17, Subramanya.
Subramanya Kaushik.
Two office objections have been raised, Your Lordship. With respect to the first office objection, not having mentioned the number of delays.
What is the value?
Value, Your Lordship, the valuation slip is at page number 57. It is shown as more than 50 lakhs and it's a suit for partition. And 1/5 share is what is sought in
If
the.
it is 1/5 share, it is 10 lakhs.
But the overall value, 11 items are there, Your Lordship. More than 50 lakhs has been stated.
See the.
One humble submission, Your Lordship. I've sought for the SR value. Just one.
So that is right, but if you're not challenged this value before the trial court, you cannot come here and say that the value is more.
Your Lordship, I have stated that the value of the property is more than 50 lakhs.
Have you said that in this
Yes,
statement?
valuation slip is at page number 57, Your Lordship.
Have you said that in your written statement?
No, I am pure for the plaintiff, Your Lordship. My suit, partition suit has been dismissed, Your Lordship.
Dismissed?
Yes.
What have you said? You have mentioned in the plaintiff that it is 10 lakhs.
It is worth more than 50 lakhs and hence the plaintiff, the share of the plaintiff would be at 10 lakhs is what has been stated. However, to verify, I have sought for the SR value of the properties. 11 items are there, Your Lordship. So kindly one chance may be granted, Your Lordship. I'll just verify it and submit it, Your Lordship. If not, I'll withdraw it and file appropriate appeal before the
Learned
district court.
counsel for the appellant seeks time to place on record a fresh valuation slip based on the guidance value in the year 2000.
11, Your Lordship. The suit-
2011.
Yes. Your Lordship, with respect to the delay, I have already stated in the appeal memorandum as well as the IA to condone the delay, Your Lordship. 707 days delay is there. I've already
First
stated.
to first to clarify about this valuation.
Grateful, Your Lordship.
Next.
Serial number 80, Kiran, Sebastian, Rosario.
The appellant in this matter, my lord, filed this appeal under section 19(1) of the Family Courts Act, my lord. There's a maintainability objection raised since the section 96.
How is an appeal RFA maintainable?
My lord, it may be converted to an MFA, my lord.
Barcode, learned counsel for the appellant has challenged the judgment and decree dated so and so, passed by so and so, and OS number so and so. Office has raised an objection that a regular first appeal under section 96 of the CPC is not maintainable in view of an appeal remedy available under section 19 or 18? 19 of the Family Courts Act 1984. The learned counsel for the appellant fairly accepts this position of law. Hence, this appeal is not maintainable. Office objection regarding maintainability of this appeal is upheld. The office is directed to, registry is directed to convert this RFA into a miscellaneous first appeal. Counsel for the appellant is directed to make appropriate corrections in the appeal to bring it in line with the format of a MFA prescribed. Full stop. For statistical purposes, this appeal is treated as closed. Yes.
For hearing on IA, serial number 19.
Lord, may I make one
B.
submission?
Reddy, Manjunath H.
I'm very sorry, but again I'm interfering. Serial number 1, interim order extension ಕೇಳಿಲ್ಲ ತಿರ್ಗಾ
Much.
Yes, next.
Serial number 19 for hearing on IA.
So the
Anusha B.
appellant's
Reddy.
counsel is met.
Your Lordship will recall, Your Lordship had asked us to come back with details of the advocates on record in the 4 suits. Not, I have passed on a list of dates, not quickly to just refresh Your Lordship's memory. Lordship just have those list of dates.
Yeah, what is this? Delay of 4 to 5, 4,
Please,
5.
Lord. Suit, this is the appeal by the plaintiff.
Ah.
Plaintiff filed a suit for the rectification of the sale deed. Her vendors were placed ex parte. The defendants who were
Plaintiffs
there placed
filed a
ex parte.
suit for rectification of the sale deed.
Rectification of the sale deed.
Ah.
The vendors were placed ex parte. The person before Your Lordships now opposing the delay is a subsequent purchaser who purchases the property in 2022.
Yes.
There were multiple suits between the neighboring landowners and the plaintiff. The contention of the respondent now is that you were prosecuting the other matters, and this matter being dismissed, you did not challenge it in 2009. So there is a delay. My lord, the plaintiff before Your Lordships is a housewife. She resides permanently in Hyderabad. The matter was being prosecuted by her husband. Her husband died in 2012, November 2012. She was unaware of the dismissal of the suit nor the pendency of the suit. Subsequently, she gives the power of attorney to her son. Her son enters
Which are the suits that you had filed?
Well, Lord, I had filed 3 suits. One was 8729, my lord, of 2004. In 2004, my lord.
Who is the lawyer in 8729?
My lord, in 8729, I have prepared a list of lawyers
Everybody.
from we have obtained the certified copy of the wakalats also.
Who are the lawyers?
This is the court. Well, Lord, first suit is 8729 of 2004. It was filed by one Mr. Muralidhar on 26/11/2004. Subsequently, another lawyer enters appearance on 2007. Subsequently, in 2012, my lord, Ramesh P. Kulakarni continues the suit. 9897 is filed by the vendors of the respondent before Your Lordships. There I am defendant number 2. There my lawyer in 2007 was one Mr. Shantaram then Venkataram enters appearance, and 2012 Ramesh P. Kulakarni enters appearance. Such 3599 is the judgment which is under challenge before your lordships. This was filed by one Mr. Venkatram in 2008. Suit came to be dismissed in 2009. My husband passes away in 2012. The lawyer who enters, the change of wakalat happens in 2012. Mr. Ramesh Kulakarni is the one who comes on record in all the matters, in the two matters, not all matters. But
In 3599 is not entered appearance.
no, because it dismissed in 2009 itself. It came to be dismissed in 2009. And Mr. Ramesh Kulakarni is the lawyer who appears in 2012. The husband of the appellant passes away in November of 2012. She was unaware of it, and he was suffering from chronic kidney disease. He had not informed about
I have
this.
3 submissions to make. One, can your lordship just please have the affidavit, because according to them, their case is that the wife was a housewife. She was unaware of the pendency of this case. She had absolutely no information regarding the pendency or dismissal of the suit. Your lordship will only have the IA for condemnation, what Kusuma Kumari has stated on affidavit, and then I will show your lordship how that's a false statement.
Yes.
Yes, your lordship have the IA. But para 4, if your lordship permit me to read.
Yes.
I state that I filed a suit bearing OS number 3599 of 2008 on June 4, 2008 before the Honorable 39th Additional City Civil and Sessions Court. I state that I had appointed my late husband, Mr. late S. Venkateshwarlu, as an attorney via a GPA to initiate and to defend proceedings in respect of the suit property. I state that the suit was filed seeking a mandatory injunction directing the defendants to execute a deed of rectification by incorporating survey number 17/2A instead of 3/3B as depicted in the sale deed dated November 24, 1994. Para 5. I state that defendants in the instant suit were placed ex parte by the Honorable Trial Court. I state that my attorney holder and his husband, late S. Venkateshwarlu, led evidence on my behalf as PW1. I state that a total of 5 exhibits were marked and taken on record by the Honorable Trial Court. I state that pursuant to recording of evidence and hearing arguments, the trial court was pleased to dismiss the suit via a judgment dated June 18, 2009. Now, this date is very important. Not June 18, 2009. I will tell you lordship why. I state that I am a housewife and was residing with my family at Hyderabad when the suit came to be filed. I state that I don't have knowledge and know-how of the court procedures and much less about the laws governing the suit schedule property. I also state that as on 2008, I had been suffering from minor health ailments. I state that in view of the above stated facts and circumstances, I had appointed my husband as my power of attorney to conduct the matter on behalf of me. I state that my husband was diagnosed with kidney-related ailments during the year 2008. I state that my husband's health deteriorated commencing from August 2008 and he was diagnosed with chronic kidney disease. I state that he was undergoing medical treatment from Care Hospital so-and-so. State that my husband, owing to kidney-related ailments, was undergoing dialysis on a day-to-day basis for treatment of his copies of the consultation received October 6th, December 18th, all of 2008. I state that owing to my, next page, 48. I state that owing to my husband's ill health, we were required to make frequent visits to Care Hospital. I state that my husband, owing to prolonged health ailments, passed away on November 27, 2012. Till now, Lord, there is not one statement in the affidavit to say that the husband, who is not merely a husband, he is a GPA holder, and I'll come to explain why that is important that he is a GPA holder. Under 229 of the Contract Act, notice to GPA is notice to principal, deeming fiction. Now, please see 9. There's no statement in the affidavit that the husband was not.
Considering an application for condonation of delay.
Yes,
no, don't go to 229 and all.
Yes, I'm coming. Just come to para 9. I state that my husband was the sole person who had complete knowledge in relation to the suit. I state that I was not aware of the suit. I was not aware of the conclusion of the suit, and the Honorable Trial Court, having dismissed the suit by judgment dated June 18, 2009. Then she says the sons also had no knowledge. Now, Lord, I've produced one document, your Lordship will see in the memo that I just passed, an affidavit filed by this lady itself.
Yes.
Yeah, I know. Not please have page number 2 of this note. This is an affidavit filed in the name of Kusuma Kumari in the 2004 suit which she had filed. Have you given them a copy?
Yes.
Please see, I have a certified copy of this as well. I, Kusuma Kumari, wife of Venkateshwarlu, Major now at Bangalore, do hereby solemnly affirm and state on oath as follows. I am the plaintiff in the above case and am well aware of the facts. I submit that in the above case, I have filed the original sale deed and original letter issued by BDA. I submit that I have filed one more suit in OS 3599 of 2008, pending on the file of additional city civil. In the above suit, I have commenced evidence and the case is now posted on 12/6/2009 for production of further documents and for my further evidence. The above documents are necessary to be produced in the above said. I submit that after completion of the evidence, I undertake to return of the said documents and produce the same before this honorable court. This affidavit is signed off on 6/6/2009, in which they say on 12/6/2009 the matter is next listed in the 2008 suit, and the suit is dismissed 6 days thereafter.
Yes.
From 2009, the husband, who is an attorney holder, no statement in the affidavit to say that the attorney holder was not aware. It is not a case where the husband was the plaintiff and husband prosecuted the suit and husband died. It is a case where the power of attorney holder, who incidentally happens to be the husband, was alive on the date of dismissal, was prosecuting, no statement that he was unaware. He dies in 2012.
Yes.
The lawyer, Lord, in the 2008 till 2012 is the same. I have produced the wakalats also, Lord.
Same and thing agutte.
Lord,
The lawyer was not the same.
no, I'm showing you, Lordship. That's why I produced the wakalat as well. Your Lordship will see 8729 of 2004 at page 3. Lord, your Lordship will see at the bottom, T. Venkatram. He gives an NOC to Ramesh Kulkarni on 23/8/2012. I obtained certified copy. So, Lord, in the 2004 suit, in the 2008 suit, and in the 2006 suit, till 2012, it was Venkatram. Whom Venkatram obtained NOC, I have produced that wakalat also, Lord. Your Lordship will see on page 4.
So this is in the at page number 4. It is some Shantaram.
Yes, ma'am. That's, if your Lordship just turn the previous page. Page 3, Lord.
Venkatram.
Venkatram.
Yes.
He gives NOC on 2012.
Yes.
Now, whom Venkatram gets NOC from is produced on the next page. Shantaram.
This is 98-97.
In 98-97, all connected suits, Lord. He is on record in 2007, Shantaram. So from Shantaram, it goes to Venkatram. Your Lordship will turn to page 6, Lord. Page 6. Shantaram gives wakalat to Venkatram in 1/6/2007.
No, this is in which suit?
2006 suit.
Yes.
Lord, if your Lordship come to page 6, I've shown the transfer of wakalat from Shantaram to Venkatram and the date of transfer. 1/6/2007. Page 6. This Venkatram gets NOC on 1/6/2007 from Shantaram. He continues prosecuting all the suits on behalf of the plaintiff till 2012, when he hands over the reins to one Ramesh P. Kulkarni.
Yes.
So between 2007 and 2012, all the 3 suits were actively being prosecuted.
Now, what is there to show that this, which is the suit? 8399
3599.
3599.
Avare produce ಮಾಡಿದ್ರು your Lordship.
3599. No, this was also handled by this Shantaram ಅಂತ ಇಲ್ಲಿದೆ.
In the judgment, I believe not.
Where is it mentioned? 3599 is.
Judgmental bardide in the impugned order. No?
T. Venkatram is one who was pursuing it.
Yes, in the judgment impugned order in the RFA.
2008 ಅಲ್ಲಿ.
Yes, RFA 3599 in the main petition that they have filed.
After that, nobody has entered appearance in 3599.
3599 got dismissed.
is Venkatram.
Right.
Annexure A,
No,
page
it is not
25.
as if 3599 was also handled by Shantaram. It was handled by Venkatram. Correct.
Yes.
So therefore, Shantaram could not know.
But Venkatram was on record, my Lord.
Correct. Venkatram was record. He gave the NOC for Shantaram in respect of other suits.
No, it's the opposite.
You know.
Shantaram gives NOC to Venkatram. Lord, Right. What happens? It's not as if different lawyers are conducting different suits.
All right, Mr. Let the bill decide the appeal on merits. Barkul.
Not then your lordship will only record my submission.
I'll record
I
whatever.
have 3 submissions to make. With 2 judgments to give across. One lot in the affidavit in which they have filed, there is no statement that the husband, who happens to be an attorney holder, was not aware of the pendency of the suit at all. So the husband is aware of the pendency of suit. He died only in 2012.
Yes.
4 years, there is no explanation at all. Second, the Kusuma Kumari, who claims, and as it was argued now by my learned senior, that she was not aware at all of the pending case and that she's a housewife sitting in Hyderabad, she has filed an affidavit in which she is aware 6 days prior to the dismissal of the suit, what was the stage of the suit and she had to obtain documents from that suit to produce in the connected suit. And the third note, this is not a case where the husband was running the suit, he dies, and the wife, who is a non-party to the suit, is unaware of what has happened. It's a case where there was a power of attorney who was conducting the suit on behalf of the plaintiff.
Yes.
Now, Lord, for 229, if your lordship were to see 229 of the Contract Act, it discusses the consequence of notice given to the agent.
Yes.
So what happens on knowledge to the principal? 229 holds with 2 judgments that I have now.
We're not going to 229. We're not deciding the agency, the principal.
No.
It's only a probability whether the wife knew. Wife knew about the death, about the pendency of the case.
Yes.
More particularly when the husband was pursuing the cases. That is all.
No, it's not a husband. That's the slight nuance that I'm trying to put.
Power of attorney.
Because it makes a difference. If it's a power of attorney,
That is a legal argument, Mr. Not a probable argument. It's a legal argument, yes. When it
order
comes,
3 Rule 5 principle as well. If your lordship's orders notice to be accepted by a lawyer, it's deemed notice to the
yes,
party as well.
yes.
So even on order 3 Rule 5, the lawyer who was present in respect of all 3 suits, this is the 4th submission, Lord, between 2007 and 2012, when the suit gets dismissed in 2008, the lawyer is one Venkatram, he's prosecuting. Notice to him also is deemed to be notice. So
Barkul, I will consider that. Barkul. IA 1 of 23 is filed for condemnation of delay of 4 to 45 days in filing the appeal. It is stated in the affidavit accompanying the application that the appellant is the owner of the suit property. She having purchased it in terms of a sale deed dated 24/11/1994. Full stop. She, through her husband, had filed OS number 3599/2008. She through her husband, who was her power of attorney, had filed OS number 3599 of 2008 in respect of the suit property for the relief of rectification of the sale deed by incorporating survey number 17/2A instead of survey number 3/3B in the sale deed dated 24/11/1994. She contends that in the said suit, the defendants were placed ex parte, and her husband, being her power of attorney, had adduced evidence and had marked documents. The trial court, after considering the oral and documentary evidence, dismissed the suit with a judgment and decree dated 18/6/2009. She contends that she is a housewife and residing at Hyderabad, and she did not have any knowledge and the knowledge about the court procedure and also the laws governing the suit property. She claimed that in the year 2008, she was also suffering from minor health ailments, and therefore she had appointed her husband as her power of attorney to pursue the suits on her behalf. She claimed that her husband was diagnosed with kidney-related ailments during the year 2008, and his condition deteriorated from August 2008 and was undergoing medical treatment at Care Hospital, Hyderabad, and Nizam Institute of Medical Sciences, Hyderabad. Later, he underwent dialysis on a day-to-day basis and was again admitted at the aforesaid hospitals for treatment. Full stop. She contends that her husband died due to the ailment suffered. Died on 27/11/2012 due to the ailment suffered. She contends that it was her husband who was looking after the suit and she was not aware of the dismissal of the suit. Full stop. Likewise, she contends that her two sons also had no knowledge about the dismissal of the suit before the trial court. Full stop. She contends that she had filed a suit in OS number 5156 of 2021 before the City Civil Court, Bangalore, for perpetual injunction to restrain the defendants from interfering with her possession of the suit property. On 18/10/2022, the defendant in the suit filed a statement of objections to the interlocutory application, and along with the objections, he had enclosed, along with he had mentioned in the objections to the interlocutory application that a suit filed in OS number 3599 of 2008 was dismissed. She therefore contends that she came to know about the dismissal of OS number 3599 of 2008 only after perusing the objections to the application filed for interim reliefs in OS number 5156 of 2021. Full stop. This application is opposed by the respondents who have filed an elaborate statement of objections contending whatever mentioned in the objections about the delay, grounds for delay. You mentioned on the merits about the case.
Already pre-filed. I'm on NOC.
Whatever it is.
Yes.
In the objections, whatever we mentioned
I
about the
mentioned
delay.
from para 5 to 6. No, your lordship.
Unnecessary. You have mentioned about the merits of the case.
Not para 6, 7, your lordship.
What 6, 7?
Is already aware. Not D. If your lordship will only.
No, where have we mentioned? Up to paragraph number 11, it is all about your case, about plaintiff not having any title in respect of survey number 17/2A. What is this?
Para 12 and 13. No?
12 and 13 also, please read.
13, it is further submitted, no sufficient cause has been shown. And on the other hand, the appellant has misled this.
No, 13 it says
no
it
knowledge
is.
of the conclusion. Question is whether she had knowledge. It is false that her sons have no knowledge because her son is a power of attorney who is prosecuting her case.
Yes, Madam, I filed objections contending that the reasons assigned by the appellant for condoning the delay are false, and there's no iota of truth in it, and that she has slept over her rights. Full stop. It is also contended that the appellant has made a deliberate false statement as she was following up the other litigations in respect of suit property bearing site number 52 of Omkar layout situated in survey number 17/2F Ganakal village. Full stop. It is contended that the son of the appellant is her power of attorney who is presently prosecuting the case on her behalf, and that he had adduced evidence as PW1 in OS number 8729 of 2004 and 9897 of 2006, and therefore is aware of the litigation. Full stop. Next, but the learned senior counsel for the appellant submitted that the appellant is a housewife and she was suffering from various ailments, and therefore she had appointed her husband as a power of attorney. She contends that it was her husband who was pursuing the various suits before various courts in respect of the suit property from time to time, and that the appellant had no knowledge about the particulars of the suit filed and the results in those suits. Full stop. She contends that the appellant came to know about the dismissal of OS number 3599 of 2008 only when the defendant in OS number 5156 of 2021 filed an objections to the interlocutory application where he had referred to the dismissal of OS number 3599 of 2008 was mentioned. She therefore contends that the suit filed in OS number 3599 of 2008 is for a substantial relief, namely to direct the defendants in the suit to effect rectification to the sale deed dated 29/11/1994. 29/11/1994. She therefore contends that the delay caused was due to a reason beyond the control of the appellant, and hence the court may consider the reasons mentioned sympathetically, and also having regard to the fact that the dismissal of the suit would ultimately deprive the appellant of her proprietary rights in the suit property. Full stop. Per contra, the learned counsel for the respondents submitted that the appellant had knowledge about the filing of OS number 3599 of 2008, and the same is evident from an affidavit filed by her in OS number in the said suit on
6/6/2009.
On 6/6/2009. On 6/6/2009, where 6/6/2009. 6/6/2009, where she has stated, about the particulars of the suit filed in OS number 3599 of 2008, and also the stage at which the suit was when she filed the affidavit. Full stop. He contends that therefore the plaintiff cannot feign ignorance of the disposal of OS number 3599 of 2008 by claiming that she was a housewife and she had no knowledge about the suit as well as the result therein. Full stop. He also contends that the appellant had given a power of attorney to her husband, and therefore the husband was bound to know the result in OS number 3599 of 2008. Consequently, by virtue of section 2(229) of the Contract Act, the knowledge of the disposal of the suit in OS number 3599 of 2008 has to be imputed to the appellant also. Full stop. Thus, he contends that the appellant cannot claim that she had no knowledge about the disposal of OS number 3599 of 2008. What is the other two?
The advocates.
He also contends that the one Mr. T. Venkatram was the advocate who was representing the appellant in all the suits filed in OS number, in all the suits, in the suit filed in OS number 8729 of 2004, 9897 of 2004,
Not 8729, he was not the lawyer. Venkatraman was not the lawyer.
ಇದರಲ್ಲ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ
8729
ಹೌದು
as per our
ಏನ್ ಮಾಡಬಹುದು Mr. Venkatram was a lawyer representing the appellant in OS number 8729 of 2004 till 23/8/2012. Full stop. Mr. M.T. Shantaram was the advocate representing the appellant in OS number 9897 of 2006.
Yes, 2006.
2006.
He hands over Vakal.
Who gave an objection, and Mr. T. Venkatram entered appearance on 1/6/2007.
Yes.
And thereafter, Mr. T. Venkatram gave no objection on 8/10/2012, and Mr. Ramesh P. Kulkarni entered appearance. Full stop. He contends that Mr. Ramesh P. Kulkarni represented the appellant in all the three suits from
Venkatram.
Ramesh Kulkarni also
Venkatram comes much
from 2012.
correct. I am talking Ramesh Kulkarni.
Yes.
Represented Mr. Ramesh P. Kulkarni represented the appellant in OS number 8729 of 2004 from 23/8/2012. From 8/10/2012. Full stop. He therefore contends that appellant cannot therefore contends the notice to the appellant's lawyer should be deemed to be implied notice
according
to the appellant. Full stop. He therefore contends that the appellant cannot claim that she has no knowledge about the disposal of OS number 3599 of 2008. What is the other fourth one?
That in the affidavit, there is no statement in which she denies that her power of attorney was not aware of the dismissal of the suit between 2008 and 2012.
He also contends that the husband of the appellant, he also contends that the appellant has not mentioned in the affidavit accompanying the application that her husband was also unaware of the disposal of OS number 3599 of 2008. Full stop. Till the year 2023.
2012 when he died.
Till the year also
2012. He died in November 2012.
Till the year 2012
From
when he
2009
died.
to 12.
Full stop. He therefore prays that the application filed by the, you have any judgments to rely upon?
Yes.
He has relied upon the following judgments, copy to contend that the cause shown for the delay is not satisfactory, and that the appellant is bound to explain each and every day's delay in filing the appeal. Full stop. I will consider submissions made by the learned counsel for the appellant, learned senior counsel for the appellant, and the learned counsel for the respondents. Next para. The suit in OS number 3599 of 2008 was filed for a substantive relief, namely for a declaration that, namely for a rectification of the sale deed dated
21/11/94.
21/11/1994. Full stop. The fact that the appellant is a resident of Hyderabad is not in dispute. It is also not in dispute that the appellant had appointed her husband as a power of attorney to pursue litigations in respect of the property in question. The said power of attorney was executed on, what is the date of the power of attorney? Was executed on dash.
I'll just.
Full stop. The earliest of the suits, namely OS number 8729 of 2004 and OS number 98 of 2006, were filed by the husband of the appellant as her power of attorney. Full stop. The suit in OS number 3599 of 2008 was also filed by the husband of the appellant as a power of attorney of the appellant. Full stop. The medical documents placed on record give an indication that the husband of the appellant fell sick due to kidney related ailments in the year 2008. Full stop. It is no doubt true that the husband of the appellant had adduced evidence in OS number 3599 of 2008 as PW1 and had marked a few documents on, when was that?
6/6/2009.
On so and so. Give the two dates.
Please.
Full stop. Between the year 2008 till he died on 27/11/2012. 27/11/2012. The suit in OS number 87 to 29 of 2004 and 98/97 of 2006 were not disposed but were pending. However, since the defendants in OS number 3599 of 2008 were placed ex parte and the husband of the appellant had adduced evidence, the trial court proceeded to dispose of the said suit. Full stop. With a judgment and decree dated
18/6/2009.
18/6/2009.
Please.
Full stop. 18/6/2009. Full stop. It appears that the husband of the appellant died on 27/11/2012 and he had not taken any steps 2012. And this suit was pursued by an advocate named Mr.
T. Venkatram.
T. Venkatram. Mr. T. Venkatram. Ideally, Mr. T. Venkatram must have informed the advocate who entered appearance on behalf of the appellant on 8/10/2012 in OS number 98/97 of 2006 and OS number 87/2029 of 2004 about the dismissal of OS number 3599 of 2008. Full stop. When the appellant was pursuing the other two suits, even after the death of her husband, there is no reason why the appellant would not have taken steps to challenge the judgment and decree passed in OS number 3599 of 2008, particularly when it affected her right, title, and interest in the suit property, and the outcome of which had a bearing on OS number 8729 of 2004 and 9897 of 2006. Full stop. Therefore, the contention of the appellant that she had no knowledge about the disposal of OS number 3599 of 2008, merits acceptance. Full stop. It is not the case of the respondents that the appellant had quoted the decree passed in OS number 3599 of 2008 in any other proceedings before any other court or quasi-judicial forum. Full stop. It is for the first time that a reference was made to the dismissal of OS number 3599 of 2008 in OS number 5156 of 2021, which was a suit filed by the appellant. Full stop. Therefore, the contention of the learned senior counsel for the appellant that the appellant did not have knowledge about the dismissal of OS number 3599 of 2008, merits acceptance. Consequently, IA so and so filed by the appellant is allowed and the delay of so and so days in filing this appeal is condoned. Admit call for records. Filing of paper books is dispensed. List for final hearing. Yes.
Right. Still number 20, Manjunath K.
Manjunath K.
If appeal, there is a delay of 278 days in a notice.
Real reason no notice hogilla.
In a notice.
Issue notice on IA 1 of 24 as well as in the main appeal. So far as the response 1 to 6 are concerned.
Yes.
Others have entered caveat.
Caveat illa, notice not sir.
Notice ಆಡಕ್ಕೆ ಮುಂಚೆನೇ ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ. And also it may be dispensed for this respondent number 5 minutes because he has
Memo
placed
code.
it.
Memo code. Please placed ex parte. If I place ex parte. Memo code.
Please, madam.
Issue emergent notice on IA 1 of 24 as well as in the main appeal to the respondents 1 to 4, 6 to 13. Notice to respondent number 5 is dispensed as he was placed ex parte before the trial court. Yes.
Serial number 21, Chaitanya SG. 21.
My lord, I'm appearing for the appellants, my lord.
Well, ಕೇವಟ್ ಒಬ್ಬರೇ issue emergent notice to respondent number 1 on IA 1 of 25 as well as in the main appeal.
Serial number 22, Rakshita DJ.
Issue notice on IA 1 of 25 as well as in the main appeal.
Serial number 23, V. Vishwanath Shetty.
Same order.
Serial number 24.
Same order.
Shivakumar. Serial number 25.
Same order.
List number 2. Serial number 1 for orders matter. First time orders matter, serial number 1, Srikanth NV. List number 2 matters.
Srikanth NV Srikanth. A memo for retirement is filed by the notice ಕೊಟ್ಟಿದ್ದಾರಾ? A memo for retirement is filed by the petitioner. However, there is no notice of retirement issued to the petitioner. Hence, a memo for retirement is rejected. There is no representation for the appellant, petitioner. List on Saturday.
On complaints. On complaints.
Saturday, by which time office objection shall be complied. Yes.
List number 1 for admission matters. Serial number 26, Kariyappa NA.
NA Kariyappa.
Serial number 26.
ಯಾರು ಬಂದಿದಾರ ಇದಕ್ಕೆ?
They are settling the matter.
ಬಂದಿಲ್ಲ ಅವರು? Please wait, let us see. You can come at 1:30. Come at 1:30. Yes, Mr. Kariyappa. What is this? Settlement ಮಾಡ್ಕೋತೀವಿ ಅಂತಿದ್ರಾ? ಏನಂತ? The petitioner petitioner respondent has amicably settled the matter and request to list this matter. Where is Mr. Kariyappa? N.A. Kariyappa. Pass over.
Serial number 27, Joseph Anthony.
For the petitioner, your lordship.
Settled.
Settled, yes, your lordship.
Only the petitioners challenged the criminal proceedings launched. Petitioners have challenged the criminal proceedings launched against them by the respondent number 1 in CC number so and so on the file of so and so for offences punishable under so and so. When this petition is listed for admission, comma, a joint memo is filed by the petition number 2. What about petition number 1?
Petition number 1 is dead, man.
Petition number 2 and the petition respondent number 2, the terms of which reads as follows. Copy Mahbudi. The offences alleged against the petitioner number 2 are under section 506, 34, 504, 447, 448 of IPC, which are neither punishable with death or life imprisonment. Therefore, in view of the judgment of the Apex Court in the case of Gyan Singh versus State of Punjab, the petitioner number 2 and the respondent number 2 are permitted to settle the disputes amicably. In view of the joint memo filed in terms of which, the respondent number 2 and the petitioner number 2 have settled the dispute, the continuation of the criminal prosecution of the petition number 2 is unwarranted. Hence, the petition is allowed and the prosecution launched against the petition number 2 is quashed.
It's almost
in CC number so and so on the file of so and so is quashed.
The accused number 1 in the FIR is an entity. They have not approached this honorable court. The entire FIR as well may kindly be quashed.
Accused number 1 yaru?
Akila Films Private Limited anta. Other director was the petitioner number 1 who is dead. So the case, there is no point in continuing the case.
Who is the accused number 1?
Accused number 1 is an entity. Petition, Akila Films Private Limited, of which petitioner number 1, who is accused number 2, was a director. The case against accused number 2 having been now quashed.
You file a memo before the trial court?
Please.
Quashed insofar as the petitioners are concerned.
Please.
It is open for the respondent number 2 to file an appropriate memo before the trial court, bringing to its notice the order passed by this court and the steps to be, and the trial court shall decide the steps to be taken as regards the accused number 1.
Please.
Seal number 26, man. Settlement, man.
Please wait, Mr.
Serial number 28.
Ramesh T. From where did you learn this bad habit? No, where did you learn this bad habit? When 27 is going on, how can you ask the court to take a 56? This is bad habits, bad manners. Huh? Don't do it again.
Filing an application. Letter.
For?
One of the letter was not placed.
Letter? Yes.
This is, my lord, last day.
What is the suit for?
Declaration declaring my husband dead, my lord.
Last date, your lordships had heard it. Lord, he
Yeah,
was
date
saying,
of- One letter was missed. So in
What
view-
letter?
It's given by the police saying that it's not been traceable, my lord. Endorsement given at page 9, my lord.
For 1-page letter, you filed 8-page application. Correct? 1-page letter, again, 8-page application.
Two
Can't you be crisp,
pages,
Mr.?
2-page spacing.
2-page, in the 4 space.
Two-line spaces are good.
You should have given 4 spaces, 4-line space. Idella beka. I have 2 daughters, namely Monica. Idella beka. All that you have to say is that my husband, we have complaint put to the police have given an endorsement. You could not produce it for ABCD reason. Adi helad bittu ನೀವು ಬ್ಯಾಡವಾದ ಹೇಳ್ಕೊಂಡು ಕೂತಿದ್ದಿ. ರೇಡಿಯೋಲ್ ಕೊಟ್ಟೆ, ಟಿವಿಲ್ ಕೊಟ್ಟೆ. Be crisp, sir. Yes, can this be taken as additional evidence? Any objection?
already one more application is pending.
ಯಾವ್ದು?
2 application ಹಾಕಿದ್ದಾರೆ. ಇದು 2ನೇ application ಇದು.
ಇನ್ನ ಏನು ಹಾಕ್ತೀರಾ?
ಇಲ್ಲ.
ಇಷ್ಟೇನಾ?
Can be considered along with the main also. No problem.
ಆಯ್ತು, ಇನ್ನೆಂತ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಗೆಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ? Which
I
is the
have
other
few
application?
submissions to be. Lord, since this has got some serious consequences, seeking a declaratory relief that so and so is civilly dead ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Documents produced, my lord, may kindly be seen now.
So what is this order 41/27? What decree you want to produce? What additional documents you want to produce?
The trial court has observed that I'm working in a bank at Delhi. They have not produced any documents. One.
ಎಲ್ಲ ಹಾಕಿದ್ರೆ ಇಲ್ಲಿ?
That
Where are the documents? You only filed an IA. Where are the documents?
the documents are along with the IA, my lord.
ಕೊಡಿ ತೋರ್ಸಿ. ಅದನ್ನ ತೋರ್ಸಿ. Yeah.
But one of the observations is that the paper publication and all.
How many applications have you filed, Mr.?
Not only one application.
No, there's one more application. What
No,
is
that
that?
was for stay, but I withdrawn that application.
Order 41 rule 27, you filed one more application.
Only one application has been filed. One letter on 9/6/2015, they have said that they have done paper publication, Durvani, radio and other things they have done. Other things are that I'm an employee of bank, but the court has said that you have not produced any documents, so I've produced all those records. That I was just.
Your husband was an employee of a bank.
Yes, employee of Vijaya Bank. I've taken a loan. He has taken a loan in Vijaya Bank and deposited all the original documents there. When we closed the loan, they said they will not give the documents until unless we produce this death certificate. There was some 50,000 misappropriation due to which she did not give these documents and subsequently we filed to show that he was an employee of Vijaya Bank.
So he was removed from service.
He was terminated.
He has participated in the proceedings also.
Correct. What was the last date?
Last date, my lord, 6/6/2011 is the date of charge sheet. Afterwards, my lord, he has participated. Kindly turn to
What is the
page
date
60.
What is the date of the disciplinary?
Date of missing is 8/3.
The date of the order passed by disciplinary authority.
My lord, that is on 14/9/2012.
When did he go missing?
My lord, 8/3/2011.
The last communication.
Page 60 may kindly be seen. Idರಲ್ಲಿ he has participated ಅಂತ ಬರೀತಾರೆ 61 ಅಲ್ಲಿ.
But
last letter is on second.
However, the CSE had failed to collect a copy of the said inquiry findings dated 19/1/2012 from the then disciplinary authority. So he is not even given a reply to the second show cause notice.
No, the last notice he has replied is on 2/2/2011, which is at page 53. After that, he has not given any reply.
When was the suit filed? 2019.
2019, madam.
Then I think this will consider this.
But till date is not traceable, my lord.
You can't have any objection against this.
More than 15 years.
But cool. IA 1 of 23 and IA orders on IA 1 of 23 and IA 1 of, you not filed it in the registry.
No, my lord. She was traveling. She just came this morning. I could take the signature.
Mr. Date is given. Why you kept quiet? It is stamp entry madasari. And IA 1 of 26. Stamp entry madasitara keli. These two applications are filed by the appellant under Order 41 Rule 27 of CPC to furnish additional documentary evidence. It is stated in the affidavit accompanying the application that the appellant had filed OS number 5314 of 2019 for a declaration that her husband is dead, is deemed to be dead since his whereabouts are not known for more than 7 years, and for a direction to the respondents to register his death and to issue a death certificate. Full stop. It is contended that the husband of the appellant left the house on 8th March 2011 and did not return back. The appellant made inquiries with her friends, relatives, but did not know anything about his whereabouts. Her husband was also not attending work at Vijaya Bank where he was employed as a clerk. Therefore, the appellant had no other option than to lodge a complaint with the jurisdictional police on 9/3/2011. Full stop. It is contended that the trial court, while deciding the suit, had observed that the appellant had failed to
Page 7, my lord.
appellant had not produced any document to show the status of the complaint lodged before the police. It also observed that the appellant had not given publication in a newspaper to trace her husband and had also not demonstrated the steps taken by her to trace her husband. Full stop. It also observed that the appellant did not produce any documents to indicate that her husband was an employee in Vijaya Bank from 7/5/2005, and that there were no documents produced by the appellant to show that the appellant, her husband, along with their children, were living at Vidyaranepura, Bengaluru. The appellant therefore contends that the appellant was unaware that these documents are necessary for the purpose of considering the suit, and hence the appellant has filed this application to place on record additional documentary evidence. Full stop. The learned counsel for the appellants reiterated the above submissions and submitted that the documents now placed on record would indicate the appellant's husband was working in Vijaya Bank until he was removed from service, Vijaya Bank, and that he was suspended from service on Yavaga. When was he suspended? On
Removal orders have been passed.
16/12/2010, and that he did not attend to duties thereafter. He submits that the husband of the appellant was thereafter served with a charge sheet on 6/6/2011. Were you served or not?
It was served. There is a finding to that effect. 61, last 3 lines. 6/6. However, though the CSC had received the said charge sheet on 6/6/2011. If this is the case, my lord, 8/3, how is he missing, my lord?
He was issued antiде ಅಷ್ಟೇ.
Allala, last 3 lines. Bottom ಅಲ್ಲಿ.
Page number 61 ಅಲ್ಲ.
61 ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ?
Even
one second. Last 3 lines. However,
no, the paragraph begins with the proprietor.
Alla. Shri T.N. Ramchandra anta paragraph, last paragraph. Page 61 anta ನಂದ್ರಲ್ಲಿ ಇದೆ. Is this the one?
Shri T.N. Ramchandra,
Yes.
That is 62.
If the lordship may see
The last 3 lines. However,
received the charge sheet, did
yes,
also issued to him, he failed to. But illond kade eno ideyalla was issued.
Even on 1/12/2010, he failed to inform the branch head and make good of the misappropriated on page 61 itself.
Thereafter, appellant was served, but thereafter articles of charge was issued on on 6/6/2011, but 6/6/2011, which was followed by an order of the disciplinary authority removing her husband from service. The terminal benefits of the husband of the appellant was released on 12/12/2012. Full stop. He also contends that that the police have issued an endorsement. Issued an endorsement dated
17th May 2018.
17th May.
17/5/2018, stating that the whereabouts of the husband of the appellant is not traced. Full stop. He therefore contends that these documents are necessary in view of the observations made by the trial court, and therefore prays that the same be taken on record and treated as additional documentary evidence. The learned counsel for the respondents, however, contend that the appellant has not mentioned as to why these documents could not be produced before the trial court at the earliest point in time. Next para. The appellant had filed the suit for a declaration that her husband is dead, since his whereabouts are not known. Full stop. Therefore, the appellant has furnished documents to show that she had intimated the police about the missing of her husband, and the police had registered an FIR on that basis. Full stop. In a suit of this nature, the appellant cannot be expected to know what kind of documents are required to be produced. Full stop. Therefore, the appellant is justified in now placing on record documents to overcome the observations made by the trial court. To place on record documents which are commented upon by the trial court in the impugned judgment and decree, so as to demonstrate her bona fides in pursuing the suit, in pursuing this appeal for the relief sought for in the suit. Full stop. Consequently, both these applications are allowed, and the documents sought to be furnished by the appellant are treated as plaintiff's exhibits and are marked as exhibits P. P11 to P11 to how much? How many?
14.
P12, P13, P14, P15, P16, 17, 18, 19, 20, and 21. 21 and 22. It's 22. Can we allow this?
Record let it be remanded back to the trial court.
Remand
Let it be considered, my lord.
Appellate court has got all the powers of a civil court, so therefore we will dispose it. Remand.
Let the trial court take
No. I will decide this. You being a civil lawyer, don't ever speak of remand unnecessarily. Remand is not given for the asking. The plaintiff.
But that, my lord, the additional documents are placed on record. Now that your lordships have marked it also. Additional documents. Let the trial court take it.
You cannot object, mister. You cannot object to these documents.
I am only bringing to your lordships.
The plaintiff in OS number so and so on the file so and so has filed this appeal challenging the judgment and decree dated so and so, by which her suit for a declaration that her husband had died since his whereabouts were not known for 7 years, was dismissed. Next para. The plaintiff filed OS number, the party shall henceforth be referred to as they were arraigned before the trial court. Next para. The suit in OS number 5314 of 2009 was filed for a declaration that the husband of the plaintiff had died. Declaration that her husband. Declaration that the whereabouts of her husband was not known for more than 7 years and therefore is deemed to be dead as provided under section 108 of the Evidence Act, and to issue a death certificate accordingly. Full stop. The plaintiff claimed that her husband had gone out on 8/3/2011 and did not return back. Full stop. Plaintiff inquired his whereabouts with friends, family members, and relatives, but did not know, but could not trace him out. Could not trace him. Later, she realized that her husband was also not attending work at Vijaya Bank, where he was employed as a clerk. She therefore lodged a complaint before the police on 9/3/2011. Full stop. The police had internally published photographs of her husband for circulation in various police stations. Full stop. Plaintiff claimed that she continuously followed up with the jurisdiction police, but the same was of no avail. She then approached the defendants for issuance of a death certificate, but the registrar of births and deaths issued a non-availability certificate as the death was not registered. Full stop. The plaintiff claimed that her husband was employed in Vijaya Bank and had availed 2 loans, and that the said loans were cleared by her. And the plaintiff and the bank had provided a letter dated 2012-2017 certifying that the plaintiff had cleared the loan, but the bank did not return the original documents such as sale deed, Khata certificate, etc. She contends that she is the dependent of her husband, and since his whereabouts are not known, it is necessary to get a death certificate to collect back the original documents which are mortgaged with the bank. Full stop. Therefore, she filed the instant suit for the aforementioned reliefs. The suit was contested by the defendants, who contended that the plaintiff was bound to issue a notice under Section 482 of the KMC Act 1976, and hence the suit was not maintainable. It is also contended that the Joint Director of Statistics, who is the competent authority to issue a death certificate, is also not added as a party in the suit, and hence the suit is not maintainable. Based on the above contentions, the trial court framed the following issues. Copy them up. The plaintiff was examined as PW1 and she marked exhibits P1 to P10. The defendants did not cross-examine PW1 nor did not lead did not lead any evidence. Full stop. Based on the oral and documentary evidence, the trial court passed the impugned judgment and decree dismissing the suit on the ground that
was cross-examined. Cross-examined. That was an error.
There's an error.
Cross-examined.
But subsequent paragraph already there. PW1 in a cross-examination is this.
That PW1 was cross-examined, but the defendants did not lead any evidence. Based on oral and documentary evidence, the trial court passed the impugned judgment and decree dismissing the suit on the premise that the plaintiff had not furnished any document to show the status of the complaint lodged by her with the jurisdiction police. It also held that the plaintiff did not demonstrate before the court that she had taken all necessary measures to trace out her husband, and that her husband was an employee at Vijaya Bank, and that he had raised a loan mortgaging the property documents of a property, and that the said loan was repaid, and that the bank had issued a clearance certificate. Full stop. Was employed with Vijaya Bank and employed with Vijaya Bank. Full stop. Being agreed with the said judgment and decree, the plaintiff is before this court. Next, the Learned Counsel for the plaintiff contends that the documents which are marked as exhibit, which are now marked before this court as exhibit P11, P12 would go to show P12, P13, P14, P15, P16, P17, 18, and 19 go to show 19 and 20 go to show that the husband of the plaintiff was employed as a clerk in Vijaya Bank and that he was suspended from service and thereafter removed from service and his terminal benefits were settled. Full stop. He contends that exhibit P23 is a endorsement issued by the police dated 17/5/2018, which shows that even as on the date of filing the suit, comma, the whereabouts of her husband, even by that date, comma, the whereabouts of the husband of the plaintiff was not found, was not traced. Full stop. He therefore contends that there is ample evidence to show that the husband of the appellant is missing and his whereabouts are not traced for more than 7 years, and by virtue of section 108 of the Evidence Act, comma, he is deemed, the trial court must have declared that her husband is dead. Full stop. Per contra, the learned counsel for the respondent submitted that the plaintiff ought to have filed a suit, ought to have issued a notice under section 482 of the Karnataka Municipal Corporation Act. Failure to do so should result in dismissal of the suit. Next, I consider submissions made by the learned counsel for the plaintiff and the learned counsel for the defendants. Very full stop. A perusal of the no due certificate issued by Vijaya Bank as per exhibit P6 goes to show that the plaintiff had cleared the loan raised by her husband from Vijaya Bank on the security of the documents of title mortgage with the bank. Full stop. There is no serious dispute regarding the relationship of the plaintiff with Mr. T.N. Ramachandra, na?
T.N. Ramachandra.
Yes.
T.N. Ramachandra. Full stop. The plaintiff has claimed that the whereabouts of her husband was not known from
2011.
9/3/2011. Full stop. The plaintiff has marked the complaint lodged before the police and the FIR drawn by the police as per exhibit P3. Exhibit P22, which is now marked before this court, would establish that from the year 2011 till the year 2018, the police were unable to trace the husband of the plaintiff. Full stop. Where is that publication then of the Tala? The plaintiff has also placed on record. Where is that paper published?
Page 47, my lord.
Has also placed on record
9/6/2015.
in a letter addressed by the police Vidyaranyapura police station dated 9/6/2015 to the plaintiff state, wherein it is which indicates that the police had taken out publication in Doordarshan, Akashvani, local newspapers, and also distributed pamphlets about the missing of her husband, and that no information was received till 9/6/2015. These documents clearly indicate that the plaintiff could not trace the whereabouts of her husband for more than 7 years, and therefore the plaintiff was entitled for a declaration that her husband was deemed to be was entitled for a declaration that her husband is dead as provided under section 108 of the Evidence Act 1872. Consequently, the impugned judgment and decree passed by the trial court is set aside and the suit filed by the plaintiff is decreed. The defendants are directed to register the death of the husband of the plaintiff and also issue appropriate death certificate acknowledging the same. acknowledging, but death certificate reflecting the same. Yes. They shall be complied within 3 months from the date of the plaintiff furnishing a copy of this judgment before the appropriate authority. Yes.
Serial number 29, HR Anand Krishnamurthy.
Counsel for respondent number 1 and 3,
Hmm.
having personal inconvenience, kindly.
Again, suit, injunction suit.
For mandatory injunction
Mandatory injunction of what?
of 2/26
For demolition.
for demolition.
Demolition.
Oh.
Demolition of what?
Of a structure, pillars are erected by the defendant illegally on my property.
Admit madam. Admit, call for records. Filing of paper books is
Has not
dispensed.
been proved by the.
Filing of paper books is dispensed for the time being. This for final hearing as per seniority. Yes. Syed Peer Ullah Shah.
30, Syed Pirullah Shah.
Suit is dismissed or decreed?
Decreed, Your Lordship.
Decreed.
Decreed.
Issue emergent notice regarding rule. Rashid Khan.
31,
This is
Rashid
for
Khan.
partial lordship. Partial rejection of the plaintiff lordship. Only one defendant has filed the.
Partial rejection of the plaint.
Plaintiff lordship. Only one defendant has, respondent number 3 filed the rejection, where there are 2 properties, Your Lordship. 2 properties are there.
The suit is for partition filed by the daughters.
Daughters.
And who has filed this application 7 to
Respondent number 3, Your
11?
Lordship. There are 2 purchasers, Your Lordship. Respondent number 3
Purchaser has filed the application.
filed one of the purchasers.
Yeah, what is the date of purchase?
That is before 2004. That is the
So
admitted
therefore, plaint cannot be rejected, mister.
rejection partially, Your Lordship, review of the Supreme Court judgment.
Plaint cannot be rejected partially. Only the suit item can be excluded.
Here is not the case, Your Lordship. Only one respondent has filed.
Take out notice, emergent notice regarding rule. Suresh T.S.
Serial number 32, Suresh T.S. Anant Kumar.
Anant Kumar.
Suit for permanent injunction, my lord.
ಏನಾಗಿದೆ ಸೂಟು?
Decreed in part, my lord.
Decreed in part. What is refused?
My lord.
What is refused?
My lord. Pass for kindly it may pass on. Senior will appear.
It is already 114, mister. You not read the file.
No, my lord, sir. Like senior is set to appear. Like
correct, appa. What prevented you from reading the file?
My lord, sir, like we had sought for like permanent injunction against the comments which has been passed, like restraining the different number 1 is a foundation, my lord, sir.
Take out notice, emergent notice regarding rule.
My lord. My lord, we are thinking for the
My lord, andre?
stay application.
Even if Nandakumar comes, this will be the order.
My lord, I apologize. I am for the petitioner, my lords. My lords, in this matter, my lord.
Madam, I issued emergent notice regarding rule.
Okay. My lord, same can be done, my lord. My lord, I have one request, my lord.
Same
I
can
want
be
to
done, andre?
My lord, I want to file an IA, my lords. There
Do
is
whatever you want. You have not even filed an application.
My lord, I'm filing it, my
You file an application.
I'm
When it
filing
is
it,
posted, we'll consider.
My lord, I have a request, my lord. My lord, I am an auction house, my lord. Against me, defamatory statements have been made, my lord, because of which my reputation has been damaged, my lord.
Yes.
This point was not noted by the trial court, my lord. I can
We'll
showcase.
consider all these things. Yes, next.
My lord, my request is, my lord, for the past 10 years, I've not been able to do an auction, my lord. I am an auction house who only features Indian art, my lord. And now, my lords, with the rise of Indian arts, my lord very well knows that Indian art has now found value, my lord, after the Raja Ravi Varma painting got sold, my lord. My lord, therefore, in such a situation, this has been a point where I want to do
Take
my
out
auction,
notice,
my
madam.
lord.
First you take out notice. You take out notice, or if you
I will-
filed any application, we'll consider it accordingly. You file your application first.
My request is, my lord, I'll file in the notice may be given later, my lord. Let me file my application. Let my application be heard.
What is the
whenever
application for?
The application is simply saying, my lord, that the order of the trial court be stayed until I do the auction, my lord.
What do you mean by that?
My
You are
lord.
virtually, madam, it's
Yes, my
virtually
lord.
allowing the appeal.
My lord, only
They
until
permit
the
you-
auction, my lords. Huh.
If we permit you, it is virtually allowing your appeal. You are asking for the impossible.
My lord, if you look at the case for a minute, my lord, if I may be
Let
allowed.
notice go and come back just
In this-
immediately after vacation.
Serial number 33, Chaitanya SG.
Much obliged.
Appearing for the appellants in this case, my lord. Copy has been served to the opposite counsel, my lord. Copy has been served to the opposite counsel, my lord. One Shailaja for caveator, she has filed a caveat petition.
It is for injunction.
Yes, my lord. Declaration and injunction.
Now what has happened?
My lord, there is a
suit is rejecting.
Yes, my lord. 7 rule 11 will reject agide. The limitation, my lord. The appellant is a society, my lord. The erstwhile president and the secretary, my lord, had had fabricated certain documents and had sold the sites, my lord, illegally without permission, my lord.
There's no representation for the appellant. Sorry, there's no representation for the respondent. The learned counsel for the appellant submits that copies of the appeal memo along with all enclosures are served to the learned counsel for the caveator respondent. It's list on Thursday. You're not filed any application for stay.
My lord, suit has been dismissed, my lord.
Correct, you will stay file ಮಾಡಕ್ಕೇನಾಗಿತ್ತು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ stay ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
Correct, appa. Suit is for injunction. Your suit is dismissed. Why can't you file an application for injunction? Injunction ಏನ ಕೇಳಬಹುದಿತ್ತಲ್ಲ?
Declaration and injunction, ಸ್ವಾಮಿ.
ಆಯ್ತು, injunction ಕೇಳಬಹುದಿತ್ತಲ್ಲ? Did not occur to you?
No, my lord. There was no stay, my lord.
There is no stay, correct, but what prevented you from seeking for some interim reliefs? Yes, next, correct.
Number 34, Chaitanya
Same,
SG.
Same order.
Same order.
Gunashekar.
35, Gunashekar S.
Suit for recovery of money was decreed.
P. Satish.
Challenging that decree, I filed this appeal.
What is the amount?
Amount is 10 lakhs.
10 lakhs.
My case is that I had lent him the money which was repaid by him. The cross-examination he has clearly admitted. In spite of that, the trial court has not considered that aspect and passed a decree against me.
The plaintiff has admitted that he is supposed to owe it to you.
He returned back the money which I had lent him. That he has clearly admitted in his cross-examination.
Yelle. Told.
Para 12, first 2 lines. It is true to suggest that have repaid the money paid by.
No, done post graduation. It is false to suggest that to improve settlement, I had borrowed 20 lakhs from defendant in March 2009. It is false that the defendant has lent 65,500 by cash to me in March. It is true that on 25/4/2019, some of it was lent to me by defendant.
Evidence. His case is that he had lent me money on 31/10/2019, but my case is that was repaid to me because I had lent him the money. That was repaid on 31/10/2019 by way of check. In para 12, first 2 lines, he admits that I have repaid that money on 31/10/2019. And the criminal CC which was filed, I had preferred an appeal. There also it is acquitted. I have not got the judgment copy. Place it before this order.
Whether the trial court has considered that admission in the.
No, my lord, it has not been considered by.
Not referred.
Not even referred.
Are you sure?
Yes, my lord.
Have you gone through the judgment?
My lord.
Have you gone through the judgment?
Yes, my lord. Yes.
Thoroughly.
Yes, my lord. That there is no word with referring to that cross-examination portion.
Madam, please come to para 13.
Plaintiff, in order to substantiate the contents.
Last sentence, exhibit D1 got marked by defined as DW1.
Which is the bank statement account which reflects payments made by him to the plaintiff, made by the defendant to the plaintiff. 3,50,000. No.
Which has been repaid by the plaintiff to the said finance on 20, and plaintiff repaid gold loan of so and so, and totally repaid gold loan of so and so.
The entire fax is not pleaded by the plaintiff.
Plaintiff is repaid bank account, somebody so and so.
They were entirely new facts introduced by the plaintiff.
No, last sentence of the page 10 only. It also reflects the customer name as.
My lord, this were not part of the pleadings at all. Because I had paid the money, that was returned to me. Thereafter.
Yes. See, Satish, there is no representation for the respondent. Admit call for records. In view of the admission by PW1 that he had repaid some of rupees 10 lakhs to the defendant by way of check bracket exhibit P1 comma, it appears P1 comma, the contention of the plaintiff that he had advanced loan of rupees 10 lakhs to the defendant deserves to be tested. Consequently, admit call for records. Filing of paper books is dispensed for the time being. List for final hearing.
My lord, I have sought for stay.
Operation and execution of the impugned judgment and decree is state. Yes.
Serial number 36, V. Anand.
V. Anand.
The order dated. My lord, serial number 36, Lordship. I am for the appellant in this matter, Lordship.
If the order dated 10/4/26, my lords, may be seen, my lords.
10/4?
10/4/26. Interim order dated 10/4/26. One, my lords, I don't see an application for interim relief. The second thing, my sale deed was prior to their sale deed. If my lords may see page number 45.
No, but the MPM sale deed in favor of the appellant is prior in time.
No, my lords. My sale deed is
but why did not mention that on the last sheet then?
I could not appear.
Please.
You did not appear.
I did not appear.
What is your sale deed date?
My lords, if my lords may see page number 45, my lords, that's a discussion. Page number 45 of the impugned judgment, my lords. Last 6 lines, my lords. Page number 45 of the appeal memo. On pursual of records, Exhibit D23 sale deed dated 11/8/2006 executed in favor of defendant number 1 and Exhibit D26 sale deed dated 11/8/2006 executed in favor of defendant number 3 are prior to Exhibit P1 sale deed executed in favor of plaintiff dated 26/8/2000.
Yes, Mr. Is this a fact?
My lord, kindly, because Lordship, senior is not well today. Kindly have it on next
Senior
week.
is not well alive. He will become unwell after he hears this order that I am going to pass now.
Submission.
Even if he will become unwell now. How did you make this false submission on the last date?
Lordship, my sale deed dated 16/8, Lordship. The thing is identification of properties,
Mr.
Lordship, because
on the last date you said that the sale deed in favor of the appellant is prior in time than the sale deed executed in favor of the respondent.
Please, Lordship.
Now, the judgment at paragraph page number 34 shows the sale deed in favor of the defendant number 1 was 11/8/2006 and the sale deed in favor of the plaintiff was 26/8/2019. So plaintiff sale deed cannot be.
16/8 ಅಲ್ಲಿ ಅವ್ರಿಗೂ ಆಗಿದೆ 16/8 ಅಲ್ಲಿ ನಮಗೂ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸರ್ವೆ ನಂಬರ್ ಡಿಫ್ರೆಂಟ್. ನಮ್ಮ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ನಮಗಾಗಿರೋದು ಸೈಟ್ ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ.
No, I am not on that. I am not on merits of the case. I am not on the merits of the case. On the last date, you took an interim order saying that your sale is prior in time than the sale deed of the respondents.
Please,
now the respondents counsel says that your sale deed is in 26/8/2019. Their sale deed is 11/8/2006. So how much cost will you pay for making a wrong submission?
No, Lordship. Senior will come and argue, Lordship. Because
you do whatever you want to bring a senior counsel. Today it has to be resolved. This interim order will have to be reconsidered, and cost will have to be decided. Pass over.
They have not filed an application for interim.
Court can grant interim order, no? Yes, next. Maregoda.
37 H. Maregoda.
Counsel for appellant, Your Honor. It's a suit for permanent injunction, Your Honor.
Dismissed.
Decreed, Your Honor.
Decreed.
Yes.
No, emergent notice regarding rule.
When I seek for a stay, Your Honor.
Please serve it and come back.
Case number 38. Samarth Prakash.
For the plaintiff's appeal, my lord, it's a suit for injunction which came to be dismissed, my lord. The
No,
defendant,
emergent notice regarding rule.
my lord, stay may be granted. So vacant site, my lord. My lord, I had the benefit of an interim order, my lords.
Suit is dismissed. How can I grant injunction?
Because I had the benefit of an interim order, my lord.
Illide torsi kodi illide. What is the suit property?
It's a vacant site, my lords. My vacant site. I had purchased it priorly. Subsequently,
till the next
defendant
date of
discussed.
hearing, till the next date of hearing, in order to maintain status quo of the suit property, neither the appellant nor the respondent shall change the nature of the suit property, nor shall they alienate, encumber, or transfer or part with possession of the suit property in any manner whatsoever.
Yes, much of it.
39, serial number 39, Venkatesh Prasad.
Yes, appearing for recovery suit, my lord. Amount is 6,32,000.
Decreed.
Decreed.
Yes, kattira.
50%. 1 lakh. 1 lakh. Car loan, my lord. It's a car loan.
So what?
At the time of
Car ತಗೊಂಡ ಮೇಲೆ ಇದೆಲ್ಲ ಏನು ಮಾಡಿ?
Pandemic ಅಲ್ಲಿ ಕಾರ್ ಓಡ್ಸಕ್ ಆಗ್ಲಿಲ್ಲ.
ಆಯ್ತು, ಇವಾಗ ಓಡಿಸ್ತಿದ್ರಲ್ಲ.
ಸ್ವಲ್ಪ
1
lakh.
Sir, suit is filed in 2021. We are in 26. 5 ವರ್ಷ ಇದೆ. 5 ವರ್ಷದಲ್ಲಿ you are not taken steps.
Settlement ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ.
50%.
ಅಲ್ಲ.
Emergent notice regarding rule, interim stay of the impugned judgment and decree, subject to the appellant depositing 50% of this
2 lakhs
decree amount
2 lakhs
before the trial court within a period of
2 months, my lord.
8 weeks. Yes.
2 lakhs, my lord. 2 lakhs.
Serial number 40, yes, Vidya.
Appear for respondents, please, your lordships.
Kindly pass over, senior will.
Pass over for what, madam?
My lord,
Suit is
For bare
decreed.
injunction, it is decreed, please, your lordships.
Decreed.
Yes, please, your lordship.
What is the suit property?
It's a place where there are 3-4 sheds put up in the vacant possession, and it is the ownership of the respondent before your lordships. Sole and absolute owners are the respondents, and the petitioners, the appellants are in the habit of filing the suits upon the suits in respect of all the properties which has been sold by their ancestors. I have clearly established my title, my possession, and interference of the appellates.
my lord, the
Land
suit
is
is for
already
bare
converted.
injunction.
Yes, please, your lordship. Sites have been formed.
My lord, the suit is for bare injunction. There has been a serious dispute with respect to title. My sale deed is of 2006, though the original owner is our family member. Now, my lord, there is one more RFA. May I be permitted to produce a document? I'm serving it to the other side also.
Now, from whom did the plaintiff purchase? From whom did the plaintiff purchase?
Plaintiff purchased with previous vendor, Miss Lata.
Lata. From
Yes.
whom did Lata purchase?
From Ambari Ji.
Huh?
My lord, original owner was Narayana Reddy, my lord.
Narayan
Thereafter
Reddy had sold it to
to
Lata.
Venkata Reddy and then to Ambari.
Huh?
Narayan Reddy sold it to Venkat Reddy. Venkat Reddy sold it to Ambrish. Ambrish sold it to Lata. Lata sold it to the plaintiff before your lordships. There is already suit for injunction that has been restraining
For
this
these
particular.
defendants.
These defendants related to Narayan Reddy, who is a daughter-in-law of said Narayan Reddy, claims have to have got a property by virtue of a gift deed and a sale deed from Narayan Reddy, her own father-in-law and mother-in-law, without even specifying as to how they got the property in their name. And this, there is this particular appellant before your lordship is already suffering a decree of injunction from my vendors. Both Lata and Ambarish have filed a suit for injunction against the said appellate, and she has been restrained from interfering into my peaceful possession.
My lord, small correction,
Now,
not
again-
against the appellant, against my husband, my lord. I am not even made party in that OS.
No. You are claiming from Narayan Reddy.
Yes, my lord.
And Narayan Reddy executed the sale deed to whom?
To Venkata Reddy, my lord, converted and formed the sites.
ಆಯ್ತಮ್ಮ ವೆಂಕಟರೆಡ್ಡಿಯಿಂದ ಎಲ್ಲ ಬಂತು ನಾರಾಯಣ ರೆಡ್ಡಿಗೆ ಬಂತು. ನಾರಾಯಣ
ಸ್ವಾಮಿ
ರೆಡ್ಡಿ
ನನ್ಗೆ ನಾರಾಯಣ್ ರೆಡ್ಡಿಯಿಂದ ಬಂದಿರೋದು.
ಆಯ್ತು. ನಾರಾಯಣ ರೆಡ್ಡಿಯಿಂದ ಲತಾಗೆ ಹೆಂಗೋಯ್ತು?
First to Venkata Reddy, then Ambarish, and then Lata, my lord.
ವೆಂಕಟ ರೆಡ್ಡಿ, ಅಂಬರೀಶ್.
And Lata.
Where is Narayan Reddy here?
ವೆಂಕಟೇಶ್ ರೆಡ್ಡಿ ಅವರ ತಂದೆ ನಾರಾಯಣ ರೆಡ್ಡಿ.
ನಾರಾಯಣ್ ರೆಡ್ಡಿ.
ವೆಂಕಟೇಶ್ ತಂದೆ ನಾರಾಯಣ ರೆಡ್ಡಿ.
ಹೌದು ಸ್ವಾಮಿ.
So she says that Narayan Reddy executed a gift deed.
Sale deed.
Sale deed in favor of
In favor of her daughter-in-law. That is the appellant before your lordship.
Mamta.
Yes,
ma'am.
please.
When was that?
Two 2006.
We'll continue at 2:30.
5/10/2000.
5:10?
2006.
When was the sale by
Your lordship, I have got 3 sale deeds before my vendors who have purchased, and their sale date is much before
When did
2006.
Venkat Reddy sell it to Ambarish?
Lordship, I will submit in the afternoon, please, sir. May I request your
Yeah,
lordship?
2:30.
2:30.
Yes, Sidramaya. Huh? 25ನೇ ತಾರೀಕು ಬರುತ್ತೆ. ನಾಡಿದ್ದು ಬರುತ್ತೆ. ಶನಿವಾರ ಬರುತ್ತೆ.
With your lordships kind.
ಏನಾಯ್ತು?
ಬರ್ತಾ ಇಲ್ಲ.
Your serial number?
8.8 and 8.1. Orders.
ಬರ್ಕೊಳ್ಳಿ. 8 ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 3 and 4. 8.1 ಅಲ್ಲಿ learned counsel has not amended the cost title in respect of deceased R6 as a last chance list on Saturday. After vacation. After vacation. As a last chance, he is permitted to amend the cost title, failing which the order dated 10/4/2026 shall not be given effect to, and the appeal will stand dismissed. List on so and so date ಕೊಡ್ತೀನಿ.
Great.
Madam. ಇಟ್ಕೊಂಡಿದ್ದು.
Madam. Madam. Madam.
Lord's kindly.
Hmm.
Lord's kindly.
Yeah.
Morning, I moved 2 matters, my Lord, for 2:30. One number, my Lord, I gave wrongly. So, I need to bless my mouth.
Hold on. ಆಯ್ತು
ಸರ್ವ್ ಮಾಡ್ತೀನಿ, ರೆಡಿ ಇದೆ, ಇಬ್ಬರಿಗೂ ಸರ್ವ್ ಮಾಡ್ತೀನಿ.
ಕಾಪಿ ಸರ್ವ್
ಕೊಡ್ತೀನಿ, ಜೆರಾಕ್ಸ್ ಮಾಡಿಸಿ.
ಹಾಂ ಆಯ್ತು, ಅಡ್ಮಿಷನ್ ಮುಗಿಸ್ಬಿಡಿಯಾ?
Serial number 40. Yes, Vidya.
My Lord, this is a suit for injunction which they had filed, and it was decreed in that favor. That I have challenged before the Honorable Court, my Lord. Morning, the Honorable
Details
Court.
appeared in the morning.
Yes, my Lord. The dates of my purchasing this particular property is on 5/10/2006, my Lord. My Lord, how did this property come to me is, my Lord, the survey number 123 totally had 3 acres, 1 guntas. It was owned by one Mr. Narayan Reddy. Subsequently, it was sold to Venkata Reddy in the year 23/11/1953. And from then, Venkata Reddy was in possession, my Lord. He converted that particular land and made certain sites. He owned that particular land, my Lord. And Venkata Reddy passed away in the year 2002, my Lord. And subsequent to that, this particular property came to his wife, that is Bhagyamma, and her children. Bhagyamma. Venkata Reddy's wife and the children. So Venkata Reddy is none other than my husband's father. So my mother-in-law and his brothers sold this property to me in the year 2006, my Lord.
Hello. How was it sold? You said Venkat Reddy died in 2002.
Yes, my Lord.
When was it sold to you?
Lord,
2006.
2006. Yes.
Who executed the sale deed?
My Lord, Bhagyamma and others. Bhagyamma and Venkat Reddy's other children. Through
Bhagyamma sold it to you. Yes.
From then, I have been in possession of this particular property, my Lord. But subsequently, the one Miss Leta, that is basically their vendor, the respondent's vendor, they purchased this property on 14/12/2022, my Lord.
Leta?
No, my Lord, the respondent, that is the respondent, Javed Hafsid.
Javed.
Yes, ma'am. They purchased this particular property from one Miss Leta, which was on 14/12/2022.
14/12/22.
22, ma'am.
From whom did Leta purchase?
Lord, Leta purchased this particular property from one Mr. Amrish.
When?
Lord, according to their pleadings, it was in the year 1978.
From whom did Amrish purchase?
It is from Venkata Reddy.
So, how do you get title?
Lord, in this particular case, I have been in possession, my Lord. That Lord, this particular.
Your suit is based on title.
Yes, my Lord.
It is not based on mere possession. It is based on title.
Yes, my Lord.
So therefore, when you don't have title, when the suit property is a vacant site, possession follows title.
Yes, my Lord. But
so you don't have title.
My Lord, in this particular case, the property which came to me was specifically, I have 2 sites, my Lord, site number 1 and site number 2. Both site number 1, it was sold to someone else, is the claim which they also claimed that it was sold by Mr. Venkata Reddy to someone else, my Lord. That was a suit for declaration which they filed. And that particular suit got dismissed, my Lord.
No, we are not concerned with site number 1.
1, my Lord.
We are concerned with site number 2.
My Lord, site number 1 and 2, both were in my possession, my Lord. It was both were in my possession. And specifically.
You please tell us, when Venkat Reddy sold the site to Amrish in 1978, how could you or purchase from Venkat Reddy's wife in 1953? Sorry.
2006, my Lord.
2006.
Lord, this came to Bhagyamma and their children through Pani, my Lord, through Pautika. And subsequently, they have sold it to me, my Lord.
I have a case.
Lord, in this particular case, this particular deed, I've not seen, my Lord. Might be I can check. One short date may be given. I will check this particular
No short
deed.
date, madam. Call for records.
Lord, till then, stay may be granted, my
No
Lord.
stay. Call for records, list down date ಕೊಡಿ ಯಾವತ್ತು ಬೇಕು? Thursday.
Thursday.
Next Thursday?
Yes, ma'am.
Yes, next Thursday.
Acha.
Serial number 41, Sidramaya, VB.
That this appeal is filed by the defendant number 5 and 6. That appellants have purchased the property from father of defendant number 1 to 4 through the sale deed dated 7/2/2019 through two different sale deeds as per exhibit D3 and D15. That on 6/7/2019, the plaintiff has filed a suit for specific performance against defendant number 1 to 4. On 6/7/2019, on 6/7/2019, we have filed two suits against the plaintiff as they have made an efforts to interfere with the possession of the property. On 27/8/2019, plaintiff has filed a suit against respondent defendant number 1 to 4 for specific performance, stating that they have entered into an agreement to purchase on 8/1/2014 as per exhibit P2, and it is an unregistered agreement, my lord, it is a created document. The plaintiff has not examined the witness to the agreement.
Whether defendants deny the execution.
Defendants have admitted they have not colluded, they have not laid evidence, they have colluded with the plaintiff. So defendant 5 and 6, they are not made as party, even though my sale deed reflects in RTC and Kata, in EC, Kata was also changed in our name. In spite of, in the absence of even though it is an unregistered agreement per sale, in the absence of evidence of the witnesses, the trial court has decreed the suit for specific performance, my lord. If the specific performance decree is passed, then they will interfere with the possession. On 13/7/2021, we have come on record by impleading ourselves. We ourselves have laid evidence, my lord. Defendants, other defendants have not laid evidence.
This is a site, is it?
It is a site, ma'am.
What is the measurement?
It's a 40 into 30.
30/40.
Yes. No, it was allotted by the government on 12/1/1972 to
issue emergent notice regarding rule to the respondents. To the respondent number 1. Notice to the other respondents is dispensed. Since the suit for specific performance is decreed by the trial court, while the appellants herein claim to be subsequent purchasers. Subsequent, inge?
now earlier purchaser.
Claim to be purchasers of the very same property. Execution of the impugned judgment and decree may affect the right, title, interest of the appellants. Consequently, till the next date of hearing, the operation and execution of the impugned judgment and decree is stayed. Call for records. This for admission on. This for admission on one date after vacation.
4th June.
4th
place.
Serial number 42, Nagaraj Shetty.
Yeah. I proceed for judgment, don't put. On the last date itself, I told you, I get an impression that you people are trying to avoid. No. Whatever it is. This tomorrow.
Serial number 43, EI Sanmati.
Appeal is filed by the guarantor in the housing loan, my lord. The appellant was a guarantor in a housing loan, my lord. Your lordship, the suit has been decreed against the borrower, builder, and guarantor.
Yes, Amresh,
Judgment copy, your lordship, in view of such the KFC Act deal ಮಾಡಬೇಕಂದ್ರೆ your lordship has said that bank has to proceed against the
ಏನದು? ಏನಾಗುತ್ತೆ? So we have to allow this appeal.
Under section 29 of the SFC Act, they have to proceed against the borrower, not against the. There is no such provision under section 29 to proceed against the guarantor ಅಂತ hold ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, but this is.
But this is under the securitization surprise act ಅಲ್ಲಿ section 13 ಅಲ್ಲೂ ಅಷ್ಟೇ they have to proceed against the only borrower and take possession under section 14. And in this case, there is a tri-party agreement between the builder, bank, and the.
Please come to section 1310 of the Surface Act. What it says, also the section 1310 of 1310.
Other functions, asset.
Where dues of the secured creditor are not fully satisfied with the sale proceeds of the secured assets, the secured creditor may file an application in the form and manner as may be prescribed the debt recovery tribunal having jurisdiction or a competent court as the case may be for recovery of the balance amount from the borrower. ಇಲ್ಲಿ ಗ್ಯಾರಂಟರ್ ಮೇಲೆ ಹೋಗಬಾರದು ಅಂತ ಹೇಳಿದೆ.
Section 13 says, only they have to proceed against the where in subsection 2, where any borrower who is under a liability to a secured creditor under a security agreement makes any default in repayment of secured debt or any installment thereof, and his account in respect of such debt is classified by the secured creditor as non-performing asset, then the secured creditor may require the borrower by notice in writing to discharge in full his liabilities to the secured creditor within 60 days from the date of the notice filing, with the secured creditor shall be entitled to exercise all or any of the rights under this subsection 4.
Borrower ಅಂದ್ರೆ ಏನು ಓದಿ?
Borrower ಬಗ್ಗೆ guarantor ಬಗ್ಗೆ ಇಲ್ಲ.
Borrower, what borrower definition ಓದಿ? ಓದಿ.
Your Lordship, 2F, my Lord. 2F, borrower means any person who or pooled investment vehicle as defined in clause DD of section 2 of Security Contracts Regulation Act 1956 has been granted financial assistance by any bank or financial institution or who has given any guarantee or created any mortgage or pledge as security.
The borrower includes a guarantee.
Your Lordship, in this case, there is a tri-party agreement. The builders.
ಅದನ್ನ ಎಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದೀರಾ?
Your Lordship, it has been marked by the bank itself, my Lord. Your Lordship, bank itself, they have produced it.
Which is that document?
Your Lordship,
tri-party exhibit P7.
P7, my Lord. I'm having a copy of that. There is a defect in the title. The defect in the title, Lord, they have. This builder has to indemnify the bank. In this case, there is a defect, Lord, and the purchase and the owners of the property are also been made party.
Where does it say defect in title?
Your Lordship, clause 8, my Lord. The builder has assured that it has a clear title to the land on which the said property is constructed, and the same can be freely transferred or conveyed or registered, and is not subject to any lien or encumbrance, and they have obtained all requisite sanction for construction and sale of town houses, apartments, flats. The builder has also assured that the construction of the said property is as per the sanctioned plan. The builder shall indemnify the borrower, purchaser, and woodco in this respect. So, Lordship, the suit has been decreed against the builder as well, Lord, borrower and guarantor. They have not challenged the judgment. Only I am the guarantor who is challenging the judgment.
Yes. ಯಾರು ನೀವು ಯಾರಿಗೆ? ನೀವು ಯಾರಿಗೆ?
Bank.
Bank.
Only contesting party.
Correct. See, clause 11 clause 10 ಅಲ್ಲಿ woodco reserves a right to recall the entire loan on demand or on any default made by the borrower cum purchaser, or on the borrower cum purchaser being declared as insolvent or incapable of handling its affairs, or for delays in completion of the project for unreasonable time, which in the opinion of the woodco would affect the repayment or the security of the loan, or for any reason. In case the loan is recalled before the builder has actually handed over possession of the flat to the borrower cum purchaser, the builder shall not hand over the possession of the flat to the borrower and shall refund the entire loan amount along with other dues payable to woodco without obtaining any consent from the borrower, and the borrower thereby authorizes Pudco to recover the outstanding loan amount. See, ಈ ಕಂಡೀಷನ್ಗೆ ಗ್ಯಾರಂಟಿ ಕೊಟ್ಟಿರೋದು. ಇವಾಗ if you don't use this condition or you don't comply with this condition, proceed against the builder, how can you proceed against the guarantor? Adjournment ಬೇಕಾ? Is there any interim order? Learned counsel for the respondent seeks time. Respond Saturday. Shanwara. The matter can be closed at a preliminary hearing itself, admission stage itself.
Monday.
ಎಲ್ಲಿ ಯಾವ ದೇಶಕ್ಕೆ ಹೋಗಿದ್ರು? ಯಾವ ದೇಶ? ಮತ್ತೆ ಬರ್ತಾರೆ ಶನಿವಾರ.
Page number 44, Shashikiran V.
Interim order ಇದೆ extend ಮಾಡ್ಬೇಕಾ? ಸನ್ಮತಿ. Is it till the next date or until further orders? Yes, next.
Appear for the appellant, my lord, original defendant.
Adjournment for what? Yes, please go on. I think interim order extended ಅಂತ ಮಾಡಿ serial number 43. Yes, Mr.
I'm the sole defendant in this case. This is a suit for eviction sought by the plaintiff based on a sale deed from 2014. The facts are the plaintiff and the defendant have been in a relationship since 2012. And due to certain matrimonial and other constraints, he created a nominal sale deed in favor of the plaintiff.
File a suit.
Hello?
You file a suit. Have you filed a suit saying that the sale deed in her favor is nominal?
No, my lord. No suit has
Then
been filed. But eviction proceedings were started in the year 2018. Under this said sale deed, no consideration has been paid and there is no tenancy. There is no agreement to tenancy whatsoever, and the learned trial judge has explicitly made this mention at paragraph 16. If I may make this other submission, my lord, there is no evidence of tenancy. There is no documents that were marked pertaining to tenancy. There is only a nominal sale deed to which there is no issue that has been framed by the learned trial judge. And all of this has been proceeded against me, saying that you have not produced any evidence.
What is exhibit D12? What is D12?
Exhibit D12 is the lease agreement. It has not been admitted nor marked. It is produced by the lease agreement. That is a different lease agreement, my lord.
What is that?
It is not pertaining to the transaction between the parties. This was another bank loan which was availed pertaining to the suit scheduled property. To show that there was an existing loan and this property originally belonged to me. It was just produced for those collateral purposes. But they have not produced any documents to show tenancy. During the course of proceedings, if your lordship may turn to page number.
Now you say that you are in a relationship with the plaintiff.
Please.
You say that the sale deed under which she is claiming is a nominal sale deed.
Please.
You don't establish your relationship. You don't establish it's a nominal sale deed. But yet you are in possession.
The issue was not framed despite pleadings have already been given to that effect. No issue was framed stating that this was a nominal sale deed or consideration has not been paid. My main, if I may, my lordship, my main contention pertaining to the nominal sale deed is that the entirety of the sale consideration has not been paid. There is no vested title in the plaintiff to claim eviction in the first place.
Who conveyed this property to the plaintiff?
I conveyed the property.
You conveyed.
As a nominal sale deed. Because as per my instruction, what was happened, there were matrimonial discord. If I may just give a description of the scheduled property, it's ground plus 3 floors. I used to originally reside in the first floor with my wife and children. Due to matrimonial discord, I started residing in the ground floor with my mother. And given the matrimonial discord in my family, I had a relationship with the original plaintiff. And due to a loss or a threat of losing this said property, I created a nominal sale deed in favor of the plaintiff. And right after the remaining sale consideration had not been
paid. Your wife getting this property, somebody else is getting this property.
Sorry, my lord?
In order to avoid your wife getting this property, you conveyed it to the plaintiff.
It was conveyed to that effect, but matrimonial.
Ultimately, you lost it.
Please. That is why I'm before your lordship seeking some indulgence.
How much time you need to vacate?
It's on 2nd May.
How much time you need to vacate?
Lordship may grant been about 6 months, my lord.
6 months. ಆರು ತಿಂಗಳಲ್ಲಿ ಖಾಲಿ ಮಾಡ್ತಾರಂತೆ. This is a residential property.
Please, my lord. Residential ground plus 3 floors.
You are in occupation of all the 3 floors.
No, my lord. Only one floor, first floor.
Who is in occupation other 2?
Other floors, they've rented it out to her children from her first marriage. But now, as stated by instructions, even in their pleadings, they do not reside in Bangalore as of now. They reside in Tamil Nadu and they've been represented by GPA holder, even during evidence.
Yes. ಯಾವ ಕರ್ಕೊಂಡ್ಬಿಡ್ತೀಯಪ್ಪ? Start date ಇದೆ ನಾಳೆನಾ? Next week ಇಲ್ಲ, ರಜಾ ಬರುತ್ತೆ ನಾಳೆ. Tell your senior that they will vacate the premises with if 6 months time is granted. ಅರ್ಥ ಆಯ್ತಾ? Get instructions by tomorrow. Yes. Password.
List number 1, passed over matter, serial number 26.
26, my lord.
Kariyappa.
Filling a memo, my lord, where the matter has been settled in the matrimonial case.
Serial number
26.
ಯಾವ ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಕರೆದಿದ್ದು?
Password 20.
ಕರಿಯಪ್ಪ. ಎಷ್ಟಾಯ್ತಾ?
Settle ಆಗಿದೆ. The matter I have produced along with the memo, my lord. MC judge.
The criminal petition so and so is filed for so and so, so and so, so and so. In this appeal, in this petition is listed for admission, a memo is filed by the learned counsel for the petitioner, enclosing therewith an order dated 7/3/2026 passed by so and so, second additional senior civil judge and JMFC Kolar in EMC number 42 of 2025. In terms of the said order, the a petition filed under section 13B of the Hindu Marriage Act is allowed. Full stop. ಯಾರು ಬೇರೆ ಯಾರು ಬಂದಿಲ್ವಾ?
ಅಲ್ಲ, ಇವರು ಪೆಟಿಷನರ್ ಕಡೆ ಮೇಡಮ್, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಡೆಯವರು ಅವರು ಅಲ್ಲೇ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. Since the parties have amicably settled the matrimonial dispute, since the respondent number 2 and her husband, is he the accused in here? Yes, my lord, accused, my lord, in the criminal petition number 82/84 of 2021, my lord, is the accused number 1, who is the husband, my lord.
The respondent number 2 and the petitioner in criminal petition 82/84
of 2021.
Her husband, who is the petitioner in criminal petition 82/84 of 2021, have settled their matrimonial dispute.
And in criminal petition 84/11
the continuation of the criminal proceedings against the petitioners is unwarranted. Consequently, both these petitions are allowed, and the impugned prosecution of the petitioners in CC number so and so on the file of so and so is quashed.
Much obliged.
Number 36.
V. Anand.
V. Anand.
V. Anand.
36.
Sir, my lords. V. Anand. V. Anand. There is no representation for the appellant. Full stop. Next para. This court, in terms of an order dated 10/4/2026, directed both the parties to maintain status quo in view of a submission made by the learned counsel for the appellant that the sale deed executed in favor of the appellant was prior in time than the sale deed executed in favor of the respondents. Full stop. The learned counsel for the respondents 1 to 3 now submits that the sale deed by Mysore Paper Mills Employees House Building Cooperative Society was executed on 11/8/2006, while the sale deed in favor of the appellant plaintiff was executed on 26/8/2019. Full stop. Therefore, it is more than evident that the learned counsel for the appellant has misled this court into believing that the sale deed in favor of the appellant was prior in title than the sale deed in favor of the respondents 1 to 3. Therefore, the order dated 10/4/2026 is recalled, and
Recalled. Since the learned counsel for the appellant has misled the court and has committed a professional misconduct, this court considers it appropriate to impose cost of rupees 25,000 payable by the learned counsel for the appellant. Payable to the ಯಾರಿಗೆ ಇದು Advocates Association, High Court Unit, Bangalore. ಯಾವುದು? Harikrishna Pramod. I'll take it some other time, Mr.
Please.
ಇನ್ನೊಂದು ಯಾವ ಡೇಟ್ ಕೊಡಿ. I'll take it on some other date. Maybe on Saturday I'll take it. Saturday. Yes, 46.
Final hearing matter, serial number 46. D. Prabhakar, PM Narayan Swamy, Ramesh Kumar.
So D. Prabhakar.
But I bring for the appellant senior is held up in another.
Which court?
Total 6.
6. What is the serial number?
Serial number 51.
Total 6 ಅಲ್ಲ ಯಾವ್ದು ನಡೀತಿದೆ ನೋಡ್ರಿ. ಮತ್ತೆ ಇಲ್ಲಿ ಬರಕ್ಕೆ ಹೇಳಿ, ಇಲ್ಲಿ ಕೇಸ್ ರೀಚ್ ಆಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ, ಇಲ್ಲೂ ಇರ್ಬೇಕು. ಇಲ್ಲಿ ರೀಚ್ ಆದಾಗ ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಅಂತೀರಾ, ಅಲ್ಲಿ ರೀಚ್ ಆದಾಗ ಇಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಅಂತೀರಾ. ಆಸ್ಕ್ ಹಿಮ್ ಟು ಕಮ್. ಶುರು ಮಾಡಿ. ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ? ಕೊಡಿ.
Please.
What is the suit for?
Suit for bare injunction. The subject property, according to the plaintiff, is east to west 111 feet, north to south 211.5 feet, with certain boundaries.
Suit property is?
Kanishmari number, Kata number 90, east to west 111 feet, north to south 211 feet, consisting of a shed on the entire property.
Let us see what is the claim of the plaintiffs.
Claim of the plaintiff. Page number 6.
Will.
Page number 3, para number.
Arogyappa.
The derivation of title is at para number 4. They claim that they have acquired title to the property on the basis of will dated 7/1/2002. That will has not been produced.
What is your claim?
Your Lordship, McKenzie, we are the owners of certain portion of the property. And in respect of, in order to claim that portion of the property, the present suit has been filed. He is not the owner nor in possession of the property. There is no property as described by the plaintiff at this spot. Twice commissioner has been appointed. Report has been secured. If the at the hands of this honorable court and in earlier round of litigation.
No, what is your claim? What is your claim?
I am the owner of one of the bit of the property which has been claimed by him. May I request this honorable court to take out exhibit P 828.
The first statement ಅಲ್ಲಿ ಏನು ಹೇಳಿದ್ರೆ ಹೇಳಿ. Para 21 of your written statement.
Yes, I will read it. We are owning 90 into 28 feet. Para 21.
Hmm.
In respect of the very property, he is claiming by adducing evidence.
Hmm.
If the court goes to the commissioner report, which has been accepted, there is no property at all as shown in the plain schedule.
Correct. ಏನು RFE ಈ ತರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಾ? You should take out what is the plain government, what is the statement.
Yes, my lord.
You're arguing like a writ petition. Yes, please.
Please, my lord. Para number 21, page number 15, ink page number 15.
Yes.
The defendants have their property with absolute right and title over 4 items under the registered sale deed dated 17/5/1973, executed in the name of defendant number 1 by his vendor, one Hemlata, daughter of Gadi Chelurai Shetty, with clear boundaries and the extent distinctly given there. 4 items of the property bearing number 240, measuring 1 acre, 1 guntas, in survey number 24/10, measuring 9 guntas, Gramtana open space measuring about 90 into 28 feet, and Gramtana open space measuring 141 into 21.5 feet belong to the defendant. Over the plaintiffs have no manner of right, interest, title, any claim at any point of time. The defendants who are the absolute.
So that is your claim.
Yes. In respect of the very property, he has laid the claim. There is no property as shown in the plain schedule.
Please read para 23, para 23.
Yes, my lord. It is further submitted. It is further submitted. The plaintiff by this suit have dishonestly tried to establish the right laying claims over the adjoining Sigebele property under the Gramtana measuring about 45 feet into 73.6 feet, over which they have no right, interest and title at any point of time, inasmuch as they getting the reliefs they have intended to dispose of it for gains and the strength of judicial orders against the defendants. The para number 24. That the plaintiffs have neither got surveyed the suit property nor made any such attempt at any point of time and without specific boundaries, and the extent being fixed with their clear document from the competent authority, the present suit is not maintainable against the defendants for any relief. In the absence of specific pleadings, the plaintiff with sole intention to grab the Sigebele property for illegal gains without manner of right, interest over it, tried to establish their claim title to this suit, claiming right over the suit property against the defendant without any clear boundaries and extent, in as much as the legal rights of the plaintiffs have been violated or aggrieved with the activities of the defendant in any manner. It is further submitted plaintiffs have not shown prima facie case against the defendant in respect to the suit schedule property is concerned, much less established before this court the right interest over the suit property by any declaration. More so, the plaintiffs have no balance of convenience in any way to claim relief against this defendant. Also, they have failed to establish the circumstances of irreparable loss being caused or going to be caused in the event of this court decline to grant the relief or any inconvenience they suffer if this court does not consider their request in respect to the suit property is concerned, as does the whole suit misconceived, not maintainable in the facts and circumstances, liable to be dismissed. It is pertinent to note that plaintiffs are not fair in filing the suit without any cause of action, have not approached the court with clean hands, but suppressed the true material fact, inasmuch with the ulterior and illegal acts brought the suit against the defendant just to harass them and for getting the relief confirmed through the judicial orders over their alleged claims. Such suit by the plaintiff seeking discretionary relief before this court is not tenable in law, and the circumstances of the case liable to be dismissed in toto for the reasons so and so and so. Now the plaintiff has entered the witness box and deposed. His deposition is at page number 34. Page number 34.
Just a moment.
Yes. ಇದೆಯಾ? ನೋಡಪ್ಪ ಚೆಕ್ ಮಾಡಿ. I will straight away come to the cross-examination, which is at
Please
page
wait,
number
please
37.
wait, please wait. Hey, what are these documents? Eastern documents ಹಾಕಿದಾರಲ್ಲ.
The property ನೇ ಇಲ್ಲ spot ಅಲ್ಲಿ.
Let us see the evidence. Could it?
Sketch, commissioner report ಹೋಗ್ಬಿಟ್ರೆ.
Oh, correct, sir. ಒಂದೊಂದ ಹೋಗೋಣ. I am not in a hurry. Why are you in a
Yes.
hurry?
ಅಲ್ಲಿ ಎಲ್ಲ ಓದೋಣ.
Correct, but why are you in a hurry?
ಅದು ತಾವು ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಒಂದ್ಸಲಿ ನೋಡಿದ್ರೆ ಆ ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್ ಇಟ್ಕೊಂಡು ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗೋಗುತ್ತೆ.
Commissioner's report ಅಂತ.
ಪೂರ್ತಿ Commissioner report has been marked as exhibit P28.
This is the Tahsildar.
This was an advocate commissioner. Earlier Tahsildar had gone there.
Advocate commissioner ಹೆಂಗ್ ನೋಡಕ್ಕಾಗುತ್ತೆ?
In the previous round of litigation, when Praveen has been appointed, learned advocate has been appointed as commissioner. ಯಾವ report ತಗೊಂಡ್ರು ಒಂದೇನೆ.
This report is dated 3/3/2015.
Yes. Yes. Report of the court commissioner. This honorable court wide order dated 20th February 2015 has appointed me as the court commissioner to visit the suit scheduled property and identify the same with the assistance of the counsel for the parties, and also to identify item number 1, 2, 3 as shown in the sketch produced by the counsel for the respondent with the assistance of any professional or a surveyor, and submit a report. The respondent in this appeal is the plaintiff and appellant now in the previous round of litigation. On receipt of the court commissioner warrant, I intimated the counsel appearing for both the parties, requesting them to present on 28/2/2015 along with the parties to conducting inspection, spot inspection.
This appeal was filed against what?
Your Lordship may kindly see, in earlier round of litigation, suit came to be decreed.
OS number?
OS number. It's very same OS number.
ಇದೇ ಇದಲ್ಲ?
Yes.
ಅದ್ಮೇಲೆ appeal ಬಂತು.
And the appeal
ಆದ್ಮೇಲೆ?
Appeal came to be allowed. They went in SLP. And the apex court has reached a conclusion. There is a dispute with regard to the identity of the property that requires to be resolved. Therefore, I will send back the matter to the trial court to redo the matter afresh.
Trial court, high court?
The Supreme Court, the High Court, trial court bantu chiriga. The second round of litigation, suit came to be dismissed. It is as against the same the plaintiff is before this court.
No, but RFL finding, how can we now look into it?
Your Lordship, I can say when the matter was pending before this honorable court in the earlier round of litigation, court felt, having filed a suit for one suit in respect of one block, he has furnished a sketch stating these are the 3 blocks belonging to me. And court has put a question, ದಾವಾದಲ್ಲಿ ನೀವು 1 ಬ್ಲಾಕ್ ಹಾಕಿದ್ದೀರಾ, ಇಲ್ಲಿ 3 ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಇಲ್ಲ ಅಲ್ಲಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇರೋದೇ 3 ಅಂತ ಹೇಳಿದ್ರು. A court commissioner was appointed and sent to him to the spot. On going there, he found out there are 3 blocks, which is contrary to the plaint.
Correct, sir. But the RFA 493 of 2009 ಮೇಲೆ SLP ಹೋದ್ರಲ್ವಾ?
SLP ಇಲ್ಲ. Your Lordship, may kindly see first OS number 7290 has been filed.
OS number
7290 of 7280 of 2002 has been filed by the plaintiff appellant. Suit came to be decreed. We being the defendant filed an appeal before this honorable court in RFA number 493 of 2009. Said appeal allowed and suit came to be dismissed. They went in SLP. The SLP, in the SLP, court has remitted the matter back to the trial court to redo the matter with regard to the identity of the property. Upon adducing evidence, court felt there is no property as claimed by the plaintiff at the spot. and the property, subject property is not available at this spot, and the plaintiff is not in possession of the property, therefore I will dismiss this suit. It is as against the dismissal of the suit, the present appeal has been filed.
There is one more RFA, Adhenadu.
Yes, sir.
There is one more RFA.
That's the earlier judgment and decree which has been passed by the learned trial judge is dated 23/2009. 23/2009.
ಅದರ ಮೇಲೆ ಈ RFA ಬಂದಿದ್ದು 493.
OS 7280 of 2002 was dismissed, decreed on
20th of March 2009.
2009. ಅದರ ಮೇಲೆ 493
493 ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಪೀಲ್ ಇದು.
ಆಯ್ತು.
ಈ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಅಪೀಲ್ ಕೇಮ್ ಟು ಬಿ
RFA 994 of 2015 ಏನದು? RFA 994.
RFA ಅಲ್ಲ ಅದು. What they have done, if I am correct.
Exhibit P29.
What they have done, RSA ಅದು.
RFA 994 ಅಂತ ಇದೆ.
ಏನಾಯ್ತು ಅಂದ್ರೆ ಈ RSA RFA ಅಲೋ ಆದ್ಮೇಲೆ RSA ಹಾಕಿದ್ರು. That is the RSA.
But RFA ಅಂತ ಇದೆ.
RSA ಅದು.
Yes.
ಆಮೇಲೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು SLP ಹಾಕಿದ್ರು.
ಇದು RTA ಹಾಕ್ಲಿಲ್ವಲ್ಲ? ರೆಗ್ಯುಲರ್ ಥರ್ಡ್ ಅಪೀಲ್.
ಸೆಕೆಂಡ್ ಅಪೀಲ್. RFA ಮೇಲೆ ಒಂದು RSA ಹಾಕಿದ್ರು.
Yes.
Para number 3 of the commissioner report. I visited the place of inspection on 28/2/2015 at 12:45 p.m. The parties with their respective advocates had also come to the place of inspection. I had taken the assistance of the surveyor for the purpose of taking measurement of the properties mentioned in the warrant and identifying the same. I took measurement of item number 1, 2, 3 and the scheduled property, suit scheduled property with assistance of the surveyor, presence of the parties, their counsel. I completed my work. After conducting spot inspection and taking measurement of the properties in question, in compliance with the orders of this honorable court by following the instruction given by the parties, the property shown in the schedule to the plaintiff invoice number has been described as property bearing number, Khata number, Gramtana number, Mariyanapalya, Dasaralli, Dakle, Krishnarajpura, Hubli, South Taluk, measuring 111 to 211.5 feet with boundaries. The property described in the sale date dated 6/1/1971 is Bangalore South Taluk, Dasaralli, Dakle, Krishnarajpura, Hubli, Mariyanapalya, Khata number 90, bounded on east by northeast, north and south by vacant land of Chikarogyappa and west by Papaya's property and vacant land, and the property situated within measuring about east to west 111 feet, north to south 211 feet. There is a road on the northern boundary. To the eastern boundary is the property that is claimed by the appellant. The measurement of the property as taken after the point being claimed by the appellant is north to south 149.5 feet, and thereafter there is a compound wall and property said to have been constructed by one Harsha. The measurement is east to west 133 feet, and thereafter there is a road measuring 18.5 feet, and thereafter there is a private property said to belong to one Martin. During the taking of the measurement, the counsel for the appellant insisted that the commissioner verify whether the suit property claimed by the respondent is a survey number or a Khata number or a Gramtana number. The counsel for the respondent objected to the same, citing the scope of commissioner report does not permit the same. In the light of the specific direction given by the honorable court, visit the scheduled property and identify the same with the assistance of the counsel for the parties, and also to identify item number 1, 2, 3 as shown in the sketch produced by the counsel for the respondent with reference to the respective sale deeds. Due to non-availability of the official records, I decline to verify the same. I measured item number 1. To the northern boundary is a road and the western boundary is Papaya's house. not and to the south boundary is vacant space, measuring north to south 14 feet and east to west 36 feet, said to be being the Andralappa, and the eastern boundary is house property in all measuring 36 into 42 feet. And after the said vacant space, 14 feet, item number 2 has been shown by the respondent in his sketch. He is located and the same measures north to south 56 feet and east to west 30 feet. After the said measurement of 56 feet, vacant space claimed by James is situated measuring north to south 48 feet, east to west 49 feet. While measuring item number 1 and 2, the counsel for the appellant insisted that the vacant space to the east of item number 2 also be measured. Accordingly, I measured the same. The vacant space to the east of item number 1 is 13 feet east to west and 42 feet north to south. Likewise, the vacant space to the east of item number 2 is 56 feet north to south 19 feet. The said vacant space extend up to the aforesaid extent of 56 feet from where the property of James has claimed by him commences. Therefore, I measure item number 3 as shown in the sketch. To the northern boundary is road and to the southern boundary is the house of Premalata, and thereafter there is a road. To the eastern side of Kata number 126/138 belong to Kanikyaraj, and to the west of the property of Lurdamma and Bilemane Rayappa, measuring 45 feet, north to south 73.5 feet. In between the said properties is item number 3 as shown by the respondent. Insofar as item number 1, 2, 3 are concerned, the schedule in the sale deed dated 4/3/1950 is 4 Ankanas Mangalore Styles House along with passage Bengaluru South Taluk, Dasgadi Dakle Krishnarajpura Hubli, Marianan Palla, Kata number 90, bounded east to west, Papaya South, north to south, north road, south by Andralappa's Hisse number. In same Kata number 90, the backyard with east Andralappa and Aragyappa's Hissa, west by Papaya's land, north by Andralappa's Hissa, and south by Yeshwam Yellashavamma house, property situated therein measures east to west 30 feet, north to south. The space called Ninibele space, situated south of Gramtana and east by Bilemane Rayappa's Hisse, west by Chalurai Swami's land, north by Government Road, and south by Andralappa's house, measures east to west 45 feet, north to south 73.5 feet, with Angadi trees. Therefore, thereafter the appellant identified their claim and the same was measured, and to the northern side there is a road, and to the southern boundary vacant property in survey number 24/9, and to the west claimed by survey number 24/9, east by road measuring 17 feet in width, totally extending up to the house of Papaya north to south, and east to the said road property of Lozamma Bilimade Rayappa.
ಏನು ಅರ್ಥ ಆಗುತ್ತೆ ಇದರಿಂದ? ಏನು ಅರ್ಥ ಆಗಲ್ಲ.
ಏನು ಅರ್ಥ ಆಗಲ್ಲ, ಅಲ್ಲಿ ಪ್ರಾಪರ್ಟಿನೇ ಇಲ್ಲ. 111, 211 ಇಲ್ಲವೇ ಇಲ್ಲ ಪ್ರಾಪರ್ಟಿ.
ರಿಪೋರ್ಟ್ ಓದಿದ್ರಿ, but what did you understand from the commission's?
A sketch has been annexed. Sketch has been annexed.
Yes. Property, he claims in 3 bits. That is where the entire social.
Your Lordship may kindly see, the sketch has been marked as exhibit P28A.
Yes, please.
Item number 1. He says 42 feet into 36 feet. As middle barattadu. This portion middle idu. This is item number 1. Item number 2. Measure 56 into 30 feet. Item number 3. 73 feet into 45 feet. These are all the 3 bits with the different boundaries he identifies at the spot.
ಇಲ್ಲ ಐಟಮ್ ನಂಬರ್ 3 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Item number 3 ಇದು ಮೇಲ್ಗಡೆದು. There is no property as stated by the plaintiff at this spot.
Yes.
These are all the 3 properties claimed by him. plain schedule property ನೇ ಬೇರೆ ಅವ್ರು ತೋರಿಸ್ತಾ ಇರೋದೇ ಬೇರೆ. There is no existence of the plain schedule property at this part. And the class examination of PW1, PW2.
Yes.
Please, Madam. Page number 37. Para number 3.
ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ತೋರಿಸ್ಬೇಕು ಡಿಸ್ಪ್ಯೂಟ್ ಇಷ್ಟಿರೋದು ಇಷ್ಟಕ್ಕೆ ನ್ಯಾರೋ ಡೌನ್ ಆಗಬೇಕು ಅನ್ನೋ ತನಕ ತೋರಿಸೋ ತನಕ
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್
ಮತ್ತೆ ಬಟ್ ಅವ್ರ ಹತ್ರ ಇರ್ಬೇಕಲ್ಲ ಅವ್ರ ಹತ್ರ ಇರ್ಬೇಕಲ್ಲ ಇವತ್ತಿನ ಎರಡು ಕೊಟ್ಬಿಟ್ಟು ಮಾಡೋದು ವಾಸಿ ಅನ್ಸುತ್ತೆ.
I know the contents of the will. 3 items in item number 1 described in the will were purchased by my father in the year 1958 under a sale deed dated 4/3/1958. I have seen the registered sale deed dated 4/3/1958. Now, I know the contents. The properties which were purchased under the said sale deed is 19 were one situated at Sigebele and the other 2 properties in Kata number 90. All 3 items are bearing different numbers with a different dimension. 2 items are situated abutting each other, whereas another item is situated at a different place. I do not know whether the property which is situated at Sigebele was sold to one Hemlata by means of a sale deed dated 9/12/1959. After the filing of the suit, I did not try to verify.
Sigebele ಇದ್ದದ್ದು, you accept the existence of this property.
Yes.
Whether you accept the existence of this Sigebele property.
Sigebele property is our property.
No.
Idu Sigebele property, this is the Sigebele property.
Plaint PW2 says one property was situated at Sigebele.
Sigebele. This is Sigebele property.
ನನಗೆ ನಿಮಗೆ ಕೇಸ್ ಗೊತ್ತು, ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Yes.
Please help me understand your case.
Yes.
Plaintiff's PW2 says there are 3 items.
There are 3 items.
2 items are situated adjacent to each other.
Adjacent to each other.
1 item is Sigebele.
Yes.
ಆ Sigebele ಪ್ರಾಪರ್ಟಿನ ಹೇಮಲತಾ ಅನ್ನೋರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೀವು ಸಜೆಷನ್ ಮಾಡಿದ್ದೀರಾ.
Yes.
ಸೊ ಅಲ್ಲಿಗೆ Sigebele ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ಆಯ್ತು.
Yes. It has been purchased by us subsequently.
ಇದೆ ಅಂತ ಆಯ್ತು.
Yes.
ಅದನ್ನ ನಾನು ಕೇಳ್ತೀನಿ.
Yes. All the 3 items are bearing different numbers with a different dimension. The 2 items are situated abutting each other, whereas the another item is situated at a different place. I do not know whether the property which is situated at Sigebele was sold to one Hemlata by means of a sale deed dated 9/12/1959. After filing of the suit, I did not try to verify in whose possession Sigebele property is. I do not know whether the first defendant Gabriel had purchased the Sigebele property from Hemlata under a sale deed dated 17/5/1973. It is not within my knowledge or notice that the Sigebele property is in possession of Gabriel. It is true that I have filed suit in OS number 791 of 2008 against Gabriel for the relief of injunction in respect of Sigebele property. Sigebele property is not the subject matter of this suit. It is not correct to say that the present suit is filed in respect of all the 3 properties which are purchased by my father in the year 1958. My father purchased the property from Chinsamappa on 6/1/1971. Chinsamappa had purchased that property from Doddaligappa. I do not know how to Doddaligappa got the property. The properties which are the subject matter of the sale deed of 1958 and the properties which are the subject matter of the sale deed of 90 are situated in different places. It is not correct to say that the properties which are subject matter of the above said sale deed are one and the same. The commissioner appointed by court has inspected the spot which were purchased by my father in the year 1971. I was not present when the commissioner visited the spot. I do not know whether my mother was present at the time of commissioner visit. I do not know whether my mother was present at the spot when the commissioner came and showed the property to be inspected. I have not gone through the commissioner report or the sketch prepared by him, nor I know its contents. I now see the sketch prepared by the commissioner, which is in the court record. The property marked in green color is the one which was purchased by my father in the year 1958, and the portion abutting to it purchased by my father in the year 1971. For the purpose of reference, the sketch is marked as Exhibit C1, and the property shown in green color is marked as Exhibit C1A. C1A. And the property abutting to is marked as C1B. It is not correct to say that Papaya had put up construction of house on the portion of property in C1B. The portion marked as C1B in the sketch measures 111 feet in the east and west direction and 211 feet in the northern direction. The property which is situated to the east, to the west of C1B is my property onto the west of, by which he says adjacent to the 211 into 111 foot. The property of defendants, it is correct to say that the defendants are in possession of the property shown differently in orange color in sketch exhibit C1. The portion is situated towards east, or the portion marked as orange color is the property of the defendant. The portion is not colored. The property which is situated towards the west portion of C1B is my ancestral property. The property shown in C1B, which is abutting the green color, is C1A, is the suit schedule property of this case. The property is bound on east by the property of Arogyappa, west by property of Arogyappa, which is the ancestral property. The road is shown to be existing towards the north of the property of C1A, and C1C is not at all existing. Even towards north, the property marked as C1B, the property of Arogyappa is situated. So also towards south is my father. Para number 5. Angdi Chinsamappa, who is my father, vendor, and had purchased the property from Doddarakappa in the year 1966. That was the ancestral property of Doddarakappa. My father and Doddarakappa are cousins. My father had purchased 3 items of immovable property by means of a sale deed dated 4/3/1958. One of the 3 items measures 45 into 73 feet. 45 into 73 feet, situated at Sigebele property, Sigebele. That is the third bit. This is the Sigebele property according to them. A third bit. My father had purchased 3 items immovable properties by means of sale deed dated 4/3/1958. One of those 3 items measures 45 into 73 feet, situated Sigebele. I do not know whether my father had sold a portion of the property in favor of Hemlata on 9/12/1959. Before filing this suit, I did not try to ascertain as to whether or not there was any change of portion of Sigebele property. It is not correct to say that the Sigebele property is also included in the schedule to the plaintiff. It is not correct to say that Hemlata had sold a portion of the Sigebele property to defendant number 1, Gabriel. I have not gone through the contents of the sale deed of 1958, under which my father has purchased 3 items of the properties. The sale deed, kata extract, encumbrance certificate, tax paid receipt are the documents which are produced by me to show that my father was in possession of this property till 1971. All the 3 items which are the subject matter of the sale deed of the year 19 were of different boundaries. Under the sale deed of 1971, only one item was purchased. The properties which were purchased, which were the subject matter of the sale deed of the year 1958 and 71, are situated in one and the same village. It is not correct to say that the measurement of the property purchased under the sale deed of 19 is equal to the total measurement of 3 items of the sale deeds in 1958. It is not correct to say.
Please read the suggestion.
Under the sale deed of 1971 is equal to the total measurement of 3 items in the sale deed of 1958.
That's a suggestion put by you.
That is true. Your Lordship may kindly see,
Whatever-
thereafter there was another sale in the year 1959. In the year 1959. Their father did not purchase the property in 1958. What they have purchased in 1971. ಅದೇ ಬೇರೆ ಇದೇ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ.
Suggestion ಮಾಡೋದು ನೋಡಿ.
ಅದು his father has purchased only in 1971, not 1958. ಆ ಮೂರ್ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ ಇದೆ ಅದು.
Correct. Suggestion.
Yes, I agree.
I agree ಅಲ್ಲ sir. You please read the suggestion again.
There are
It is not
Yes.
correct.
Yes, my lord.
It is not correct to say
Yes.
that the measurement of the property purchased under the sale deed of the year 1971
Yes.
is equal
Yes.
to the total measurement of all the three items of the sale deed of the year 1958.
Yes.
ಅಂದ್ರೇನು?
Yes.
58 ಅಲ್ಲಿ ಇರುವಂತ ಮೆಜರ್ಮೆಂಟ್ 71 ಅಲ್ಲೂ ಇದೆ ಅಂತ. 58 ಅಲ್ಲಿ
There are two properties. There are two properties. One property was purchased by father in the year 1958. Another property which was purchased by father in the year 1971. The property which has been purchased in 1971 is the subject matter of the suit and not the 1958 sale deed. 58.
Yes. ಹಂಗೆ ಓದಿ.
It is correct to say.
It is not correct to say. Not correct to say.
It is not correct to say that the boundaries mentioned in the sale deed in the year 1971 is compared with the boundaries mentioned in respect of three properties. The sale deeds of the year are found to be one and the same. Are found to be one and the same.
That is your suggestion.
That is true, my lord. The 1971 property is not in existence. Is not in existence at all. ಆ 1958 ಅಲ್ಲಿ ಮೂರು ಪ್ರಾಪರ್ಟಿ ಹೇಮರತ್ನಿಂದ ಕೊಂಡ್ಕೊಂತಾರೆ. ಆ ಒಂದ್ ಪ್ರಾಪರ್ಟಿ ಮಾರ್ತಾರೆ 1959 ನಲ್ಲಿ. ಎರಡು ಪ್ರಾಪರ್ಟಿ ಉಳ್ಕೊಳುತ್ತೆ. ಎರಡು ಪ್ರಾಪರ್ಟಿ ಉಳ್ಕೊಂಡಿದ್ರು ಆ ಎರಡು ಪ್ರಾಪರ್ಟಿನೂ ಇನ್ನೊಬ್ರಿಗೆ ಹೋಗುತ್ತದು. ಇವ್ರು 1971 ಅಲ್ಲಿ ಕೊಂಡ್ಕೊಂತಾರೆ. We will go through the plaint also once again.
Yes.
In 1958 sale deed is not the subject matter of the suit. 1971 sale deed is the subject matter of the suit.
Yes.
My father died in 2002. The document will was written on 7/1/2002. The Kasa in respect of suit property was standing in the name of my mother before the death of my father. Kata claims on the basis of the will. Since my father was aged and was not keeping good health and he was not in a position to take care of the property, the Kata of the suit property was changed to the name of my mother during the year 98-99. Exhibit P3 is the Kata extract. Panchayat was assigned with 102 as Kata to the property. He'll claim Madhar 90. That itself is a different property. Kata in respect Panchayat was assigned 102, the suit property. Exhibit P3, the Kata extract shows that Kata number 118, a different Kata has been produced. It is correct to say that exhibit P3, the Kata extract does not pertain to the suit property. He admits it.
No, it doesn't admit.
It is not correct to say that the exhibit P3 Kata extract does not pertain to the suit property. It is not correct to say that the Kandayam receipt produced by me in this case is not in respect to the suit schedule property. The suit property had fallen into the limits of BBMP just about a year ago. I do not know the survey number of the land of which the suit site is part. It is not correct to say that survey number of the said land is 24/9. It is not correct to say that neither my father nor other members of our family, including myself, were never in possession of the suit property. The Kata in respect to suit property was in the name of my father prior to 1998-1999. Exhibit P22 does not pertain to suit property. There is no other property of Marian and Palya other than the suit property standing in the name of my mother. It is not correct to say that the document exhibit P3 and P22 have been concocted and created for the purpose of the case. It is not correct to say that the defendant Gabriel has been in possession and enjoyment of the property since the year 1973. It is not correct to say that Gabriel purchased the suit property from Hemlata in the year 1973. It is not correct to say that I am very well aware of the sale of the suit property in favor of the defendant Gabriel. Then further cross-examination at page number 57.
Yes. 51.
Page number 51. This is after remand. My father has purchased the property under the sale deed dated 6/1/1971, covered under the bill dated 7/1/2002. There were 4 properties in the said will exhibit P1. 4 properties. It is false to suggest there are 4 properties in exhibit P2, but it is only 1 property. Remaining 3 properties were acquired under different sale deeds dated 4/3/1958. Property covered under the sale deed dated 4/3 is not involved in exhibit P1. My father has purchased the property involved in exhibit P2. I have acquired the suit property under the will exhibit under the will. Exhibit C1 is prepared by the court commissioner. Suit schedule property is not there in exhibit C1. Suit property is not there in exhibit C1. It is true to suggest the Honorable High Court sent the court commissioner in RFA number 493 of 2009, and at that time I was present at the spot and shown my property to the commissioner, and then sketch was prepared at the spot, and myself and my counsel have signed the commissioner report. Now I see sketch exhibit P28 and I identify my property, and the same is marked as exhibit P28A. I have shown 4 properties to the commissioner standing that they are my properties. 4 properties. Now I see those properties in exhibit P28 and they are marked as exhibit P28B, C and D.
Yes.
There are different boundaries and measurement to the above said 4 properties. Have you instructed your counsel regarding different boundaries and measurement of those properties? As only there was a dispute in respect of the suit property, hence this case is filed. I told the commissioner that I have filed the suit only in respect of exhibit P28A property. P28A. This is P28A.
Yes.
Is on the right hand side, which measures 143 feet into 133 feet. And the boundaries contained to exhibit P28A and the boundaries mentioned in the plan are different. Measurement also different. ಇದರೊಳಗೆ ನಾರ್ತ್ಗೆ ರೋಡ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ, ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಆಫ್ ಚಿಕ್ಕರಗ್ಯಪ್ಪ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಸೌತ್ಗೆ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಅಂತ ಇದೆ, ಹರ್ಷಕ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಇಲ್ಲಿಗೆ ಸೌತ್ಗೆ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಆಫ್ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪ ಅಂತ ಹೇಳಿದ್ದಾರೆ ದಾವಾದಲ್ಲಿ. ಈ ಈಸ್ಟ್ಗೆ ವೇಕೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಕ್ಲೈಮ್ಡ್ ಬೈ ದಿ ಅಪಲೆಂಟ್, ದಟ್ ಈಸ್ ಅವರ್ ಗ್ಯಾಬ್ರಿಯಲ್ ಪ್ರಾಪರ್ಟಿ. ಇಲ್ಲಿ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಬೌಂಡ್ರಿ. ದೆನ್ ವೆಸ್ಟ್ಗೆ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಮಾರ್ಟಿನ್ ಅಂತ ಇದೆ, ರೋಡ್ ಅಂಡ್ ದೇರ್ ಆಫ್ಟರ್ ಮಾರ್ಟಿನ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ. Now it has been shown as Chikkarogya property. So therefore, the property claimed by him and the property which is the subject matter of the suit are quite different and distinct. And the boundaries do not tally and the measurement also do not tally. I told the commissioner that I have filed this suit only in respect of exhibit P28A. Boundaries of P28 is in form is from one street, Chinswamappa, and Chinswamappa has acquired the same from Doddaragappa. Original document of said Chikkaragappa is exhibit P10. Doddaragappa is at P10. Said property is an ancestral property of Doddaragappa. I do not have any record to show that Doddaragappa has acquired the suit property, and also no records to show that he was in possession of the suit property. There is no records to show that Chinswamappa was in possession of the suit property after purchasing the same from Doddaragappa in favor of my father. Khata of suit schedule property was in the name of my father prior to filing of the suit. After purchasing it, earlier Khata number of suit property was 90. Thereafter, a new number has been 102/118. Only one Khata number is given to 4 properties involved in exhibit P1. There is no records to show that Khata number 90 was changed to 118 and it was changed in 1992. There is a proceedings for this Kata number. It is false to say there is no such proceedings, and Kata number 118 is only concerned to the suit scheduled property. Further, page number 54.
Yes.
I was present during the inspection of the commissioner appointed by the Honorable High Court of Karnataka. Exhibit P28 is the sketch prepared by the court commissioner. Exhibit P28 A, B, C, and D are my properties. I filed this suit only in respect of Exhibit P28A. It is in P28A. It's like that. It is true to suggest there is a difference in measurement and boundaries in Exhibit P28A compared to the plain schedule. We have also elicited that. My father Arogyappa died in the year 2002. Kata of the suit property was in the name of my mother during the lifetime of my father. My father got transferred Kata in the name of my mother in the year 1996-1997. Kata number is Exhibit P28 is 102 by 118. Kata number 28A is 102 at the time of filing of the suit property was Kata number 102 by 100. I have not told my lawyer at the time of filing the suit. Kata number was 102 by 118. Kata number is mentioned as 90 in the plaint. It is false to suggest 24 bar 9 does not have Kata number. It is false to suggest 28A is not belonging to our family and it is property of defendant. Since the time of their ancestors, they have put sheds and compound wall with hollow bricks. It is also false to say there is electricity connection to P28A. There is a property on Harsha Ben South 28A. It is true to say they said Harsha. It is true to suggest that said Harsha towards east property of Chikarogyappa, towards west vacant land of Papaya, towards north and south property of Chikarogyappa. As per Exhibit P28, towards east, there is a property claimed by the appellant defendant, Namdu. Towards west and north, road. Towards south, compound constructed by Harsha. Witness volunteers that Harsha has encroached. It is true to suggest that the defendants have sold the property to Harsha. We have sold the property. The dimension shown in Exhibit P28 is east to west 133 feet, north to south 149.5 feet.
Yes.
Harsha had filed suit in OS number 82 of 85 of 2003 against me, which came to be decreed on 33/2007. In the said suit, the northern boundary was shown as the property of the defendant. This northern boundary is the northern boundary of Harsha property is the very property. He is a party to the suit and he suffers a decree. Now he is claiming. It is false to suggest that I knew Exhibit P28 is not belonging to me at the time of filing the suit itself. I cannot say total measurement of item number 1 to 3 of the sketch prepared by the court commissioner. It is false to say that only item number 1 will belong to me and I am not the owner in possession of.
Yes.
I am not owner in possession of the suit property. The first document that they have produced is the will, which is marked as Exhibit P1.
Yes. You cannot have any objection regarding the will.
Yes, ma'am.
You're not a beneficiary under the will. You're not a heir apparent.
Will provagilla, that is a different thing.
Sir, you cannot dispute the will if you're
Nandala will aurdu.
Aurde sari. If you're an heir apparent.
Yes.
of the testator,
Yes.
then you have right to
Yes.
deny.
Yes.
You're not a heir apparent alla ನೀವು.
ನಾನು ಡಿನೇ ಮಾಡಿದ್ರು ಏನಾಗಲ್ಲ, ಇನ್ಹೆರಿಟೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಡುತ್ತೆ ಅವರಿಗೆ. So they have based their claim on the basis of the will. Now kindly see the will. Kindly compare the property contained in the will. Kindly compare the property contained in the will with the plain schedule property.
Yes, please read.
Please, my lord. My lord, what is important is there are first and second page. The property which has been bequeathed in their favor is at page number 59.
Yes.
If schedule is looked into, that is sufficient. B. ಡಿಟಮ್ ಮರಿಯಣ್ಣನಪಾಳ್ಯದ 90 ನಂಬರ್ ಖಾತೆ ಇರುವ ಹಿತ್ತಲು ಜಾಗ ಪೂರ್ವಕ್ಕೆ ಅಂಡ್ರಾಳಪ್ಪನವರ ಸೊತ್ತು ಮತ್ತು ನಮ್ಮ ಜಾಗ, ಪಶ್ಚಿಮಕ್ಕೆ ಪಾಪಯ್ಯನವರ ಸೊತ್ತು, ಉತ್ತರಕ್ಕೆ ಅಂಡ್ರಾಳಪ್ಪನವರ ಸೊತ್ತು, ದಕ್ಷಿಣಕ್ಕೆ ಯಾಕಾಶಮ್ಮನವರ ಸ್ವತ್ತು. ಈ ಮಧ್ಯೆ ಇರುವ 30-96. ಡಿಟೋ ಮರಿಯಣ್ಣನಪಾಳ್ಯದ ಗ್ರಾಮ ಠಾಣಾ ಸೀಗೆಬೆಲೆ ಜಾಗಕ್ಕೆ ಚೆಕ್ ಬಂದಿ. ಸೀಗೆಬೆಲೆ ಜಾಗಕ್ಕೆ ಚೆಕ್ ಬಂದಿ. ಬಿಲ್ಲೆ ಮನೆ ರಾಯಪ್ಪನ ಸ್ವತ್ತು ಪಶ್ಚಿಮಕ್ಕೆ, ಪೂರ್ವಕ್ಕೆ ಚಲುವರಾಯ ಶೆಟ್ಟಿ ಸ್ವತ್ತು, ಉತ್ತರಕ್ಕೆ ಸರ್ಕಾರಿ ದಾರಿ, ದಕ್ಷಿಣಕ್ಕೆ ಅಂಡ್ರಾಳಪ್ಪನವರ ಸ್ವತ್ತು. ಈ ಮಧ್ಯೆ ಇರುವ 45 ಅಡಿ 76 ಅಡಿ 73.5. ದಕ್ಷಿಣಕ್ಕೆ ಇದು ಐಟಮ್ ನಂಬರ್ 2. ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೃಷ್ಣರಾಜಪುರ ಹುಬ್ಳಿ ದಾಸರಳ್ಳಿ ದಾಖಲೆ ಮರಿಯಣ್ಣನಪಾಳ್ಯ ಖಾತಾ ನಂಬರ್ 90 ಮನೆಗೆ ಚೆಕ್ ಬಂದಿ. ದೊರೆಯಬಹುದ ಇದೆ 90. ಪೂರ್ವಕ್ಕೆ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪನವರ ಖಾಲಿ ಜಾಗ, ಪಶ್ಚಿಮಕ್ಕೆ ಪಾಪಯ್ಯನ ಮನೆ, ಉತ್ತರಕ್ಕೆ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪನವರ ಖಾಲಿ ಜಾಗ, ದಕ್ಷಿಣಕ್ಕೆ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪನವರ ಖಾಲಿ ಜಾಗ. ಈ ಮಧ್ಯೆ ಇರುವ 111 ಅಡಿ 211 ಅಡಿ.
Yes.
Ulashima, kindly the second document that they have produced, which is marked as Exhibit P2, is the sale deed dated 6/1/1971. The father of the appellant claims to have purchased the subject property under the sale deed of 1971, 6/1/1971. 6/1/1971, page number 63. ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ದಾಸರಳ್ಳಿ ಮರಿಯಣ್ಣನಪಾಳ್ಯದ ಸರ್ವೆ ನಂಬರ್ 90 ರಲ್ಲಿರುವ ಕ್ರಯಕ್ಕೆ ಚೆಕ್ ಬಂದಿ. ಪೂರ್ವಕ್ಕೆ, ಉತ್ತರಕ್ಕೆ, ದಕ್ಷಿಣಕ್ಕೆ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪನ ಖಾಲಿ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಪಾಪಯ್ಯನ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ, ಪೂರ್ವ ಪಶ್ಚಿಮ 111 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 211 ಅಡಿ. ಈ ಮಧ್ಯೆ ಇರುವ ಸ್ಥಳ ನಿವೇಶನ ಕ್ರಯಕ್ಕೆ ಸೇರಿರುತ್ತದೆ. They have incorporated this property as the scheduled property and they have filed this suit.
3 ಕಡೆ ಚಿಕ್ಕಾರೋಗ್ಯಪ್ಪ.
3 ಕಡೆ
ಹೌದು
ಚಿಕ್ಕಾರೋಗ್ಯ.
ಹೌದು.
Yes.
Though they claims to have filed the suit in respect of this property, when the commissioner had come to the spot, they had shown the property which is 28A as the property which is the subject matter of the suit.
Yes.
So 28A in the commissioner report did not tally with the plain schedule.
Yes.
On the other hand, the property which has been shown as 28A in the commissioner report is concerned. Onto the south of the said property, Harsha possessed a Harsha is possessing the property. When there was an interference by the very plaintiff, the appellant, Harsha has filed a suit. That judgment also be part of the court records. Court has observed it is not this property 28A is not the property of the plaintiff herein, who suffers a decree. On the other hand, records are finding it is the property of Gabriel, that is the defendant.
Yes.
That judgment is also part of the court records, so I will point out. Then they have produced certain other documents. Crucial document is exhibit P1 and P2.
Yes.
1958 document is concerned. 1958 document is concerned, which is at page number 77.
Yes.
Page number 77. 1958ನೇ ಇಸ್ವಿ ಮಾರ್ಚ್ ತಾರೀಕು 4ರಂದು ಬೆಂಗಳೂರು ಸೌತ್ ತಾಲೂಕು ಕೃಷ್ಣರಾಜಪುರ ಹೋಬಳಿ ದಾಸರಳ್ಳಿ ದಾಖಲೆ ಮರಿಯಣ್ಣನಪಾಳ್ಯದಲ್ಲಿ ಇರುವ ಪೌತಿ ಸೌರಪ್ಪ ಮತ್ತು ಅವರ ಕುಟುಂಬ ಆರೋಗ್ಯಪ್ಪನವರಿಗೆ ಬೆಂಗಳೂರು ಸೌತ್ ತಾಲೂಕು ಕೃಷ್ಣರಾಜಪುರ ಹೋಬಳಿ ದಾಸರಳ್ಳಿ ದಾಖಲೆ ಮರಿಯಣ್ಣನಪಾಳ್ಯದಲ್ಲಿ ಪೌತಿಯಾಗಿ ಅಬ್ಬಯ್ಯಪ್ಪನವರ ಕುಮಾರ ಸೌರಪ್ಪನಾದ ನಾನು ಬರೆದುಕೊಟ್ಟ ಸ್ಥಿರ ಸ್ವತ್ತುಗಳ ಕ್ರಯಪತ್ರದ ಕ್ರಮವೇನೆಂದರೆ, ಮರಿಯಣ್ಣನಪಾಳ್ಯದ ಬಳಿ ನನ್ನ ಪಿತ್ರಾರ್ಜಿತವಾದ ಸ್ವತ್ತು ಅಂದರೆ ನಮ್ಮ ಚಿಕ್ಕಪ್ಪನಿಂದ ಧ್ಯಾನಪ್ಪನವರ ಇವರ ಮಕ್ಕಳು ಕುಟುಂಬವು ಪೌತಿಯಾಗಿರುವ ಸ್ವತ್ತುಗಳಿಗೆ ನಾನು ಹಕ್ಕುದಾರನಾಗಿ ನನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಇದೇ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನು ಈ ದಿವಸ ನನ್ನ ಕುಟುಂಬದ ಪೋಷಣೆಗಾಗಿ 200 ರೂಪಾಯಿಗಳು ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಸದರಿ ಮೊಬೈಲ್ಗಿನಿಂದ ಪೈಕಿ ಬಂದ ಅಡ್ವಾನ್ಸ್ ಆಗಿ 20 ರೂಪಾಯಿಗಳನ್ನು ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಉಳಿದ 170 ರೂಪಾಯಿಗಳನ್ನು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಸಮಕ್ಷಮ ತೆಗೆದುಕೊಂಡು ಕ್ರಯಪತ್ರ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡುತ್ತಾನೆ. ಸದರಿ ಸ್ವತ್ತು ಈ ದಿನವೇ ನಿಮ್ಮ ಸುಬರ್ದು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಈ ಸ್ವತ್ತಿಗೆ ಕಟ್ಟಬೇಕಾದ ಕಂದಾಯವನ್ನು ಸಾಲೆ ನೀವು ಪಾವತಿ ಮಾಡಿಕೊಂಡು ಖಾತೆಯನ್ನು ನಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡಿಸಿಕೊಳ್ಳತಕ್ಕದ್ದು. ಇನ್ನು ಮುಂದೆ ಸ್ವತ್ತುಗಳಲ್ಲಿ ದೊರೆಯಬಹುದಾದ ನಿಧಿ ನಿಕ್ಷೇಪ ಅಷ್ಟಭೋಗ್ಯ ತೇಜಸ್ಸುಗಳಿಗೆ ನಿಮ್ಮ ಪುತ್ರ ಪೌತ್ರ ವಂಶ ಪಾರಂಪರ್ಯವಾಗಿ ದಾನ ಭೋಗ್ಯಾದಿಗಳು ಸುಖದಿಂದ ಅನುಭವಿಸಿಕೊಂಡು ಬರತಕ್ಕದ್ದು. ಇನ್ನು ಮುಂದೆ ಒಂದು ವೇಳೆ ತಂಟೆ ತಕರಾರು ಬಂದರೆ ನೇನೇ ನನ್ನ ಸ್ವಂತ ಖರ್ಚಿನಿಂದ ಪರಿಹರಿಸಿಕೊಡ್ತೀನಿ ಎಂಬುದು ನನ್ನ ಖುದ್ದು ಮನೋರಾಜಿಯಿಂದ ಬರೆಸಿಕೊಟ್ಟ ಸ್ಥಿರ ಸ್ವತ್ತುಗಳ ಕ್ರಯಪತ್ರ ಮರಿಯಣ್ಣನಪಾಳ್ಯದ ಸರ್ವೆ ನಂಬರ್ 90 ಮನೆಗೆ ಚೆಕ್ ಬಂದಿ. ಪೂರ್ವಕ್ಕೆ ನಿಮ್ಮ ಮನೆ, ಪಶ್ಚಿಮಕ್ಕೆ ಪಾಪಯ್ಯನ ಮನೆ, ಉತ್ತರಕ್ಕೆ ರಾಜಬೀದಿ, ದಕ್ಷಿಣಕ್ಕೆ ಅಂದ್ರಾಳಪ್ಪನ ಹಸ್ತೆ, ಈ ಮಧ್ಯೆ ಇರುವ ಪೂರ್ವ ಪಶ್ಚಿಮ 36 ಅಡಿ, ಇನ್ನೊಂದು ಉತ್ತರ ದಕ್ಷಿಣ 42. ಈ ಜಾಗದಲ್ಲಿ ಕಟ್ಟಿರುವ ಸುಮಾರು 4 ಅಂಕಣದ ಮಂಗಳೂರು ಹೆಂಚಿನ ಮನೆಗೆ ಸೇರಿರುವ ಅಂಗಳಗಳು ಖಾತೆ ಇರುವ ಚೆಕ್ ಬಂದಿ. ಪೂರ್ವಕ್ಕೆ ಅಂದ್ರಾಳ ಡಿಟೋ 90ನೇ ನಂಬರ್ ಖಾತೆ ಇರುವ ಹಿತ್ತಲು ಜಾಗಕ್ಕೆ ಚೆಕ್ ಬಂದಿ. ಪೂರ್ವಕ್ಕೆ ಅಂದ್ರಾಳಪ್ಪ ಮತ್ತು ಹಿಸ್ಸೆ, ಪಶ್ಚಿಮಕ್ಕೆ ಸದೃಯ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ಅಂದ್ರಾಳಪ್ಪನ ದಕ್ಷಿಣ ಜಮೀನು, ಈ ಮಧ್ಯೆ ಇರುವ ಪೂರ್ವ ಪಶ್ಚಿಮ 30 ಅಡಿ ಗ್ರಾಮ ಠಾಣ ಮತ್ತು ಬೇಡಿ ಜಾಗಕ್ಕೆ ಚೆಕ್ ಬಂದಿ. ಬಿಲ್ಲೆಮನೆ ರಾಯಪ್ಪನ ಹಿಸ್ಸೆ ಮತ್ತು ಚೆಲುರಾಯನ ಶೆಟ್ಟಿ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ಸರ್ಕಾರಿ ದಾರಿ, ಅಂದ್ರಾಳಪ್ಪ ಮತ್ತು ನಿಮ್ಮ ಹಿಸ್ಸೆಗಳ ಮಧ್ಯೆ ಇರುವ ಪೂರ್ವ ಪಶ್ಚಿಮ 45 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 73 ಅಡಿ. This is one property which has been claimed by them.
Yes. These are two properties, Alva.
There are two properties.
Idರಲ್ಲಿ.
Where is the property which is the subject matter of the suit is more important. He points out this is the property. This is the property
Yes.
for which he suffers a decree. Now we will go to the document of the defendants.
Yes.
ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀರಲ್ಲಪ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ ನೋಡಮ್ಮ. ಮಾಡಿಲ್ಲಲ್ಲ? ಎಷ್ಟಮ್ಮ? Our document commences at page number 191.
ಈಗ ಈ ಸಜೆಷನ್
I have shown the two sale deeds of 1958 and 1971. In 1971 document, there is one property. In 1958, there are three properties. There are three properties. The three properties which has been claimed by them on the basis of the sale deed are item number 1, 2, 3.
Yes.
One above the other. Having purchased that three properties, had put a claim in respect of property having exhibit P28A. P28A is not the property which has been purchased, is not the property which has been purchased by them. So far as those three blocks are concerned, we have no claim. The interesting point is, if the measurement are put together with regard to the three properties, it becomes the one property's measurement, that is 111 into 211.
Yes.
So taking that measurement, indirectly he wants to claim the property which belongs to us, that is 28A. 28A was our property. Part of the property we have sold to Harsha. After we selling the property in favor of Harsha, this plaintiff interferes with his possession, and Harsha makes him as a party and files a suit. Court has decided the property which has been shown as 28A is not the property of plaintiff. That finding is also recorded. He suffers a decree, and that judgment has become final and conclusive between the parties. ಅದಕ್ಕೆ I have suggested ನೋಡಿ ಆ ಮೂರು ಪ್ರಾಪರ್ಟಿ ಮೆಜರ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ 1958 ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಿದೆ ಆ ಪ್ರಾಪರ್ಟಿ ಹೋಗುತ್ತೆ. 1971 ಬರೋದಿಲ್ಲ ಅದಕ್ಕೆ. So 1971 sale deed property, the property covered under the sale deed of 71, it is not in existence at this point. We have suggested the case different.
Yes.
The document which we have reviewed at page number 191. Is the sale deed dated 1960-1950.
Yes.
The property which is covered with this sale deed is page number 193. It is we have purchased it. All that agriculture land in survey number 24/9. Dasgadi village, Bangalore, North Cover, 20 kuntas of garden land, assessed at so and so, village, Arugate, rounded east by village side, and Abaya, and Arugate was land, west by Saurabha, and Papaya's land, north by road, and south by Nagwara lake. All item number 2. All that agriculture land 2410, Dasgadi village, Krishnapura village, South Cover consists of 9 kuntas, garden land and assessed so and so, east by Appaya's land, west by Uttama's land, north by village side, and south by Arugate land. Third property, agriculture land, circle number 41, Dasgadi village, Krishnapura village, measuring 25 kuntas, so and so, east by Appaya's house, west by west and north by road, south by village side. All that from the item number 4. All the premises situated naturally within transfer of the Kenur south or consists of 6 animals of unroad traffic. 7 animals were put together with data and vacant site lie to the west. Bounded on east by Raya Pass Road, west by Raya Pass vacant land, north by Konda Pass Road, and south by road. The property of which we have purchased, a portion of which we have sold it to Harsha. Idrolage 24/9 is the property situated and shown in this survey sketch. The survey is the commissioner's sketch. It is our property. All the then the second sale is of 1959.
Yes.
Page number 193. By village site. East vacant property, village site. 28A for people. And Abhaya property. And Arogya Pass land. The Arogya Pass land is the 3 bits. Under the other is.
Yes.
West by Chaurapa's property, Chaurapa and Papaya's property. Or Maga Martin. North by road. South Care. Nagmara Kere itto. Idu Kedagade ittadu. Part of the land we have sold it to Harsha. Harsha's property is situated under the north of our property. Under the south. So this is the property which is covered in the sale deed of 1950, 1950, which is marked as Exhibit D1.
Yes.
So in respect of our property, the suit has been pressed and he is indirectly claiming my property. And we have got Khata and everything. D2 is the sale deed dated 9/4/1959. Yamulasa has got the property. Yamulasa has purchased the property.
Yes.
The property purchased by Yamulasa page number 196. Check on the पूर्व के चलुराय कोणवर खाली जागा पश्चिम के निम जमीन तो उत्तर के दक्षिण के अंतराळावर जमीन मध्ये उत्तर दक्षिण 90. This is the property.
Yes.
This is the property. E-property. Then E3 is another sale deed.
Harsha. Yes.
We have sold it.
ಹರ್ಷಂಗೆ ಸೇಲ್ ಮಾಡಿದ್ದು 114 feet into 126 feet. Huh? How much was sold to Harsha?
It comes in the bottom here.
ಅಲ್ಲ ಎಷ್ಟು ಸೇಲ್ ಮಾಡಿದ್ವಿ ಈ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ how much was sold to Harsha? But Harsha ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ please come to Harsha. ಅಲ್ಲ ಸರ್ ಪೇಜ್ 220 ನಲ್ಲಿ 220 Sri Harsha Narsimhan. He has purchased 120 into 120. ಅದೇ ಫುಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಮಾರ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಎಲ್ಲಿ ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಾ? Gabriel is not you. You are Gabriel, huh? You are Gabriel. M. Gabriel. Yes.
Exhibit E3, which is at page number 189.
Hmm.
Document dated 17/5/1973.
Hmm. Hmm.
28 acres.
Yes.
ಜಮೀನಿಗೆ ಸಿಬ್ಬಂದಿಗೂ ಬಯಲ ಜಮೀನು ಪ್ರಸ್ತುತ ಬಯಲ ಜಮೀನು ಈ ದಿವಸ ಕರೆಗೆ 24 217 is there. Page number 200.
Hmm.
This is executed by Gabriel.
Hmm.
In favor of Sri Harsha.
Hmm.
200.
Yes. But ಇದು ಆಮೇಲೆ ರೆಕ್ಟಿಫೈ ಆಯ್ತಲ್ಲ ಇದು ಮೆಷರ್ಮೆಂಟ್ ವಾಸ್ ರೆಕ್ಟಿಫೈಡ್ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಗಿದೆಯಲ್ಲ ಇದು ಅಲ್ಲ ಬೌಂಡ್ರೀಸ್ ಅಲ್ಲ ಮೆಷರ್ಮೆಂಟ್ 120 into 120 ಇದ್ದಿದ್ದು 126.5 into 112 ಆಗಿದೆ 114.
Measurement 228 page number 228.
Yes.
What is important is the boundary. Boundary is at 220.
Yes, please.
All the petition parcel of property site number 1 and 2 is circle number 4 converted for the state purpose. Measuring east to west 120 feet, north to south 120 feet. In all measuring 14,400 feet and bounded on Abhaya's property, east by Abhaya's property,
Yes.
west by 20 feet road, north by Gabriel's property. This is my property, Gabriel's property. So what I have written is not to the north. South by Nandini Alva's property. So on to the south of this property I have sold in favor of Sri Harsha in year 1900, 2002, 57, 2002.
Yes.
So by the sale deed of 2002 indicate onto the north of Sri Harsha's property, Gabriel property is indicated. Gabriel is the defendant respondent, of which he has made the claim now because it's on. So far as it is concerned, page number 222.
Hmm.
In the measurement 114 by 126 feet of the rectification.
ಆಯ್ತು
Yes.
I've seen that.
Now, the suit has been filed after purchase of the property by Sri Harsha against Chinamma Sagai Raj, that they are the plaintiff. The boundary 228.
Yes.
228 by Abhaya's property, west by 20 feet road, north by Gabriel's property, that is 28A in this state,
Yes.
south by Nandini Alva's property. This true. This was contested by the defendant by filing the written statement. It is at page number 231.
Yes.
Page number 231.
Hmm.
Then the judgment is at page number 238, which is marked as exhibit D21.
Yes.
The order portion is at page number 250.
250.
Yes. Suit of the plaintiff is declared permanent injunction is granted in favor of the plaintiff, restraining the defendant from executing the plaintiff. So therefore, they suffer a degree in respect of the property. In favor of the
Yes.
plaintiff in that suit, Sri Harsha.
Yes, please.
Issue number 2, which has been filed in the state court.
Hmm.
Whether the plaintiff issues in that page number 202.42.
Yes.
Whether the plaintiff proves alleged obstruction, whether the plaintiff is entitled for any relief, what order or degree. Issue number 1 has been affirmed, ordered, affirmatively at page number 250 before para number 17.
Yes, please.
In para number 17, issue number 2 has been answered in favor of the plaintiff affirmatively. Consequently, an order of injunction has been granted. One sentence I would like to read in para number
But all these properties lie within survey number 24/9.
24/9, of which they are not due. For our property, they have filed a suit.
Yes.
Our 24/9. Now we are claiming 24/9. And our property is identified by the commissioner and which is covered by the SETI. And it is also part of the finding recorded in OS number 82, 85 of 2023, 2003, which is at exhibit D21.
Yes.
Paragraph 16 was this issue for permanent injection, issue for permanent injection is what is rights of the parties, but it is only the concern with the possession of the property. Plaintiff is claiming. Plaintiff is claiming the suitable property under the safety from Gabriel building. In this regard, plaintiff has produced the document exhibit P10, 13, P10 and 213. There are photographs of the building in this regard. The evidence of DW1 is damaging. DW1, who is defendant number 2 in the case, clearly admits that he does not know anything regarding building in exhibit P10 and 11. He does not know if plaintiff is residing in a house in exhibit P10 and 11. In view of the clear admission, DW1 answer issue number 1 in the apartment. In para number 15, madam, 15, before para number 16, there is a penalty paid to the para. It is true to suggest that I have no concern with regard to the scheduled property in which the plaintiff built structure. It is false to suggest that it is as well as the plaintiff has reporting property. Para number 15 was this. The witness has been subjected to the cross-examination. In cross-examination, witness states, I do not know who is constructed exhibit P10 and 11. Building in exhibit P10 and 11 is a property belonging to the defendant. I do not know whether the building is seen in exhibit P10 and 11 are completed or not. I do not know whether anybody is residing in the building in exhibit P10 and 11. I do not know the plaintiff built the building in exhibit P10 and 11. I do not know the plaintiff is residing in the house in exhibit P10 and 11. The city to suggest abutting property and Arugapa property, Papaya, plaintiff is not have any right. I do not know from whom the plaintiff has purchased the property. I don't know the plaintiff has purchased the scheduled property from Gabriel. It is true to suggest that I have filed a suit against Gabriel bearing OS number. It is false to suggest that I have filed a suit against Gabriel only after the plaintiff has purchased the scheduled property from Gabriel. And I am putting started construction. I have produced deed exhibit P30, Tata D30. I do not know the Gabriel has sold 27 acres of land in Nandini Alva as per exhibit D2 to D4. I do not know the Gabriel was in possession of 7 acres of land apart from 27 and half acres sold in favor of Nandini Alva. I do not know the Gabriel has scheduled property in the remaining. It is true to suggest I have no concern with the scheduled property in which the plaintiff is building. So therefore, he admits that I have no concern over the property which is located on the southern side of it. The boundary which has been furnished to the property of CH-12, northern side is the Gabriel property. When he suffers a degree and he doesn't file an appeal against the same,
Yes.
when the said judgment has become final and conclusive, we have to see what is the right to do. So SETI shows one another property and he claims another property by way of adducing evidence.
Yes, where is he? Still arguing?
Not taking the call. He's not taking the call.
Huh?
He's not picking the call.
Which matter is going on? Serial number 56, your serial number is over. Where is he?
Not picking the call.
Yes.
Now we will read the judgment also. Page 324. Reasoning commences at page 330.
Yes.
By injunction. These issues are implemented and they are taken together for common discussion to provide benefit. The Honorable Supreme Court in civil appeal number 2 has remitted the matter to this court without the identification of the property claimed by both the sides on the basis of the respective deeds, title and bills. After the matter was remanded by the Honorable Supreme Court, as per the direction, an opportunity was given to both the parties to leave their additional evidence. Accordingly, both the plaintiff and defendants have led their additional evidence. The plaintiffs have approved the court with a specific plea that the suit property bearing part number 19 measures 111 into 211 and half feet with the following boundaries. According to the plaintiff, the said property originally belonged to sons of Andhra and they have sold the said property to Dilsom under the presidency of 1966. It does the said Dilsom has sold the scheduled property in favor of the father of the plaintiff by name Arojappa on 6/1/1971 by mentioning the above said boundaries. In further case of the plaintiff, that the father of the plaintiff by name Arojappa bequeathed the suit scheduled property along with some other properties in favor of the wife of plaintiff number 1. Now her name is deleted and plaintiff number 2 under registered with dated 7/1/2002. In the same way, the suit property is shown as item number 2 and the boundaries is also mentioned as stated above. According to the plaintiff, as of the date of filing the suit, they are in possession of the property without any hindrance. The defendants have no semblance of right over this property attempted to interfere with the possession of the plaintiff and staff of the plaintiff. The defendants have appeared. Defendant number 1 filed a return statement in the effect that he has purchased item number 4 items of the property from Yamlata and the registered sale of 1963 and they are in possession of the said property. It is the specific case of the defendant that the plaintiff now tries to establish right over the neighboring properties without any specific boundaries to the extent of the scheduled property, including the property of the defendant. From the above defense, the defendant is gathered. Now the plaintiffs are including the properties of the defendant. They are seeking permanent injunction. In view of the contention taken in the defendant, the burden is heavily casted upon the plaintiff to prove, as on the date of filing the suit, which specific properties mentioned in the schedule is in possession of the same. In order to substantiate these contentions, the plaintiff has produced as many as 46 documents. In support of the document, the plaintiff himself has examined the speed of the proof and his examination sheet has been filed by way of affidavit, wherein he has retained the government making the claim. It is also pertinent to note, though the plaintiff one, that is the mother, the plaintiff two has examined, partly cross-examined. She has not subjected for further cross-examination. Subsequently, her name has been deleted from the contract. After the exhibit document, the important document that is effectively there relied upon by the plaintiff is marked as exhibit B10. Is the original stating dated 18/11/1963, executed by sons of Andhra in since some of us that is Benda was the father of the plaintiff 90 measuring 111 feet. Boundary shown in the schedule. B2 is the certified copy of the sale deed of 1971, which reveals the father of the plaintiff has purchased the 6/1/1971, whereas the model is mentioned as shown in the schedule, especially the original exclude the in favor of plaintiff number 1 now dated one subjected to cross-examination by the defendant where it is counsel suspect. Same is denied by the witness. On the other side, DW1 by name Captain has been examined and examination in chief has been filed by way of reference where he reiterated the government making the reverse statement and part equal to the entire cross-examination concentrated only respect of server number 24/9 and 24X. Rest of the cross-examination is just delayed the examinations. DW2 is one Albert who is the defendant number 2 in this case. Examination in chief has been filed by way of where he reiterated the government making the reverse. Some of the documents were not marked for true. The granting the following admissions has been elicited from the witness. Whatever procedures are available when they head in the surveillance report for instance, at the director of the number Marian Francis, Virtual Talaku, Satyas, Indura, Shakti Lava, like a lot of this really. I will let it apart from the work evidence of the party, a commissioner, that is the surveyor, has been appointed in this case, and when RFA has been preferred against the judgment and decree, Karnataka High Court is also appointed the advocate commissioner. The said report is available in the file. Case prepared by the surveyor is marked as and report of the commissioner is, that is advocate appointed by the report is marked as P28. From the evidence of the plaintiff which is gathered, the plaintiff is in possession of the property measuring 111 feet. So this is measurement measuring P10 and P2. On the other hand, from the defense of the defendant gathered, no such extent of the property is available at this spot, and the boundaries to this property is also not correct. And the plaintiff wanted to include the property of the defendant seeking injection. Under such circumstances, as per the ruling of the apex court, it is a matter of Anapura Sudhakar, Reddy, and the plaintiff has to go for comprehensive issue, seeking for declaration even after reminded to this court. The plaintiff has not sought for the declaration. Now, at the stage of evaluation of document evidence, relied upon by the plaintiff, that examination admitted the plaintiff has not produced any fact sheet or other document. The vendor of the system of that is right and interest for number 19 measuring 111 into 111 and half. You use entire documents to demonstrate such Andhra for going this extent. Exhibit B10 reveal sons of Andhra upon 1863 sold the property in favor of income of Martha as per exhibit B2, where the same property is sold in favor of the plaintiff, father of plaintiff number 2 by name Aragya. From the set of document P10 and P2, income of retained property nearly 6 years. The Panchayat document would have been dated in the name of Chinsam. Most of the document is produced by the plaintiff. That in between 1996 to 1971 and 1966 to 71, Kakal's food property was in the name of Chinsam. Further, the father of the plaintiff number 2 and other the and then exhibit B1 here. The scheduled property in favor of the plaintiff number 2. The property right of 1971 to 2022. No Panchayat document is produced by the plaintiff to show that after purchase exhibit B22, the party, others the plaintiff number 2 for the possession enjoyment of the scheduled property. No material is produced to prove the boundary shown in the scheduled replay. Exhibit B3 is the demand for the extract of 98, 99, respect of 118, standing in the name of the number. How this document is helpful to the plaintiff to his possession over the scheduled property is not forthcoming. The plaintiff is also produced B22, demand to extract for the year 95-96, standing in the name of the first plaintiff. Even in the document also no property number extent mentioned. Therefore, these two documents are not helpful to the plaintiff to show as on the date of filing the scheduled property in his possession. It is pertinent to know admittedly the two property considered in the ground data and as stated in the plaintiff itself. It is having Kata number 90 from 1996. Therefore, it is expected In the name of the base, here neither the father is claiming, nor is claiming give any application to enter the company, including the vendor of the plaintiff name. How it is used in the to maintain other than the basis of the application. The application is so the last thing was existed from the end of the phase of the most of the steps have been made to this all except B10, B2, B1. All the entire documents are made to so that as the date of having the children, he was in possession. Even exhibit B3 and B22 are also not helpful to the patient. Both the property and the date of having the children. What of the writing is reduced? Some taxpayers in P13, 17 to 19. Those documents are not helpful because where collection of tax cannot give inference that the writing is in possession of property. Those taxpayer receipts are also not pertaining to property, whereas different numbers are mentioned. In such circumstances, the university is taken with the different. It is usually quite examining economic and guidance. Most of the systems has been made. Thus, except the statement in the document, no other document because it was to demonstrate but the event and the date of any of this is no document are VBMP documents suspended the defendants in order to do the defense. They have produced D1 is steady dated 1990. The date of actual as many as 4 items in favor of what is civilized outer pit item number 2. Is a date of 1959 where the state military 28 to 90 sold by RJ5. D3 is a date of 1978 by gave Lata by selling the property purchased under the exhibit dependent number 1. Here exhibit D1 is the most important document because of the exhibit. Exhibit D10 is the most important document and the exhibit D10 is property cost number. Sanjay Gupta, Veerana in favor of Arajeeva, mentioning two different extents in same cost number. First case 4 acre, child east to west 36 feet. Title number 2, 19 measure 30 into 90 in the CH level. By recording exhibit D10 with B1, 2 and 10, we remove exhibit cost number 19 is maintained. All this is exhibit. Thus, identification of property is involved in this case because the property is also bad. They can see
Bring him tomorrow. Tell him no adjournment tomorrow. I already spent 2 hours. Release tomorrow. Yes. Mr. V. Prabhakar.
47, V. Prabhakar.
PB Raju.
ಕಳಿಸಿದ್ದೀನಿ 2 ಫೀಟು 23 ಫೀಟ್ 3.5 ಫೀಟ್ ಅದರಲ್ಲಿ
ಏನ್ ಕಳಿಸಿದಿರಾ
ಫೋಟೋನು ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಸ್ ಮಿಸ್ಟರ್ ಯಾರು PB ರಾಜು BS ಸತ್ಯಾನಂದ್ ತೆಗ್ಸಿದಿರಾ?
ತೆಗ್ಸಿ ಇಲ್ಲಿ ಅಡ್ಡ ಬರ್ತದೆ ಅಂತ ತೆಗ್ಸಿ ಕಟ್ ಮಾಡಾಕಿದ್ದಾರೆ. ಅವರು ಫೋಟೋ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತೆ.
ಏನು ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದಾ?
ಅದೇನು ಮಾಡಲಿಲ್ಲ ನಾನು ಹೋಗ್ಲಿಕ್ಕೆ ದಾರಿ ಇಲ್ಲ. ಈಗ ಹೇಳೋದೇನಂದ್ರೆ ಕರ್ಕೊಂಡು ಮುಂದೆ ಇಡ್ತಾರೆ ಸರ್. ಅದು 2 ಪೀಸ್ ಮಾತ್ರ ಕಟ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ. ಪ್ಯಾಟರ್ನ್ ಚೇಂಜ್ ಮಾಡಲಿಲ್ಲ.
ಪ್ಯಾಟರ್ನ್ ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲೂ ಹೇಳಿದ್ದೆ ನಾನು ಮಾಡಿದ್ದೀನಿ ಅಂತ. ಅವರು ನೋಡ್ಕೊಂಡು ಬರ್ಲಿ ಸ್ವಲ್ಪ ತಲೆಗೆ ಕಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಕಟ್ ಮಾಡಿ ಆ 23 ಅಡಿ ಪ್ಲಸ್ ಏನಿದು ಪ್ಯಾಸೇಜ್ ನಲ್ಲಿ ಏನು ಇಲ್ಲ, ಅವ್ರದ್ದು ಖಾಲಿ ಲ್ಯಾಂಡ್, ಬೇರೆ ಏನು ಇಲ್ಲ, ಅಲ್ಲಿ ಏನು ಯೂಸ್ ಮಾಡಲ್ಲ, ಸುಮ್ಮನೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಸರ್ ಅವನ್ ಜಾಗನ ಯೂಸ್ ಮಾಡ್ಕೋತಾನೋ ಬಿಡ್ತಾನೋ ಅದು ಅವನ ಹಣೆ ಬರ.
ಅದು ನಾನು ಹೇಳಿಲ್ಲ.
ಅವ್ನ್ ಖಾಲಿ ಜಾಗ ಇದೆ ಅಂತ ನೀರ್ ನುಗ್ಗಕ್ಕಾಗಲ್ಲ.
ನಾವೇನು ಮಾಡ್ಲಿಲ್ಲ, ಸುಮ್ಮನೆ ಪ್ಯಾಸೇಜ್ ಆಗಿದೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವರು ಇನ್ನೇನು ಹೇಳೋಂಗಿದ್ರೆ ಹೇಳಿ.
Just find out.
ಅದೇ 3 feet 6 feet ಅನ್ನು ಏನು ಮಾಡಿದ್ರು 3 feet ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಸೂಟ್ ಗೋಡೆ ಹಾಕ್ಬಿಟ್ಟು ಅದು ಮುಚ್ಚಿದ್ರಿಂದ ನಾನು ಸೈಡ್ ಗೋಡೆ ಹೋಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಎಲ್ಲಿದೆ ಗೋಡೆ ಅದು?
ಎಕ್ಸ್ಬಿಟ್ ಪಿ 18 ಅಲ್ಲ 18 ನೋಡ್ರೆ. ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಸೂಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು ಎರಡು ಸಲ ಹೇಳ್ತಿದ್ರು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ಆಯ್ತಪ್ಪ, ನಿನಗೆ ಕೇಸ್ ಚೆನ್ನಾಗ್ ಗೊತ್ತು, ನನಗ್ ಗೊತ್ತಿಲ್ಲ. ತೋರ್ಸದ್ ಯಾವ್ದು ಅಂತ.
ದಾರಿ ಇಲ್ಲ ಸರ್. ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ.
ಎಕ್ಸಿಬಿಟ್
ಪಿ 17 18 19 ದಯವಿಟ್ಟು ಗಮನಿಸಿದ್ರೆ ಸರ್.
ತಗೊಳ್ರಿ. 17, 18, 19.
17 18 ನಾನು ಕನ್ಫ್ರಂಟ್ ಮಾಡ್ಸಿದ್ದೀನಿ ಸರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕಂಟೆಸ್ಟ್ ಆಫ್ ದಿ ಕ್ಲಾಸ್ ರೆಸಲ್ಯೂಷನ್.
ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಪ್ಯಾಸೇಜು?
ಅದೇನು 46 30 ಫೀಟ್ ಏನಿತ್ತು ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ಬ್ರದರ್ಸ್ ಹಂಚ್ಕೊಳ್ತಾರೆ ಸರ್. ಬ್ಯಾಕ್ ಪೋರ್ಷನ್ ಸೇಮ್ ಎರಡು ಹೆಣ್ಮಕ್ಳು ಕೊಡ್ತಾರೆ. ಆ ಹೆಣ್ಮಕ್ಳಲ್ಲಿ ಒಬ್ಬನ ಹತ್ರ ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೀನಿ. ಅದಾದ್ಮೇಲೆ ಏನಾಗುತ್ತೆ, ಎಲ್ಲರೂ ಓಡಾಡ್ಬೇಕಾಯ್ತು. ಯಾವಾಗ ಈ ಕ್ಲೈಂಟ್ ಫಸ್ಟ್ ಡಿಪೆಂಡೆಂಟ್ ಮನೆ ಕಟ್ತಾರೆ ಸ್ವಾಮಿ, ಆ ಮೆಜರ್ಮೆಂಟ್ ಇರ್ತಕ್ಕಂಥದ್ದನ್ನ 2.5 ಒಂದ್ ಕಡೆ ಮುಚ್ಕೊಳ್ತಾರೆ, ಇನ್ನೊಂದ್ ಕಡೆ 3 ಅಡಿ ಮುಚ್ಕೊಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಇದೆ, ಸೇಲ್ ಡೀಲ್ ಮಾಡೋ ಟೈಮಲ್ಲಿ ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನು ಒಂದು ಸೈಡ್ so far as southern side is concerned. So far as eastern side not kindly see at the time of vendors of the suit ಇದನ್ನು ಮಾಡಿದ್ದಾರೆ ಸರ್. ಫಸ್ಟ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಪಿ 17 ನಲ್ಲಿ ಮೈನ್ ರೋಡ್ ಸರ್. ಆ ಮೈನ್ ರೋಡ್ ಅಲ್ಲಿ ಅದು ಮರ ಕಾಣಿಸುತ್ತೆ ಸರ್, ದಯವಿಟ್ಟು ಅಲ್ಲಿಂದ ನನಗೆ ಎವಿಡೆನ್ಸ್ ಕೊಡಲಿಕ್ಕೆ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಪಿ 19 ದಯವಿಟ್ಟು ಅದು ಅಷ್ಟೇ ಜಾಗ ಸರ್ ನಾನು ನೋಡಲಿಕ್ಕೆ. ಆ ಎಂಡ್ ಅಂತ ನೋಡಬಹುದು, ಅದನ್ನು ಸಿಮೆಂಟ್ ಬ್ರಿಕ್ಸ್ ಅಲ್ಲಿ ಮನೆ ಕಟ್ತಾ ಇದ್ದಾರೆ. ಅದು ನನ್ನ ಸೈಡ್ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೊಂದೇ ಜಾಗದಲ್ಲಿ ನೋಡಬೇಕಾಗಿರ್ತಕ್ಕಂಥ ಆಸ್ತಿ ಅದರಲ್ಲಿ ರಸ್ತೆ. ಅದನ್ನ ಇವರು 3 ಅಡಿಗೆ ಹಾಕಿದ್ರೆ ಪಕ್ಕದಲ್ಲಿ 3 ಅಡಿ ಹಾಕಿ ಮಿಡ್ಲ್ ಹಾಕಿದ್ದಾರೆ ಸರ್, ಗೋಡೆ ಹಾಕಿದ್ದಾರೆ. ಅದು ಬಿಟ್ಟರೆ ಆಕ್ಸೆಸ್ ಇಲ್ಲ ಸರ್. ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ಏನು ಗೇಟ್ ಕಾಣಿಸುತ್ತಲ್ಲ ಸರ್, ಪಿ 19 ನಲ್ಲಿ ನಟರಾಜನ್ ಅಂತ ದಯವಿಟ್ಟು ಕೊಡಿ ಸರ್, ಒಂದು ಬೋರ್ಡ್ ಇದೆ. ಇದು ಫ್ರಂಟ್ ಪೋರ್ಷನ್ ಇವ್ರದ್ದು ಸರ್. ಇದು ಜಸ್ಟ್ ಬ್ಯಾಕ್ ಸೈಡ್ ಹೆಣ್ಮಕ್ಳು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ನಾನು ಒಂದು 23ಕ್ಕೆ 30 ಅಡಿ ತಗೊಂಡಿದ್ದೀನಿ ಸರ್. ಅದು 30 ಅಡಿನಲ್ಲಿ 25 ಇಲ್ಲ. ಅದರಲ್ಲಿ ಇದು ಸೇರಿ ಓಡಾಡಿ ಜಾಗ ಅಂತ ಹೇಳಿ 25 23 ಕೊಟ್ಟಿದ್ರು ಸರ್. ಈಗ ಮುಂದ್ಗಡೆ ಜಾಗ ಇಲ್ಲ, ಸೈಡ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ದಾರಿಯನ್ನು ಮುಚ್ಚಿದ್ದಾರೆ. ಸೊ ದಟ್ ವಾಸ್ ದಿ ಫೈಂಡಿಂಗ್ ಆಫ್ ದಟ್ ರಿಪೋರ್ಟ್. ಅದನ್ನ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಸೂಟ್ ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ಇದನ್ನು ಮಾಡಿದ್ದಾರೆ. ಆ ಗೋಡೆ ಕಟ್ಟಿದ್ದಾರೆ. ಈಗ ನನಗೆ ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ನಾಟ್ ಆಕ್ಸೆಸ್ ಸರ್.
ಮತ್ತೆ ಆಕ್ಸೆಸ್ ಇಲ್ಲದೆ ಶೆಡ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ರಿ?
ಅದು ಅರ್ಲಿಯರ್ ಅದು ಖಾಲಿ ಇತ್ತಲ್ಲ ಸರ್ ಆಲ್ರೆಡಿ, ಆವಾಗ ಕಟ್ಟಿದ್ದೀವಿ. ಅವರೇ ಮಾರಾಟ ಮಾಡಿ ಸರ್ 1986
ಆ ಪ್ಯಾಸೇಜ್ಗೆ 116 ತಗೊಳ್ಳಿ ಸರ್. ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ರು, ನಾನು ಗೆದ್ದಿದ್ದೀನಿ ಪ್ಯಾಸೇಜ್ ಇವ್ರಿಗೆ ಸಲ್ಲ ಅಂತ ಅವ್ರು ಅದು ಹೇಳ್ತಾರೆ. 116 ತಗೊಳ್ಳಿ ಸರ್, ಪೇಜ್ ನಂಬರ್
116
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 116. ಅದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ, ಇದಕ್ಕೂ ಅವ್ರು ಹಾಕಿರೋ ಸೇಲ್ ಡೀಡ್ ಬೌಂಡ್ರೀಸ್ಗೂ ಇದಕ್ಕೂ 116 ತಗೊಳ್ಳಿ. ಅವ್ರು ಫೈಂಡಿಂಗ್ ಕೊಡ್ತಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಇದು 116
ಕೊಡ್ರಿ
ಬುಕ್ ನಲ್ಲಿ 116. ಅವರು ಹೇಳೋದು ಇದಕ್ಕೂ ನಮ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ, ನಮ್ಗೆ ಸಂಬಂಧ ಇರೋದು ಆ ಪ್ಯಾಸೇಜ್ ಮಾತ್ರ. ಇವ್ರು ಹೇಳೋದು ಇಟ್ ಈಸ್ ಫಾಲ್ಸ್ ದಟ್ ದೇರ್ ಈಸ್ ನೋ ಡ್ರೈನೇಜ್ ಟುವರ್ಡ್ ದ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಬೇರಿಂಗ್ ನಂಬರ್ 15 at Borough, but towards eastern side of the said property. It is false that my property is not abated by the passage toward eastern side, but I am using the passage of the property bearing number, Maladaka, I am using the passage of the property bearing number 60. ಅವ್ರ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ರು, ಡಿಸ್ಮಿಸ್ ಆಯ್ತು, ನಾನೇ ನಡೆಸಿದ್ದೇನೆ. ಬಿಲಾಂಗಿಂಗ್ ಟು ಶ್ರೀನಿವಾಸ್ ಅಂಡ್ ದೇವೇಂದ್ರ, ಇವರೇ ಅಲ್ಲಿ ಅದಕ್ಕೂ ಇವರೇ ಅಡ್ವೊಕೇಟ್ ದೇವೇಂದ್ರ. It is true to suggest that I have filed a suit at OS number 25 390 of 15 for the relief of mandatory injunction against the said Srinivas and Devendra, it is true to such that I have filed the said suit in respect of the passage located towards eastern side of the property bearing number 59/1. It is true to suggest that the said suit is pending on the file of the civil judge CCS 74. It is false that I have shown the width of the said passage as 5 feet. Witness volunteers that I have shown it has 6 feet. It is also to suggest that I do not have any right over the passage located towards eastern side of the property bearing number 51, which belongs to the property bearing number 60, belongs to Srinivas and Devendra. Our drainage, our property. Property bearing number 60 belongs to Srinivas and Devendra. I do not know from whom they have acquired the said property. ಅದಕ್ಕೂ ನಮ್ಗೆ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ನೀವು ಆರ್ ಎಫ್ ಎನ್ ಯಾಕ್ರಿ ಈ ತರ ಅಲ್ಲ ಆರ್ ಎಫ್ ಎ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ರೀತಿನ ಇದು? Is this the way to argue an RFA? ಎಲ್ಲೋ ಮಧ್ಯದ ಪ್ಯಾರಾಗ್ರಾಫ್ ತಕೊಂಡು ನೀವೇನೋ ಹೇಳ್ತಿದ್ರ ನೀವು ಮಾತ್ರ ಅರ್ಥ ಮೋಸ್ಟ್ಲಿ ಇಲ್ಲಿ ಕೂತಿರೋ ಯಾರಿಗೂ ಅರ್ಥ ಆಗಲಿಲ್ಲ.
ನಾನು ಡೀಟೇಲ್ ಬರ್ತೀನಿ.
ನನಗೂ ಅರ್ಥ ಆಗಲಿಲ್ಲ.
ಡೀಟೇಲ್
RFA ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಪ್ಲೈಂಟ್ ಏನು,
ಡೀಟೇಲ್ ಆಗಿ
ಕ್ಲೈಮ್ ಆಫ್ ದಿ ಪ್ಲೈಂಟಿಫ್ ಏನು, ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಏನು, ಹಂಗ ಹೋಗ್ಬೇಕು RFA. ನೀವು ಎಲ್ಲೋ ಜಜ್ಮೆಂಟ್ ಒಂದು ಪ್ಯಾರಾ ತಕೊಂಡ್ಬಿಟ್ಟು ನೀವೇನೋ ಹೇಳ್ದಂಗೆ ಏನ್ ಅರ್ಥ?
ಮೊನ್ನೆ ಈ ಫ್ಲೈಟ್ ಕಾಫಿ
ಅದ್ ಮೊನ್ನೆ ಆಗೋಯ್ತು, ಇವತ್ತಿಂದ ಹೊಸದು. This is not the way to argue an RFA.
ಅಲ್ಲ my lord, their case is prayer.
ಓದಿ ಏನ್ ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ ಓದಿ. ಪ್ರೇಯರ್ ಅಲ್ಲ ಸರ್, ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 2 ಇಂದ ಓದಿ ಸರ್.
ಪ್ಯಾರಾ 2 ಇಂದ. It is submitted that plaintiff is the owner of the property bearing number 59/1, situated Kadrappinapalya, Indira, Bangalore, bounded on east to west 23 feet and north so 25 feet and 5 feet common passage.
Yes.
The common passage 25 into 5 feet, east to west 23 and north south 5 feet. It is disputed passage and the same will be called hereinafter and herein before the suit schedule property. The plaintiff purchased the said property from his vendor Mr. Menjundappa as per the agreement of sale dated 27/1/1988. And after that sale deed executed on 8/8/1988 and registered on 12/8/1998, the copies of the said sale deeds produced as document number 1 and 2A. The plaintiff submitted that the father of the defendant 1 and 2 was purchased the property from his vendor in the year 1958. Through registered sale deed, the certified copy of the sale deed is produced for the kind perusal of this honorable court and marked as document number 2. Now the same is in Khata number 59/1. The measurements of the property was east to west 46 feet and north of 30 feet and west to east more or less 5 feet so far to enter into the property. The father of the defendants 1 and 2 and purchased the property stating from east side by leaving 6 feet drainage. The father of the defendants was purchased property in Khata number 59 and 2 years later, because there is no road or access to Khata number 59/1, the plaintiff submitted that the father of the defendants died leaving behind his legal heirs 3 sons and 2 daughters. The brothers and sister of the defendant 1 and 2 divided their property in Khata number 59/1 under the release deed dated 16/8/1991. The said release deed registered in Shivaji Nagar sub-register as document number 1449 book 1. The certified copy of the release deed is produced for kind perusal of the honorable court as document number 3. It is submitted that the Khata number 59/1 was felt in the names of the sisters of the defendant number 1, Veliamma and Bhagyavati. The plaintiff submit that the sisters of the first defendant, among them, divided their property through registered partition dated 17/8/1984. The Kata number 59/1, measuring east to west 46 feet and north 20 feet and 5 feet common passage from north to south and east to west 46 feet. As per the site plan registered number 1480 of 8485 dated 27/8/1984 in volume 29 page 6 Shivaji Nagar sub-register. The copy of the site plan is produced for the kind perusal of the Honorable Court and document number 4. At the eastern side of the Kata number, on the eastern side of the Kata was felt in the name of Bhagyavati, and the western side of the property was felt in the name of Veliamma, the second defendant herein. The property divided as per the register partition deed as document number 1480 to volume 2350 book 1 before sub-register Bangalore. The certified copy of the same is produced for kind perusal of the Honorable Court as document number 5. The plaintiff has no idea about the Kata number 59 and their exact measurements of their partition. The plaintiff know the Natarajan and Ganeshan are acquire the property through partition in Kata number 59. It is submitted that as per the partition deed and the release deed, site plan agreement of sale in Kata number 15 in Baron, as per the schedule, the property was east to west 46 feet and north to 25 feet and 5 feet common passage. When it was divided, also east to west 23 feet and north 25 feet and 5 feet length common passage, the plaintiff submit that as per the release deed and partition deed, the common passage was left to the sisters of the defendant one only up to their exact measurement. It is submitted that the sister of the defendant, Bhagyavati, sold her property, Mr. Nanjundappa, through register sale deed as document number 1090, volume 2624, book number 1, dated 16/7/19. The said sale deed certified copy is produced herewith and marked documents. That is, this is the Bhagyavati, sister of the first defendant, sold to Nanjundappa. The plaintiff submit that the boundary mentioned in the sale deed is correct, but to the common passage is concerned, the boundaries are wrong. It was reduced 5 feet into 3 feet on eastern side and the western side 5 feet into 1 feet and half feet. The plaintiff submit that the common passage east to west 5 into 46 feet. The plaintiff submit that remaining portion of common passage was encroached by the first defendant by constructing the building on the suit schedule property.
So ಅಂದಿದ್ರೆ ನಿಮಗೆ ಸೇಲ್ ಮಾಡುವಾಗಲೇ ಕಡಿಮೆ ಪ್ಯಾಸೇಜ್ ತೋರಿಸಿದ್ದಾರೆ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಕಡಿಮೆ ತೋರಿಸಿದ್ರೆ ಯು ಆರ್ ಓನ್ಲಿ ಎಂಟೈಟಲ್ಡ್ ಟು ದಟ್. ಎಷ್ಟು ಕೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ ಕೇಳಿ. 3 ಅಡಿ ಆನ್ ದಿ ಈಸ್ಟರ್ನ್ ಸೈಡ್, ವೆಸ್ಟರ್ನ್ ಸೈಡ್ ಅಲ್ಲಿ 1.5 ಅಡಿ ಅಷ್ಟೇ ಡಿಕ್ರಿ ಆಗಿರೋದು ಅಷ್ಟೇನಾ?
Yes. Exhibit P5 our sale deed. You are kindly exhibit P5. Our exhibit P5 our purchase ಮಾಡಿರೋದು.
ಕರೆಕ್ಟ್. ಈಗ ನಾನು ಕೇಳ್ತಿರೋದು
ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ ಇದಿದೆ. ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಇಲ್ಲ.
ಈಗ ರಿಲೀಸ್ ಡೀಡ್ ಇದೆಯಾ? ರಿಲೀಸ್ ಡೀಡ್ ಇದೆ.
ಸೇಲ್ ಡೀಡ್, ಆ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ
ರಿಲೀಸ್ ಡೀಡ್ ಆ ಹೆಣ್ಮಕ್ಳಿಗೆ ಬಿಟ್ಕೊಟ್ರಲ್ಲ 25 ಅಡಿ ಇಂಟು 46 ಅಡಿ. ಅದ್ರಲ್ಲಿ ಚೆಕ್ ಬಂದ್ ಅದ್ರಲ್ಲಿ ಏನು ಪ್ಯಾಸೇಜ್ ಎಷ್ಟಿದೆ? ಪ್ಯಾಸೇಜ್ ಎಷ್ಟಿದೆ?
ಪ್ಯಾಸೇಜ್ 5 ಫೀಟ್ ಇತ್ತು. ಆಲ್ರೆಡಿ ಮನೆಗಳು ಕಟ್ಟಿ ಅವ್ರ ತಂದೆ ಕಾಲದಲ್ಲಿ ಕಟ್ಬಿಟ್ಟಿದ್ರು.
ರಿಲೀಸ್ ಡೀಡ್ ಅಲ್ಲಿ ಪ್ಯಾಸೇಜ್ ಎಷ್ಟಿತ್ತು ಸರ್?
5 ಫೀಟ್ ಇತ್ತು.
5 ಫೀಟ್ ಹೋಗಿ ಕಡಿಮೆ ಆಯ್ತು.
ಕಡಿಮೆ ಆಯ್ತು.
ಇವ್ರಿಗೆ ಮಾರಾಟ ಮಾಡುವಾಗ ಎಷ್ಟಿತ್ತು?
5 feet ನಲ್ಲಿ
3 ಅಡಿ ಆಯ್ತು.
2.5 into 3 ಬರ್ತದೆ ಸೇಲ್ ಡೀಡ್ ಅವ್ರ ಸೇಲ್ ಎಕ್ಸಿಬಿಟ್. ಅದಕ್ಕೆ ನಮ್ದೇನು ತೊಂದರೆ ಇಲ್ಲ. ಅವರು ನೋಡ್ಕೊಂಡು ಎಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ಎಲ್ಲಾ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ಅಷ್ಟೇ ಇದೆ. ಅವರು ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ಅವರ ಬೇರೆ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ ಇಲ್ಲ, ಇದರಲ್ಲಿ ಇದೆ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ ಪಿ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ all that piece and parcel of vacant site bearing khata number 59/1 situated Kadrepana civil area in the post Bangalore, east west 25 feet or 7.01 meters, north 25 feet 7.62 meters. The total measurements bearing 575 square feet or 53.47. East Kanta property ಅವ್ರು ಬೇರೆ ತೋರಿಸಿದ್ದಾರೆ, ಅವರು ಡ್ರೈನೇಜ್ ಅಂತ ತೋರಿಸ್ತಾರೆ, ಅದು ಬೇರೆಯವ್ರ ಪ್ರಾಪರ್ಟಿ. ಅವ್ರ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ರು ಸೋತಿದ್ದಾರೆ ಅವರು, ಅದು ಇಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅವರು. ಕಾಂತ ವೆಸ್ಟ್ ವೆಳ್ಳಿಯಂ ಮಾಲ್ ಪ್ರಾಪರ್ಟಿ, ನಾರ್ತ್ ಜನಾರ್ದನ ಹೌಸ್, ಸೌತ್ ಕಾಮನ್ ಪ್ಯಾಸೇಜ್ ಮೆಜರಿಂಗ್ ಈಸ್ಟ್ ಸೈಡ್ 2 feet, ವೆಸ್ಟ್ 3.5 feet, ಲೆಂತ್ 23 feet. ನಮ್ದು ಇದೇನು ತೊಂದರೆ ಇಲ್ಲ, ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳಿದ್ ಇಷ್ಟಕ್ಕೆ ನಾವೇನು ಮಾಡಲ್ಲ ಅಂತ. ಅವ್ರು ಲಾಂಗ್ ಬ್ಯಾಕ್ ಕಟ್ಟಿದ್ದಾರೆ, ಮನೆಗಳಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. ಅವ್ರು ಮಾರೋ ಟೈಮ್ ನಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಟ್ರೈ ಪಾರ್ಟಿ ಮಾಡಿ ಇಷ್ಟೇನ ಅಂತ ತಗೊಂತೀನಿ ಏನೋ ಮಾಡಲ್ಲ ಅಂತ ಕೂಡ ಮಾಡಿದ್ದಾರೆ. ಇದು ಬಿಟ್ಟು ಅವ್ರೇನ್ ಹೇಳೋದು, ಆ ಡ್ರೈನೇಜ್ ನಮಗ್ ಸೇರ್ತದೆ, ಡ್ರೈನೇಜ್ ನಲ್ಲಿ ಹೋಗುವುದಕ್ಕೂ ನಮಗೂ ಅದು ಸಂಬಂಧ ಇಲ್ಲ. ಡ್ರೈನೇಜ್ ಅಂತ ಹೇಳಿದ ಇವರು ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕಿದ್ರು, ಅವ್ರು ನಮ್ದು ಅಂತ ಹೇಳಿದ್ರು, ಅವ್ರ ಕಡೆ ಆಗಿದೆ. ಡ್ರೈನೇಜ್ ಇಲ್ಲ, ಇದು ನಮ್ದು ಅಂತ ಹೇಳಿ, ಅದು ಇವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ. ಇವರೇ ಲಾಯರ್ ಆಗಿದ್ರು. ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು, ಅವ್ರೇನು ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ಲ ಆ ಡ್ರೈನೇಜ್ಗೆ. ಆ ಡ್ರೈನೇಜು ನಮ್ದು ಅಲ್ಲ, ಅವ್ರದ್ದು ಅಲ್ಲ, ಯಾರ್ದು ಅಂತ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ.
You are adding to the confusion.
ನಂದು ಅವ್ರಿಗೆ ನಾವು ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದೀವಿ.
ಪ್ರಭಾಕರ್ ಅವರೇ, ಈ ಸೂಟ್ ಹಾಕಿರೋದು ಎಷ್ಟನೇ ಇಸ್ವಿನಲ್ಲಿ?
ಸೂಟ್ ಹಾಕಿರೋದು ಅವ್ರು ಹಾಕಿರೋದು
2005.
ಕಟ್ಟಿರೋದು 81, 82 ನಲ್ಲಿ ಕಟ್ಟಿರೋದು.
20 ವರ್ಷದಿಂದ ಕೇಸ್ ನಡ್ಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀವಿ. ನಿಮ್ಗೆ ಒಂದೊಂದು ಇಂಚು ಕೇಸ್ ಗೊತ್ತು. ನನಗೆ ಇವಾಗ ಬಂದಿದ್ದೀನಿ ನಾನು, ಅದು ಫಸ್ಟ್ ಟೈಮ್ ಇವತ್ತು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬರ್ತಾ ಇದೆ. ನೀವು ಖಾತೆ ಸೈಡು ಈಸ್ಟ್ ವೆಸ್ಟ್ ಮೋರಿ ಕನ್ಸರ್ವೆನ್ಸಿ ಪಕ್ಕದವನು ಕೇಸ್ ಹಾಕಿದ್ದ ಸೋತದ ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ. ಯಾವ್ದ್ರಿ ಅದು? ಇಸ್ ದಿಸ್ ವೇ ಟು ಆರ್ಗ್ಯೂ ಅನ್ RFA? ಏನ್ರಿ
ಈಗ ನಾನು ಹೇಳೋದು, ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಿದೆ
ದಯವಿಟ್ಟು ಸಾರಿ ಸರ್, ದಿಸ್ ಇಸ್ ನಾಟ್ ದಿ ವೇ ಟು ಆರ್ಗ್ಯೂ ಅನ್ RFA. 1973 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತೆಗೆದು ನೋಡಿ, RFA ಹೆಂಗ್ ಡೀಲ್ ಮಾಡಬೇಕು, ಹೆಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ದೇ ಮೆನ್ಷನ್. ಪ್ಲೇಂಟಿಫ್ ಕೇಸ್ ಏನು, ಡಿಫೆಂಡ್ ಕೇಸ್ ಏನು, ವಾಟ್ ಆರ್ ದಿ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ಡ್, ಹಂಗ ಹೋಗ್ಬೇಕ್ರಿ ಕೇಸ್ನ. ಮಧ್ಯದಲ್ಲಿ ನಾನು ಅಲ್ಲೋದೆ ಇಲ್ಲೋದೆ ಮೋರಿ ಕನ್ಸರ್ವೆನ್ಸಿ.
ಮೈ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಮೈ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 43. ಪ್ಯಾರಾ 2 ನಿಂದ ಬರ್ತೇನೆ. The property bearing number 59/1 measuring.
Please come to page 28. Para 4 ban.
Para 4.
Para 4. Para 4 odi.
Regarding para 4.
6 and 7.
The 6 and 7. The plaintiff clearly admits that when the property of Bhagyavati was sold to the vendor of the plaintiff, the common base was reduced by 1.5 feet on the western side and 3 feet on the eastern side. Hence, it is clear that the vendor of the plaintiff and the plaintiff herein had purchased said property with full knowledge that the existing passage was measuring 2 feet on the eastern side and 3.5 feet on the western side.
ಈಗ ಡಿಕ್ರಿ ಓದಿ ಏನ್ ಹೇಳುತ್ತೆ ಕೋರ್ಟ್ನವರು? ವಾಟ್ ಡಸ್ ಅ ಕೋರ್ಟ್ ಡಿಕ್ರಿ? ನೀವು ಒಪ್ಕೋತೀರಾ? passage measuring east to west 23 feet and north to south towards eastern side measuring 2 feet and towards western side 3.5 feet, running east west in between the property plaintiff defense counsel declared as common passage. ನೀವು ಒಪ್ಕೋತೀರಾ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೌದು ಪ್ಲೈಂಟಿಫ್ ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದಾಗ 3 ಅಡಿ ಒಂದ್ ಕಡೆ ಮತ್ತೆ 2 ಅಡಿ ಇನ್ನೊಂದ್ ಕಡೆ ಇದ್ದಿದ್ದು ಅಂತ ನೀವು ಒಪ್ಕೋತೀರಿ. ಸೊ ಡಿಕ್ರಿ ಆಗಿರೋದು ಅಷ್ಟಕ್ಕೆ
ಆಗಿರೋದು.
ಸೊ ದೇರ್ ಫಾರ್ ವೇರ್ ಇಸ್ ಎ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಯು ಫೈಲಿಂಗ್ ಅನ್ ಅಪೀಲ್.
ಅವರು ಏನು ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಇದಿದೆ ಇನ್ನೊಂದು ಪ್ರೇಯರ್ ಕೇಳಿದ್ದಾರೆ, ಅದಕ್ಕೂ ನನ್ನ ಸಂಬಂಧ ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಹಾಕಿದ್ದೀನಿ.
ಓದಿ ನೆಕ್ಸ್ಟ್ ಓದಿ. Defendant number 1 is hereby directed to remove the sajja formed by way of kadapa black tiles and cement sheets on the doors and window situated in the northern side wall of the defendant number 1, causing obstruction in the enjoyment of the passage situated towards the southern side of the property within 1 month. D1 is directed to remove the compound wall measuring 2 feet situated towards the eastern side of the passage, running east to west declared as common passage within 1 month. Directed manner to get the change pattern of the opening of the doors and windows so that they should get opened inside and not outside so as to form obstructions of so and so and so. In case the fails to remove, ಏನ್ ಮಾಡಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನೀವ್ ಏನ್ ಒಪ್ಕೊಂಡಿದ್ರ ಅದನ್ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಮಾಡಿದಾರೆ.
ಅಲ್ಲ ಇದು ಫರ್ದರ್ ಡಿಪೆಂಡೆಂಟ್ ಇಸ್ ಹಿಯರ್ ಬೈ ಡೈರೆಕ್ಟೆಡ್ ಬೈ ವೇ ಆಫ್ ಮ್ಯಾಂಡೇಟರಿ ಟು ರಿಮೂವ್ ದ ಕಾಂಪೌಂಡ್ ವಾಲ್ measuring 2 feet situated toward the eastern side of the. ನನಗೂ ಅದಕ್ಕೆ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಸಂಬಂಧ ಇಲ್ಲ ಅಂದ್ರೆ
ನಾನು ಹಾಕಿದ್ದೀರಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಎವಿಡೆನ್ಸ್ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಇದು ಫೈಂಡಿಂಗ್ ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದಿಲ್ಲ ಅಂತ. ಇದಕ್ಕೆ ನಾನು ಬಂದಿದ್ದೆ ಅಷ್ಟೇ.
ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಮೇಲೆ ಯಾವ್ದೋ ಸೂಟ್ ಹಾಕಿ ಸೋತಿದ್ದಲ್ಲ ಅದ್ಯಾವ್ದ್ರಿ ಅದು? ಅಲ್ಲಪ್ಪ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಯಾವ್ದೋ ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ರಲ್ಲ,
43 ಅಡಿ ಇವ್ರು ಎಂಡ್ ಆಗುತ್ತೆ ಸಬ್ಸ್ಟೋರಿ ಪ್ರಾಪರ್ಟಿ. ಅದಾದ್ಮೇಲೆ ಅದು ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ನಾನು ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಇವ್ರು ಪೊಸಿಷನ್ ಇಂದ ಒಂದೇ ಕಾಂಪೌಂಡ್ ಆಗ್ತಾರೆ ಟೋಟಲಿ ಸೊ ದಟ್ ಮೈ ಸೈಡ್ ಎಂಟೈರ್ಲಿ ಬ್ಲಾಕ್. therefore I filed a suit. That's what will have the court come to the conclusion given common passage whatever the 5 feet start before my property starts. So therefore will have my entry ಬಂದ ತಕ್ಷಣ ನೆಕ್ಸ್ಟ್ ಅವ್ರು ಬರುತ್ತೆ, ನಿಮ್ಗೆ ಅಲ್ಲಿಂದ ಬರ್ಬೋದಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ಮಾಡ್ತಾರೆ. So therefore will ಇದು ಬಿಟ್ಟರೆ ನಾನು ಬೇರೆ ಕಮಿಷನ್ ಒಂದು ಸರ್ ರಿಪೋರ್ಟ್ ಆಗಿತ್ತು ಅಲ್ಲೇ ಕೇಸ್ ಅಲ್ಲಿ, ಅದರಲ್ಲೂ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಇವನ್ ಐ ಸೈಡ್ ಓನ್ಲಿ ಆ 6 feet ಡ್ರೈನೇಜ್ ಮೇಲೆ ಜಾಗ ಇದೆ ಸರ್, ಅದು ಬಿಟ್ಟರೆ ನನಗೆ ಏನು ಕೊಡಲಿಕ್ಕೆ ಜಾಗ ಇಲ್ಲ.
ಡ್ರೈನೇಜ್ ಮೇಲೆ ಅವ್ರದ್ದು ಅಂತ ಆಗಿದ್ಯಲ್ಲ ಆ ಕೇಸ್ ಹಾಕಿ ಅಲ್ರಿ, ಡ್ರೈನೇಜ್ ಮೇಲೆ ಇನ್ನೊವ್ರ ಮೇಲೆ ಯಾರ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದಿರಲ್ಲ. ಎಲ್ಲಿದೆ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್? ಎಲ್ಲಪ್ಪ ಇದೆ? ವೇರ್ ದ ರಿಪೋರ್ಟ್ ಆಫ್ ದ ಕಮಿಷನರ್? ಏನ್ ಕಾಣದೇ ಇಲ್ಲ, ಹಂಗೆ ಅಂತ ರಿಪೋರ್ಟ್ ಹಾಕಿ ಏನ್ ಕಾಣುತ್ತಿದ್ದ? ನೋಡ್ರಿ ತೆಗೀರಿ, ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ತೆಗೀರಿ. ನೋಡ್ರಿ ಆಫ್ ಮಾಡಿ ಮಾಡ್ಬಿಡಿ ಆಯ್ತಲ್ಲ. ಮೇಲೆ ಅದೇ ಅಲ್ಲಿ 15C ಅಲ್ವಾ?
15C 15B ಮಾದರ ಸ್ಟಿಚ್ ಮಾಡಿ ಅದು ಆಲ್ರೆಡಿ ಕೆಳಗಡೆ ನಾವು ದಯವಿಟ್ಟು ನೋಡೋಣ.
15C is a rough sketch.
ಅಲ್ಲಿ ಕಮಿಷನರ್ ಬಂದಾಗ ಅದು ಮಾಡಿ